So because it's such a, you are in a small, inclusive area where 500 students in one campus, you will learn sports if you want to learn sports. You can go out. You're also in Calcutta in the middle of the city.
Something particularly unique about NUJS mooting is that like the focus on materialistic results in sense that when you go to a moot, you win something or you reach a particular round. That's important, right? I mean, that's there everywhere. And the fact that you'll be able to put it on your CV for recruitment purposes. I think that focus here shifts to the process bit of it. As in, what's the process which you have undertaken in the moot?
And the beautiful part is that we all start mooting with strangers and we end up as a family at the end of it. And that's what brings us back to this process, even if it's fatiguing, even if it takes up a lot of our time, and even if it requires us to put in long hours of effort or give up on sleep.
So from what I know, there are very few law schools that debate regularly. And of these law schools, we've had to fight very hard to establish ourselves because our society was the newest.
Yeah.
But yeah, now I think we have the largest number of active debaters in any law school.
What is NUJS?
I don't know.
एक रहस्यमयी अनोखी माया.
Here's to the classes we never have and the courses we almost flunked. Here's to the benches at night and the walks we took. And here's to the parties we've had and the parties we'll have. Here's to all the star mooters and debaters and to the dance competitions and theatre. Here's to a non-toxic environment and an ever-youthful campus. Here's to NUJS. Just a building in Kolkata, but a home to me.
It's an emotion.
मुझे NUJS इसलिए पसंद है क्योंकि जब मैं फर्स्ट ईयर में आया था तो मुझे लगता था कि यार नहीं, ये मेरे लिए जगह नहीं है. आज फोर्थ ईयर में मैं पीछे देखता हूँ, पन्ने पलटता हूँ, तो यहाँ पे देखता हूँ कि कॉलेज कितना ज़्यादा इंक्लूसिव हो चुका है.
शुरुआत मजबूरी में की थी, अब मज़ा आ रहा है.
It was a culture shock for others, it was a fit in for me.
Pretty exciting.
Pressure will tell you.
Unpredictable and unbelievable.
Fun.
It's an emotion.
Home.
For me, NUJS has been about growing up. A lot of chilling, there's a lot of work, there's a lot of academics.
Chaotic.
Chill, parties,
My life.
emotions. NUJS is definitely special.
It's taken from high to lows.
भौकाल. हाँ. सांस.
हर ख्वाब नए अरमानों को जगह दी है. हर ख्वाब नए अरमानों को जगह दी है. इसके दरवाजे ने हम सबको पनाह दी है. NUJS वो दहलीज है यारों जिसने इमारत होकर भी जीने की वजह दी है.
will learn sports in this college because you will have someone or the other who's coming from some other town in this country and who knows the sport. So similarly, I learned volleyball after coming to college because I had a senior who knew volleyball. So because you are in a small, inclusive area where 500 students in one campus, you will learn sports if you want to learn sports. You can go out. You're also in Calcutta in the middle of the city.
Something particularly unique about NUJS mooting is that the focus on materialistic results in sense that when you go to a moot, you win something or you reach a particular round. That's important, right? I mean, that's there everywhere. And the fact that you'll be able to put it on your CV for recruitment purposes. I think that focus here shifts to the process bit of it. As in, what's the process which you have undertaken in the moot?
And the beautiful part is that we all start mooting with strangers and we end up as a family at the end of it. And that's what brings us back to this process, even if it's fatiguing, even if it takes up a lot of our time, and even if it requires us to put in long hours of effort or give up on sleep.
So from what I know, there are very few law schools that debate regularly, and of these law schools, we've had to fight very hard to establish ourselves because our society was the newest.
Yeah.
But yeah, now I think we have the largest number of active debaters in any law school.
What is NUJS?
I don't know.
एक रहस्यमयी अनोखी माया.
Here's to the classes we never have and the courses we almost flunked. Here's to the benches at night and the walks we took. And here's to the parties we've had and the parties we'll have. Here's to all the star mooters and debaters and to the dance competitions and theatre. Here's to a non-toxic environment and an ever-useful campus. Here's to NUJS. Just a building in Kolkata, but a home to me.
It's an emotion.
मुझे NUJS इसलिए पसंद है क्योंकि जब मैं फर्स्ट ईयर में आया था तो मुझे लगता था कि यार नहीं, ये मेरे लिए जगह नहीं है.
Call Samarth. Put him in the. This link is not working. Can you send? Show me the link. काम नहीं कर रहा. That's the reason I told you. You have to edit. मेट का किसी को आइडिया नहीं है वो बैचलर को मैं वो टैक्स और किसी को करता है आइडिया Is it sent? That is the reason. Did he receive the link or no? It's unable to open. So I'm unable to join. So is it asking like can in any way we can talk to him or something over phone? Because I think he's facing problem with the ask to join. He's waiting in the room. I think that's what is happening right now. I'm not sure.
That is the reason I have been kept on telling.
So but the problem with all the guests have been sent Google invites.
Yeah,
The
but
problem
we have to invite them. Yesterday I told no.
Yes,
No one
Manish-
is unable to join except NUJS people.
No, sir, people are joining. No,
Only 22.
people outside of NGs have also joined. A lot of people have joined.
Okay. Then tell immediately.
Yeah, speaker has. She has the guest speaker of our conclave has also joined. The people outside of NHS are also joining us, sir. I think the issue is from his end because a lot of people are joining with the same link.
Just ask her to send it immediately.
Yeah, Dinesha ma'am has already joined also. Anyway, if you can talk to him, I think he's waiting in the lobby. He's not able to figure out how to enter. That might be the problem.
You are speaking with Samath.
Yes, do you want to talk to him?
No, no. Did they send?
Mr. Chengapa sir is asking if you send the or not link आपने भेजा कि नहीं?
Hello, did you send?
Yes, sir.
I have forwarded it to him through mail and as also to Malovika ma'am.
Okay, okay.
Malovika ma'am has joined, sir.
Yeah. Sir has joined.
Sir, I'm switching on the mic.
Yeah.
Good morning, sir.
Sir, I will switch on mic. Let's start. You can start.
Sir has to. Reminder to NUJS people.
Good morning.
Yes. Good morning, sir.
Good morning to all. I am audible.
Yes, sir. You are audible, sir.
Okay.
Honorable Justice also has joined. Good morning, sir.
Good morning. Good morning.
Good morning.
Hmm? No, huh.
Shall we start, sir?
Yes, start.
Very good morning to the one and all present here. Respected Honorable the Vice Chancellor, sir, and the two chief guests of the program, Honorable Justice Soman Sen, delegates, the participants, and ladies and gentlemen. I am MP Changappa, the program coordinator. On behalf of West Bengal National University of Judicial Sciences, the Kolkata, let me extend a very hearty welcome to all for the 2 days International Conclave on contemporary issues of administrative law. We have received overwhelming the response from the participants. There are more than 300 participants have registered for this program. We are also going live on YouTube. My greetings to all the people who are watching through live to YouTube link. We shall begin our program with an invocation. Now let me call upon Miss Aditi Singh, fourth year BLLB students. Over to Aditi.
Thank you so much, sir. It is my absolute pleasure to once again welcome you all to the 2-day International Conclave on Contemporary Issues in Administrative Law. In the past 2 years, each one of us has seen a very tough phase. But the one thing that helped us to get through the darkest of times was hope. Hope to not give up, hope to see the light despite all the darkness. ये मत कहो खुदा से मेरे मुश्किलें बड़ी हैं, ये मत कहो खुदा से मेरे मुश्किलें बड़ी हैं, ये मुश्किलों से कह दो मेरा खुदा बड़ा है, ये मत कहो खुदा से मेरी मुश्किलें बड़ी हैं, ये मुश्किलों से कह दो मेरा खुदा बड़ा है। आती है आंधियाँ तो करे उनका खैर मकदम, आती है आंधियाँ तो करे उनका खैर मकदम, तूफान से ही तो लड़ने दुनिया ने तुम्हें गढ़ा है, ये मत कहो खुदा से मेरी मुश्किलें बड़ी है, ये मुश्किलों से कह दो मेरा खुदा बड़ा है, मेरा खुदा बड़ा है। अग्नि में तपते सोना है और भी निखरता, अग्नि में तप के सोना है और भी निखरता, दुर्गम को पार करके हिमालय कोई चढ़ा है, लाएगी रंग मेहनत आंखें तुम्हारी एक दिन, लाएगी रंग मेहनत आंखें तुम्हारी एक दिन, होगा विशाल तरवर ये बीज जो पड़ा है, ये मत कहो खुदा से मेरी मुश्किलें बड़ी है, ये मुश्किलों से कह दो मेरा खुदा बड़ा है, मेरा खुदा बड़ा है, मेरा खुदा बड़ा है। थैंक यू।
Thank you so much, Aditi. This is Ayushi Kushwaha. A very good morning to everyone. I'm the program coordinator for the International Conclave on Contemporary Issues in Administrative Law. It is my pleasure to moderate the inaugural session of the conclave and invite our esteemed guests to address the session and enrich the audience with their insights on the theme. I would first like to introduce and invite the patron-in-chief of the conclave and the Vice-Chancellor of West Bengal National University of Juridical Sciences, Professor Dr. N.K. Chakrabarty. Dr. Chakrabarty joined West Bengal Education Service and was posted as a lecturer in law in Government of West Bengal, Hooghly Mohsin College in 1985. Later, he joined in the University of Calcutta and retired as professor in the Department of Law. He worked as director, School of Law, KIT University in 2009, and later joined as the Vice Chancellor in the West Bengal National University of Juridical Sciences in 2019. As a prolific writer, Dr. Chakrabarty has so far authored 7 books. He has also published more than 100 articles and research papers in various national and international journals. Dr. Chakrabarty has established himself as a researcher in the field of criminology and criminal justice in India. I invite you, sir, to deliver the welcome address.
Thank you. Very good morning to all participants, all the distinguished guests, delegates, and my dear students. I am very much glad that even in the pandemic, our various centers, including this administrative law center, they have organized many programs, and this is one of the very important development in their activities. I congratulate the team headed by Dr. Chengappa. In fact, in the present global scenario, the administrative law and the quasi-judicial bodies in the governance of the country been very much relevant to be discussed and to evolve the various principles of governing. With that end in view, our international conference focus on contemporary issues in administrative law. At the outset, I extend my deepest gratitude and welcome to our honorable chief guest today in the inaugural session, Honorable Justice Soumen Sen, Judge Calcutta High Court, as our chief guest. I also extend my heartiest welcome to all other distinguished speakers, delegates, and participants, and also students who are participating either in the virtual this forum or through YouTube. Administrative law, we know, is that branch of public law which concern with the powers and functions of the various organs of the government and internal departments. It is said that administrative law is the lifeblood of the constitutional government. It includes matters relating to civil services, public departments, public corporation, independent entities, statutory bodies, local authorities, exercising its quasi-judicial function and governance. It also comes within governing judicial review of administrative actions. Administrative law mainly deals with powers and duties of administrative authorities and the various remedies available to affected persons or citizens. It is also, therefore, the law relating to governing relations between the citizen and the government. Administrative law in India, in fact, can be traced back to our ancient time in the Maurya and Gupta dynasties. The old kings preserved power and sovereignty to maintaining strict control over the actions of the various bodies of the governance as a centralized power followed the principle of dharma to provide for welfare of the people as a matter of king's duty. Administrative law, as we know today, however, is largely a refined version of the British legal system imported by East India Company. As the power of East India Company being
afternoon session,
governed, and in India, some parts of the then India, rules and regulations through that British Raj placed the various parts of the country to govern ever expanding administration and executive functions at that time. The modern system of administrative law started with the inauguration of the Constitution of India and establishment of Supreme Court at Calcutta and also the high courts in different states. The philosophy of welfare state, as envisaged in the Constitution, required to equitably distribute the ownership and control of material resources of the society for the social good, ushered in the new dimensions of growth in our social, economic, and political fields. The perceived failure of the laissez-faire state has led a shifting of gears from laissez-faire to welfare state. Administrative law in India, therefore, has governed considerably during the decades on welfare doctrine. The attainment of social economic justice, as promised in the preamble of our Constitution, being a conscious goal of state policy, and there is a vast and inevitable increase in the frequency with which ordinary citizens come into relationship of direct encounter with the state power and the authorities. Administrative law is an important weapon for bringing about harmony between power and justice. The primary objective of administrative law is thus to limit the powers of the government to protect the citizen against their abuse. In liberal democracies, particularly in more conservative thought, the state and its functioning is prescribed as an encroachment on individual rights of the people and a necessary evil insofar as it is required to ensure public welfare. The debate is also still now whether the core value of our constitution is individual rights or social justice. But regarding administrative law, the individual rights and liberties writ large in the various legislative framework as well as the judicial pronouncement. While a welfare state is prescribed more charitably by those who consider the state itself is a more positive light, they too realize that the vast powers vested with the state officials can be abused easily. As Lord Denning suggested, an improper use of state authority may lead to totalitarian state, which is supremely undesirable and the liberal democratic system. Administrative law therefore delimits and delineates state power in an attempt to prevent abuse and provides judicial remedies to address any potential abuses that infringe the rights of the citizens of the state. It builds up rule of law and principles of natural justice to provide an objective framework for administrative functioning. Administrative law is the byproduct of the growing socio-economic functions of the state in the global scenario in the today's world. Administrative law has become very necessary in the developed society, but the relationship of the administrative authorities and the people have become very complex. Globalization has opened up new frontiers for governance in general, as the state now necessarily has to interact with not just foreign state but also entities such as multinational corporations and foreign investors while ensuring public welfare. The rapid and drastic changes to global socio-economic systems require a dynamic and up-to-date system of legislation. As Roland says, before the days of the automobile, there was no need for policemen to direct traffic. As the statutes are loath to change very quickly and courts take time to decide cases in India, delegated legislation and quasi-judicial authorities have picked up the slack. India faces a dire need to strengthen and streamline its administrative law system to address the concerns of poverty, unemployment, underemployment, and various other social issues facing by the country today. This today conclave aims to lay the foundation for further research and policy decision on Indian administrative law and promote work in this field, especially amongst early career researchers in the universities. It will explore foundational questions in the field with a focus on distinctive features of Indian administrative law. The emphasis shall be upon administrative rules and policies concerning the executive, judiciary, and the people of the country. The conclave shall be a way to meet the increasing and timely interaction in the Indian administrative law and the practitioners among the scholars in Indian academia as well as the comparativist scholars of public law globally. In the course of this conclave, we shall look at various areas of focus such as proportionality, jurisprudence, checks and balances on the various forms of governments, and also the good governance, especially in the times of crisis which we are passing in the pandemic. West Bengal National University of Juridical Science, a premier university, seeks to use this conference as an opportunity to invest and inquire further in contemporary and need-based research and scholarship in the field of administrative law and its application in the operational level. So the insightness that to be developed through this discussion and debates can be very much useful to the interdisciplinary approach to constitutional and administrative law in the governance of the country. I express that the conclave will be very much successful, and I wish all participants and all the organizers for their efforts, and I hope that it will be a successful one among many other successful events we are organizing. Thank you all again and welcome to the today International Conclave on Contemporary Issues in Administrative Law. Thank you all.
Thank you so much, sir. For us to have Honorable Justice Somen Sen as a chief guest today is our privilege. Honorable Justice Somen Sen did his LLB from the University of Calcutta in 1990 and stood first in the order of merit. He had judged first in order of merit for individual performance at the 12th All India Moot Court competition in 1989, held in Pondicherry in relation to the selection for the international division of Philip C. Jessup International Law Moot Court competition. He practiced as an advocate in the Honorable High Court at Calcutta and before other courts and tribunals for last 20 years as senior central government advocate. He has also appeared in several civil, constitutional, banking and arbitration matters on behalf of RBI, SEBI and other statutory authorities. He was elevated as judge of the Calcutta High Court in 2011. Thank you so much, sir. We welcome you here to the conclave.
So you're on mute.
Sir, you have been put on mute, sir.
Thank you. Good morning to all the distinguished guests, scholars, participants, and viewers who are attending this program on this virtual platform. It's a great honor and privilege for me to be invited by the West Bengal National University for Juridical Sciences in this two-day international conclave on contemporary issues in administrative law. The moment I speak of administrative law, Professor Dicey and other authors' monumental works on this subject come to every mind. Professor Dicey has said administrative law relates to that portion of a nation's legal system which determines the legal status and liabilities of all state officials and defines the rights and liabilities of private individuals in their dealings with officials and specifies the procedure by which those rights and liabilities are enforced. In the modern context, Professor Bokshi has summarized it beautifully. He said, administrative law is a study of the pathology of power in a developing society and remains as an only instrument of middle-class Indians to combat governmental power through courts. The concept of administrative law is not something new to this part of the world. The study of our ancient jurisprudence would show that the seeds of modern public law were very much present in the days of yore. Kautilya, the prime minister of the powerful Magadha Empire, observed on the role of the king that in the happiness of his subject lies the king's happiness. In their welfare, his welfare. Whatever pleases himself, the king shall not be considered as good. Whatever pleases his subjects, be considered as good. Supremacy of law was the essential feature on which the edifice of ancient administration was built up. It was much before the genesis of the Western concept of rule of law Separation of powers was in existence here long before the propounder of this theory was born. The legislative power in ancient Indian polity was with the Parishads, who was to formulate the law, and the king was not to legislate. Equality before the law was recognized, and arbitrary, discriminatory, and misuse of powers of the officers were generally not appreciated. Of course, it depends with the kind of the kings governing the field. According to eminent historian Romila Thapa, the Maurya's and centralized bureaucracy was because of favorable social and economic conditions existing during that time. A uniform administrative system was developed as regards to taxes. The administration took into consideration of all local features before any assessment was made. Increased centralization under the Mauryans, more particularly during the reign of Ashoka, meant an increased control of the state over the economy, and the cultivator came into direct contact with the administration, which to himself signified the state. The king gradually became an even more remote symbol than before, and the immediate world of the cultivator was concerned with officials, a condition which was to remain current for many centuries. Diodorus has quoted Megasthenes with regard to the administration of the Mauryan Empire and observed that law ordains that no one among them shall under any circumstances be a slave, but that enjoying freedom they shall respect the equal right to it which all possesses. We read about the presence of the Mauryan officials called Pradeshikas, who were in charge of the overall administration of a district of a particular province, each district being under one officer. The law as it stood then provided protection to the minors, women, destitute, and the sick. It also recognized the right to association and liberty of thought, belief, and expression. One of the Upanishads said, "Law is the king of kings. Nothing is superior to law. The law, aided by the power of the king, enables the weak to prevail over the strong." This above verse not only declares the supremacy of law, but also the principles of rule of law. The dharma was the ultimate authority, and the authority of the king was only penultimate. Rig Veda, the most ancient in Vedas, declared that no one is superior or inferior. All are brothers, and all should strive for the interest of all and should progress collectively. The subsequent Vedas also speak of equality and that all should live together in harmony, supporting one another like the spokes of wheels of a chariot. India's independence marked a new era in the Indian legal jurisprudence, and this eon was heralded by many lofty ideas encapsulated in the preamble of the Constitution. India has entered the 75th year of her independence, liberalization of the economy, and the subsequent increased efforts for privatizations had given rise to expectations of responsibility and assignment of culpability. The law is now pandemic-ridden, economically anxious, and technologically curious. New contemporary issues have emerged in this realm of administrative law. With the advancement of civilization and the increasing complexity of the connection between administrative authorities and the general public, rigorous adherence to administrative law has become increasingly important to the society. In order to govern these complicated relationships, legislation is required which may ensure regularity while also preventing the abuse of administrative authority. Professor Wade, in this regard, has remarked, administrative law is concerned with the operation and control of the powers of administrative authorities with measures on functions rather than on structures. It can be stated to be a study of multifarious powers of the administrative authorities and their control. In modern times, state has undertaken multifarious functions which traditionally did not come within the area of its operation, apart from maintaining law and order, administration of justice, and protection of its people from aggression. The state has taken up various schemes of development, planning, and welfare, affecting almost every walk of human life. In this process, enormous powers have been conferred on the public bodies to achieve such objects. In the process of implementing multifarious objects, conflicts are bound to arise. Society grows amidst conflict and interactions among various stakeholders. It was in this context that over a period of time, administrative law has emerged as the most significant branch of public law to understand the entire control mechanism of the myriad governmental powers. Fritz Steiner, a German administrative law scholar, once wrote, "The police should not shoot at sparrows with cannons." Multiple nations have embraced this notion of proportionality as a criteria of evaluation in their jurisprudence. Due to the differences in history, culture, and institutions amongst countries, this universal notion of proportionality has various local flavors. Complications between efficiency and accountability are an interesting field of study for administrative lawyers. State welfare delivery systems, as well as law enforcement mechanisms, have become revolutionized by the use of technological advanced systems, an emerging challenge in the field of administrative law. The operation and control of administrative authorities is the main purpose of administrative law, and we require to make inquiries as to what sort of powers does the administration exercise? What procedures do administrative authorities follow in the exercise of the power of the administration? What are the limits on the powers of administration? What are the ways in which the administration is kept within those limits? What remedies are available to the individual against illegal action of the administration? These 5 inquiries, as pointed out by Professor Griffith and Street, are the most essential and of primary concern. It operates as checks and balances on the enormous and multifarious powers of administrative authorities. It intends to prevent the growth of autocratic rule of administrative authorities and provides for safeguards against what Lord Heward has described as new despotism. In England, constitutional law has no special impact on administrative law as the constitution is unwritten. To English writers, there are virtually no difference between the constitutional law and administrative law. According to Professor Wade, the whole of administrative law indeed may be treated as a branch of constitutional law since it flows directly from the constitutional principle of rule of law. Professor Jennings, however, described that the administrative law deals with the organization, functions, powers, and duties of administrative authorities, while constitutional law deals with the general principles relating to the organization and powers of various organs of the state. India, on the other hand, had a written constitution. The control mechanism over the powers of the administrative authorities is sometimes delineated at length. For example, there are several constitutional provisions. There is Article 32, 226, 227, 136, 299, and Article 300, which comprehensively devise the modes of judicial control over different kinds of administrative actions. Over the years, the judiciary has used principles of administrative law in constitutional interpretation and used constitutional law principles to decide matters of administrative excesses. This is especially true in the context of the right to privacy, data protection, the usage of internet freedom, where the Supreme Court has delimited the right of the government using principles of reasonableness and proportionality. Statutory instrument or subordinate legislations have been expressly brought within the fold of Article 13 of the Constitution by defining law. Orders, bylaws, rules, regulations, and notifications have the force of law. Thus, a subordinate legislation can be challenged not only on the ground of it being ultra-vires the Constitution, but the statute, but also on the ground that it contravenes any of the fundamental rights guaranteed under Part 3 of the Constitution. Even where the administrative action is non-legislative and does not rest on any statute and is purely administrative, it will be void if it contravenes any one of these fundamental rights which constitute limitations upon which any state action is based. An administrative act, whether statutory or non-statutory, shall be void if it contravenes any of the mandatory and justiciable provisions of the Constitution outside the realm of fundamental rights included in Part 3, as for example, Articles 265, 301, 311, and 314. In any form of government, the citizens should expect and look forward to good governance. The Right to Information Act, a tool for public participation in the decision making, a new shift in administrative law in the realm of good governance, has become an important tool in the hands of public spirited citizens to demand transparency and accountability from public functionaries. This act not only has brought forth a paradigm change in administrative law, but also has facilitated a radical change in judicial decision making. Good governance also requires that people would expect no criminalization of politics, and it may call for electoral reforms. In Public Interest Foundation Others versus Union of India and Other, reported in 2019, Volume 3, SCC 224, the Honorable Supreme Court observed that every citizen can demand, and it is a duty of the nation, that we shall be governed no better than we deserve. Thus, the complete information about criminal antecedents of the candidates forms the bedrock of wise decision-making and informed choice by the citizenry. It is essential to have a true and strong foundational democracy. Society legitimately expects to be governed by proper constitutional governance, that is good governance, which has been reiterated in Bajaj Singh versus Sunil Arora and Others, reported in 2021, Volume 10, SCC 241. As I have mentioned earlier, Dharma has played an important role in dispensation of justice in ancient India. The law as envisaged under Dharma is natural law. It stands for righteousness. It is a natural special attribute of man in his pursuit for his and social welfare. The Honorable Supreme Court has interpreted the Constitution and individuals' right and liberty in the light of Dharma or natural law. For example, in State of Bombay versus RMDC, the writ petitioner claimed that they had the fundamental right to carry on the business and conduct prize competition. Therefore, it was their contention that the law which imposed a repetitive tax on their activity clearly infringed their fundamental right under Article 19(1)(g) of the Constitution. This contention was rejected by the Honorable Supreme Court after referring extensively to Rig Veda and Smritis, which unequivocally declared that gambling and betting were the most pernicious and degrading pastime, and observed that the right conferred by Article 19(1)(g) did not include the right to carry on such activities which are a menace to the society, and accordingly the constitutional validity was upheld. No one can forget the epic battle of Kurukshetra, which was a product of gambling. Similarly, in Sunil Batra, Justice Krishna had condemned the practice of keeping under trial along with convicts. Justice Iyer, in his inimitable style, had observed that for when a prisoner is traumatized, the Constitution suffers a shock. By sending the under trial to Tihar jail, where convicts are kept in custody, perversity is caused, which violates the tests of reasonableness in Article 19 and fairness in Article 21. The said decision emphasized how natural law or dharma commands compassion, empathy, and human treatment even for convicts or under trial prisoners. In Nargis Misra, Justice Murtaza Fazal Ali, speaking on behalf of the bench, castigated the service rule which denied maternity leave to an air hostess as it insulted the dignity of Indian women, the most sacrosanct and cherished institution, apart from being grossly unethical, detestable, and abhorrent, and it smacked of a deep-rooted sense of utter selflessness at the cost of all human values. This judgment of the Honorable Supreme Court clearly showed how the concept of dharma or natural law prevails alongside interpretation of the Article 21 of the Constitution of India. Even when the Administrative Act is statutory, the validity of it can be challenged on the additional ground that the said statute under which the administrative order has been made is itself unconstitutional. The decision of an authority can be challenged when it is tainted with bias in violation of the principles of natural justice, mala fide, abuse of power, being unreasonable, arbitrary, illegal, improper, irrational, malicious, and so on and so forth. Administrative law comes to rescue at this juncture. Recent developments in administrative law have seen contemporary explorations in the doctrine of rule of law, legitimate expectation, and doctrine of proportionality, among other principles. The concept of rule of law is used in contradiction to rule of man and is held as rule according to law. Even in the false code of autocrats, some semblance of law exists according to which the powers of the government are exercised, but that does not mean that there is rule of law. The idea of rule of law in its complex sense denotes a framework for the exercise of public power based on the essential postulates of equality, freedom, and accountability. Rule of law, according to Dicey, entailed the virtual elimination of official discretion, which he equated with arbitrary power. Constitution of India incorporates the essence of rule of law, though the preamble wherein it speaks of justice, liberty, equality, fraternity, and dignity of the individual, the fundamental rights guaranteed by the Constitution, which imposes some positive obligation on the state in the form of directive principles, the basic structure doctrine, which restricts the abridgment of the fundamental rights, other restrictions on the government, that is, no taxation without law, freedom of trade, constitutional right to property, provisions of fair trial, and presumption of innocence, independence of judiciary, and lastly, the judicial review of executive and legislative measures. The recent explanations of the concept of rule of law in relation to every aspect of administrative operations are of great significance in the development of Indian administrative law. The Supreme Court, as well as the various high courts in the country, has interpreted the concept of rule of law vis-a-vis administrative powers in several recent judgments. They have emphasized the need for fair and reasonable procedure, adequate safeguards against any executive excesses or encroachment on personal liberty, free legal aid to the poor and needy, and speedy trial of criminal cases as necessary adjuncts to rule of law. Rule of law excludes arbitrariness. It postulates intelligence with passion and reason free from desire. Law in the context of rule of law does not mean that any law enacted by a legislative authority, howsoever arbitrary, despotic it may be, should be taken as sacrosanct. For rule of law militates against arbitrariness. These principles now form an important part of our constitutional and administrative law and can be applied to check executive arbitrariness. As observed by Justice Bhagavati Maneka Gandhi, I quote, "If the essentials of justice be ignored, an order to the prejudice of a person is made, the order is a nullity. This is a basic concept of the rule of law, and importance thereof transcends the sign of a decision in any particular case." What is necessary element of rule of law is that the law must not be arbitrary or irrational and must satisfy the test of reason, and the democratic form of policy seeks to ensure this element by making the framers of law accountable to the people. In a suo motu proceeding arising out of the COVID situation, which is in re the proper treatment of COVID-19 patients and dignified handling of dead bodies in the hospitals and others, in 2021, the Honorable Supreme Court instructed the state government of Gujarat to maintain the rule of law in pursuance of the direction of the government under the Gujarat Town Planning and Urban Development Act 1976 to instruct the urban local bodies not to take action against buildings in breach of building development regulations, and that if in or in connection with the exercise of its powers and discharge of its functions by any appropriate authority under this act, any dispute arises between the authority and the state government, the decision of the state government on such dispute shall be final. The Apex Court prima facie found no nexus of the notification with provisions of the act and deemed in the spirit of rule of law that condoning the gross irregularities in constructing buildings which do not have building permissions, or as the case may be fire permissions, has resulted in violation of the law and has led to the detriment of public health, as is evident from the incidents of fire which have taken place both in Rajkot and Bharuch. COVID-19 has caused serious impediment to the justice delivery system. In re-guidelines for court functioning through video conferencing during COVID-19 pandemic, the Honorable Supreme Court observed that access to justice is fundamental to preserve the rule of law in the democracy envisaged by the Constitution of India, and that indeed courts throughout the country, particularly at the level of Supreme Court and High Courts, have employed video conferencing for dispensation of justice and as guardians of the Constitution and as protectors of individual liberty governed by the rule of law. The expectation of citizens to be treated fairly and that government shall not resile from its promises have given rise to the doctrine of legitimate expectation. The doctrine has been evolved to ensure regularity, predictability, and certainty in government's dealings with the public as observed in Lalaram versus Jaipur Development Authority. It is not a legal right, it is an expectation of a benefit, relief, or remedy that may ordinarily flow from a promise or established practice. The term established practice refers to a regular, consistent, predictable, and certain conduct, process, or activity of the decision-making authority. The expectation should be legitimate, that is reasonable, logical, and valid. Any expectation which is based on sporadic or casual or random acts, or which is unreasonable, illogical, or invalid cannot be a legitimate expectation. Not being a right, it is not enforceable as such. It is a concept fashioned by the course of judicial review of administrative action. It is procedural in character based on the requirement of a higher degree of fairness in administrative action as a consequence of the promise made or practice established. In short, a person can be said to have a legitimate expectation of a particular treatment if a representation or promise is made by an authority either expressly or impliedly, or if the regular, consistent past practice of the authority gives room for such expectation in the normal course. However, the protection under the said concept is a highly context sensitive as it depends on number of factors which include how much discretionary freedom the executive authority of the public body possesses, the class of individuals affected by such public body decision, the degree of reliance, security concern, and some overriding reason of public policy or invalid appointments. There are two categories of expectations, one being procedural expectations, which is warranted by procedural protections, namely hearing, and substantive expectations, which is warranted by either procedural or substantive protection. In Kerala State Beverages case decided in 2019, the Honorable Supreme Court has lucidly explained the difference between procedural and substantive expectations. The court said, the procedural part of legitimate expectation relates to a representation that a hearing on other appropriate procedure will be afforded before the decision is made. The substantive part of the principle is that if a representation is made that a benefit of a substantive nature will be granted, or if the person is already in receipt of the benefit, that it will be continued and not to be substantially varied, then the same could be enforced. If the authority proposes to defeat a person's legitimate expectation, it must afford him an opportunity to make representations on the matter. Lord Justice Fraser in the Council of Civil Service, decided in 1985, identifies two sources of legitimate expectation. Firstly, an express promise given on behalf of the public authority and a regular practice which the claimant can reasonably expect to continue. The first source forms a class to the doctrine of promissory estoppels by a right of denial to be given an opportunity of hearing, irrespective of the fact that existing rule may permit a hearing, may not permit a hearing. The courts have observed that it is implied that when there are serious civil consequences, the person aggrieved should be given an opportunity of hearing, as every such aggrieved party has a reasonable and legitimate expectation that such claimant should not be punished unheard. The policies can also create a legitimate expectation that a change in policy will not apply to certain people, or that existing policy would be followed in a particular case, or will not be affecting any accrued or vested right, as observed in T. Vijayalakshmi in a town planning case in 2006. The published policy may amount to a representation and thereby giving rise to an expectation that the said policy should be adhered to. What is expected from the functioning of the public and administrative bodies is that they should have a consistent practice and their decision should not be arbitrary. The public body's consistent practice may create a legitimate expectation, as it may be presumed that such practice would continue to be followed in the future in the same manner. Fairness is probably the main justification for protecting legitimate expectation. There is always expectation that public bodies will adhere to the rules that bind it. Difficulties arise when there is a departure from policy or change in policy. Professor Wade and Forsyth said that generally, and I quote, all that can be legitimately expected is that the policy as it exists at the time will be applied to the case at hand. Lord Diplock, discussing a change in policy relating to the retirement age of civil services in NUJS has observed, and I quote, administrative policies may change with changing circumstances. When a change in administrative policy takes place and is communicated in a departmental circular to those affected, any reasonable expectations that may have been aroused in them by any previous circular are destroyed and are replaced by such other reasonable expectations based on the administrative policy announced in the new circular. Calcutta High Court, in the case of Sudip Kumar Shaha, decided in the 1993, has observed that the doctrine of legitimate expectation is nothing but a further extension of the doctrine of promissory estoppel. Unless from a consistent course of action it appears that a person reasonably expects the state to act in a particular way and had altered his position accordingly, the doctrine of legitimate expectation cannot be pleaded. The court should act with great care and caution in such cases. In the said case, the court held that the doctrine of legitimate expectation cannot found a cause of action unless, in a given case, it amounts to denial of a guaranteed right or is arbitrary, discriminatory, unfair, or biased. This principle has been reiterated recently by the Honorable Supreme Court in Jharkhand versus Brahmaputra Metallics, where the Supreme Court observed that the scope of the doctrine of the legitimate expectation is wider than promissory estoppel because it not only takes into consideration a promise made by a public body, but also the official practice. The bench observed that the doctrine of substantive legitimate expectation is one of the ways to secure the guarantee enshrined under Article 14 of the Constitution of India and prevents the state to act arbitrarily. The bench further observed that the doctrine of legitimate expectation cannot be claimed as right in itself, but can be used only when the denial of legitimate expectation leads to the violation of Article 14 of the Constitution. The global COVID-19 crisis has thrown up a challenge worldwide for the government to adopt exceptional measures to address imminent threats that may bend or break fundamental legal principles and constitutional guarantees in the process. It has caused serious economic imbalance, unemployment, and health hazards, particularly for nations that are having huge population. It is an obligation of the administration in such a crisis situation to safeguard core human rights and legal principles in mind concerning public health, as decided by the Supreme Court in various matters. I'm not going to refer to all those decisions because these decisions are well known. Going to the doctrine of proportionality, which is an offshoot of the concept of Wednesbury principle. Now, we all know that the Wednesbury principle was basically on the question of whether the decision is illegal, improper, suffers from procedural irregularity, to which Lord Green has added that when a statute gives discretion to an administrator to take a decision, the scope of judicial review would remain limited. He said that interference is not possible unless one or the other of the following conditions is satisfied, namely, the order was contrary to law or relevant factors were not considered, or the decision was one which no reasonable person could have taken. The proportionality standard in English law is a four-stage test that looks at whether the objective is necessary to limit a fundamental right, the impugned measure is rationally connected to it, and there is minimal impairment of the right to accomplish the objective and balancing the rights against the restrictions. The proportionality criteria in India has been used at four-stage test. Along with this, we have the protection under the reasonable limits clause under Article 19, sub-article 2 to 6, and the Wednesbury reasonableness, which is the judicial review of the administrative acts and approaches depending on the situation. In the wake of pandemic came a challenge. Now, how the doctrine of proportionality was applied in the case of pandemic, I can refer to a very recent decision of the Supreme Court. In the wake of pandemic came a challenge to a notification dated 17th April 2020 and 20th July 2020 issued by the Labour Department to the state of Gujarat under Section 5 of the Factories Act to exempt factories registered under the Act from various provisions relating to weekly hours, daily hours, intervals for rest, etc. for adult workers through a trade union which is having a state-wise presence in an Article 32 proceeding. This is in Gujarat Mazdoor Sabha versus the state of Gujarat. The question was whether the disputed notifications were within the scope of Section 5 of the Factories Act's ambit. The legitimacy of the notifications was contingent on whether COVID-19 epidemic and statewide lockdown constituted a public emergency as defined in Section 5. Citing implicit principle of proportionality, the court observed that under Section 5, a situation could qualify as a public emergency only if the following elements were satisfied, namely, there must exist a grave emergency, the security of India or any part of its territory must be threatened by such an emergency, and thirdly, the cause of the threat must be war, external aggression, or internal disturbance. The existence of the situation must be demonstrated as an objective fact, and that the correlationship between the cause and the effect must exist. The court rejected the argument that the context of the extreme financial exigencies arising due to the spread of COVID-19 pandemic had necessitated the deployment of the notification to a holistic approach to maintain the production, adequately compensate workers, and take sufficient measures to safeguard the said factories and establishments in carrying out essential activities. Following the principle of proportionality, the court held that the impure notifications did not serve any purpose apart from reducing the overhead costs of all factories in the state without regard to the nature of their manufactured products. A blanket notification of exemption to all factories irrespective of the manufactured product while denying overtime to the workers was indicative of the intention to capitalize on the pandemic to force an already worn down class of society into the chains of servitude. We are now entering into the age of machines. Question is, are we now entering a world of artificial administration in which government bodies will use information technology and artificial intelligence to replace or substitute human decision makings? Artificial administration has been described as a socio-technical ensemble of software and hardware that combines technology and process to mine a large volume of digital data, to find patterns and correlations within that data, distilling the data into predictive analytics and applying the analytics to new data. Although it has been mooted by some authors that techniques such as algorithms, neural nets, and predictive analytics certainly have substantial potential to improve the scale and efficiency of government in the provision of public goods and services, but many authors, and me too, believe that clarity is needed about where and how they can properly be used. And during the course of discussion, this problem, I'm sure, will be addressed and some solution will be found out. In the present perspective, the judicial review globally has improved the quality of decision making by making it more structured and consistent, and contributed to upholding the values of fairness, reasonableness, and objectivity in the conduct of public domain. The law of judicial review transformed from error on the face of the record to error of law in anismenic, and achieved by making use of the available ground of jurisdictional errors. Courts have currently identified disproportionality as a species of irrationality, failure to give reason, or denial of hearing as a species of procedural fairness, and as an indicator of irrationality in the case of an aberrant decision, and perhaps fundamental error of fact as a species of error of law. The judicial review, as a result of its procedure and its doctrines, has greatly increased accountability for the way in which government power is exercised is beyond doubt, but it is not all embracing. The courts will be reluctant to become involved if the subject matter is not amenable to the judicial process and is concerning matters of political opinion, involves questions of social and ethical controversy, or the allocation of resources, lacks objective criteria, or involves such questions of policy that the courts should not include because they are ill-equipped to do so. The law of judicial review can be said to be the product of competing judicial concerns of proper vigilance and proper restraint. The courts have to hold an intricate constitutional balance. On the one hand, judges must ensure that public bodies are accountable to law and that abuses and excesses of power do not go unchecked. On the other hand, the courts cannot and must not interfere by second-guessing a decision for which the relevant public body and not the judiciary has a primary function and responsibility. This intricate balance was identified by Sir Thomas Bingham in the military case when he said, and I quote, "It is not the constitutional role of the court to regulate the conditions of service in the armed forces of the crown, nor has it the expertise to do so, but it has the constitutional role and duty of ensuring that the rights of citizens are not abused by the unlawful exercise of executive power. While the court must properly defer to the expertise of reasonable decision makers, it must not shrink from its fundamental duty to do right for all manner of people. In a fairly recent decision in Punjab State Cooperative Milk deciding 2021, the Honorable Supreme Court has indicated 5 issues to which the court should confine itself to decide whether the administrative decision is to be interfered in the exercise of judicial review. The 5 issues are whether a decision-making authority has exceeded its power, second, committed an error of law, third, committed a breach of the rules of natural justice, fourth, reached a decision which no reasonable tribunal would have reached, and fifth, abused its powers. In relation to law enacting or modifying economic measures, the courts have respected the wisdom of legislature and observed that such enactments or modifications would not be subjected to judicial review if provisions in questions are otherwise compliant with the Constitution. The freedom of legislature to experiment and modify rights is often based on experience and actual working of economic measures. Wider latitude is to be given to legislature in economic matters, which essentially arise from separation of powers under the Constitution. The court in the vaccine case, which is the distribution of essential supplies, have recognized this separation of power doctrine. However, the court said that our Constitution did not intend for the courts to remain mute bystanders when executive policies impinge on individuals' fundamental rights. Judicial scrutiny and seeking constitutional justification for executive policies is an important job that the courts have been tasked with. In this case, by a comparative analysis of the administrative law in the United States, the Supreme Court of India cited instances when the Supreme Court of the United States, in the wake of current COVID-19 pandemic, stated in Roman Catholic case that members of this court are not public health experts and we should respect the judgment of those with special expertise and responsibility in this area. But even in a pandemic, the Constitution cannot be put away and forgotten. The policy of the central government for conducting free vaccination themselves for groups under first 2 phases and replacing it with paid vaccination by the state or union territory governments and private hospitals for the persons between 18 to 44 years was held to be prima facie arbitrary and irrational. The central government was directed to consider utilizing its position as a monopolistic buyer in the market and pass on the benefit to all the persons, as most of the states, union territories were largely unsuccessful to negotiate with foreign buyers. The court said that when constitutional rights of citizens are infringed by executive policies, the court should exercise its jurisdiction to determine if the chosen policy measure conforms to the standards of reasonableness, militates against manifest arbitrariness, and protects the right to life of all persons. A well-designed framework with pre-established procedures and substantive rules are necessary to address these issues, and a strong legal framework which would prevent the executive branch from exercising its power in an arbitrary, capricious, misinformed, or excessively disproportionate manner. Proper implementation of statutes, rules, and regulations, or to amend the existing laws to control such situations concerning public health are required to be made, as law is one of the gatekeepers and remains a key instrument to guide and discipline executive power. There is a need for innovative and dynamic approaches to deliver public goods. As opposed to authoritarian effectiveness, it calls for an inclusiveness and introduction of welfare measures for all countries faced with the same situation, and there may be a need to formulate a robust national and global health administration with proper guidance and measures keeping in mind the welfare of the people. As an exercise in comparative administrative law, today's conclave on administrative law in the time of the pandemic builds on a rich tradition founded upon an American educator and legal scholar, Frank Goodnough's direction that only by study and by comparison of our own with foreign administrative methods can we adequately meet the enormous demands of the administrative side of the government posed by our modern complex social condition. According to another author, Roberto Scarciglia, this view of Goodnough gained popularity in the wake of World War II, possibly the last common global experience, even somewhat comparable to the current situation. As the globe grapples with a deadly pandemic, it is more important than ever to understand how administrative law shall interact with the ever-changing face of polity, economy, and public welfare in future. I conclude with a passage from the Maha Upanishad, which says, I am Nija Paroveti Ganata Laghu Chetasam Udar Charitam Tu Vasudhaiva Kutumbakam, which in English means, this is mine, that is his, say the small-minded. The wise believe that the entire world is a family. I wish wellness for all, and I thank the organizer, the NUJS, for inviting me for this session. Thank you.
Thank you so much, sir. We're extremely thankful for you sharing so elaborately on the virtues and dynamics of good governance and delivery of justice with us. It has been really very enlightening. As we draw near to the conclusion of the inaugural session, I invite Dr. M.P. Chengappa, the program director of the Conclave, to share his thoughts with the audience on the Conclave.
Yes. Thank you, Ayushi.
Over to you.
I'm very happy to see all the resource persons, delegates, participants, and ladies and gentlemen. Let me discuss about the primary goal of the conference. The conference primarily is to understand various principles of the administrative law. We come across administrative law. Couple of the principles have been contributed in order to attain the administrative justice. This conference, we will look into the changing paradigm of the administrative law. The administrative law is one of the outstanding development in the 21st century. If you look at the present contemporary issues, especially in the 21st century, the country is moving towards disinvestment, deregulation, then denationalization, and mushrooming growth of regulatory bodies. So how far these bodies are going to deliver the administrative justice? Because the tribunals, regulatory bodies have taken over the essential functions of the judiciary. If you look at past 5 to 10 years, we come across more and more regulatory bodies are coming in. We need to see and to what extent the principles of independence, the principles of separation of the power have been followed by this independent the agency while delivering the justice. And also seminar will dwell into the issues. If you look at, the government is biggest the litigant, especially when it comes to the administrative issues is concerned. The common people often approach the court of law in order to get administrative justice. Are we using too much the principles of constitutional law? Are we really giving much importance to the administrative law? Those issues we will look into it. Apart from that, the conference also, the thrust area of the conference will focus on the identifying few of the important research areas where we will work into those areas and provide proper the guidance to the policymakers and law reformers. Apart from that, the conference also will build the knowledge system in order to promote substance of the law in a holistic perspective by looking into the comparative the approach. Anyway, the session spread across 16 sessions. We have nearly 24 the resource persons from the judges, the academicians, the policymakers, and the professors also will be discussing, deliberating the issues over 2 days. I sincerely thank our Honorable Vice Chancellor sir. Under his guidance, this program is happening. I also thank the Honorable Lordship Justice Omen Sen for graciously accepted our invitation to share very, very informative the matters pertaining to the administrative law. Thank you all. Yes, over to
Professor.
Thank you so much,
Since your paper is a valuable one, if Chengappa thinks of publishing the proceedings in a book, I will request Justice Sen to contribute one important. That may be the first one. Restop all the.
I may have overshoot the time, but I'll try to edit. And
Yes, yes. After some.
I'm sure that I have overshoot it. But I will certainly I will send the papers after I edit it.
After some editing.
Yes, I will. Thank you. Thank you.
Thank you so much, sir. With this, I would now invite Samar, a student coordinator of the conclave, to take over as the moderator of the following session. Welcome, Samar.
Thank you very much, sir. Yeah.
We'll start the next session. Good morning, everyone. Hello and welcome to the first session of the two-day conclave on contemporary issues in administrative law being organized by NUJS Kolkata. I am Samar, fourth year BA LLB student at NUJS, and I'll be your moderator for this session. At the outset, I humbly apologize to all our participants while conveying that Professor MP Singh will not be joining us today due to some personal reasons. However, he has conveyed his best regards to all of us and the conclave. Moving ahead, we have with us Professor Dr. Samit Singh, who will be addressing us on this extremely pertinent theme, that is contemporary issues in administrative law and its interplay with constitution. Professor Singh is an assistant professor of law at NUJS Kolkata and teaches constitutional as well as media and entertainment law. Sir has completed his BSc, LLB, LLM, MPhil and PhD from NUJS. Sir is also the director of Center for Media and Entertainment Law at NUJS. On behalf of the organizing committee, I welcome you to the conclave. We also have Professor Dr. MP Chengappa, Assistant Professor of Law and also the Program Director of this conclave. Sir will also be sharing his thoughts on the theme. It is my understanding that the relationship between administrative law and constitutional law is not very watertight. Both constitutional law and administrative law are parts of the public law and cannot really be separated from each other. Very often when courts are dealing with administrative challenge, they have to deal with the principles of constitutional law as well. Hence, it is very important for jurists, scholars and students to develop a proper understanding between the relationship between these two. I am sure all of us are intrigued to hear more on this from our speakers. However, before we start the session, I would like to set some rules that we are going to follow. Participants are requested to put their questions in the chat box, and we shall take as many questions as time permits. Since it's going to be a long day, we need to adhere to the timeline strictly. I would also request the participants to keep their cameras on and microphones on. Without any further ado, I request Professor Singh to kindly take over.
Samat, am I audible?
Yes, sir, Professor.
Okay, great. Thank you so much for inviting me, Chengappa. My humble gratitude to Honorable Professor Chakraborty, the Vice Chancellor, Dr. Chengappa, my very good friend and colleague. And it was such an amazing opening session, highly enlightening by Justice Shoman Sen. So my humble gratitude to all of them. Back in the 1990s, Sachin Tendulkar, when he started opening for India in the one-day format, he had around 19 opening partners. From Vikram Rathod to Sujit Somasundar, ultimately he settled on to Saurabh Ganguly. But, the 17 or 16 of them are not particularly good ones. I had an expectation that I would be playing a Sujit Somasundar or a Vikram Rathod to Professor MP Singh's Sachin Tendulkar. Now, just 3 minutes back, Samad gave me this, information that, possibly that cushion is not there. So I will have to open the batting. Naturally, it's a huge shoe to fill in, honestly speaking. Standing in for Professor MP Singh is not easy by any stretch of imagination. I will try to do my best. I will not want to bore you to death. I will keep my opening remarks short and precise. If at any point of time anybody feels the necessity to ask me a question, please do type your question on the chat box. I will just like to flag a few issues because the amazingly well spread out lineup that you have for over the next two days provides you an opportunity to discuss each of those concerns that I raise at much greater depth, at much greater lengths. So therefore, my humble effort for the next 15 odd minutes would be to simply flag a few issues. Now, one more caveat, this is the problem with a constitutional law teacher, that a constitutional law teacher always suffers from a predatory instinct. That, everything in law tends to get subsumed into the wider gamut of constitutional law. This is our inherent instincts. So we would, definitely as constitutional law teachers like you to believe that administrative law is nothing but a subset of constitutional law. When we say public laws, essentially what we do is, we tend to relate everything to constitutional law and subsume everything into constitutional law. So I will naturally, coming in from that background, try to restrict myself to delineating some specific areas where administrative law has also played a very important role in developing our constitutional foundations and our understanding of certain constitutional rights and restrictions. In addition to, of course, looking at the inherent similarities and inherent interplays between the two. Now, like all of us are aware that the Constitution of India talks about a lot of written principles as well as a lot of unwritten principles. Constitutional conventions and several other unwritten principles have informed our constitutional journey. So where have those unwritten principles come from? Justice Shoman Sen was very right when he was making references to rule of law. All of these things, rule of law, our perception of rights, certain rights as natural rights, inherent natural rights, inalienable rights. This entire thing about just, fair, reasonable restrictions, just, fair, reasonable procedures, this entire migration from a very formalistic notion of procedure established by law to something closer to due process in Article 21. This entire, migration from reasonable classification to arbitrariness to manifest arbitrariness in Article 14. Now, essentially, these constitutional journeys are nothing but reflections of standards of administrative law into our constitutional decision making. What is arbitrariness? What is just, fair, reasonable? What is rule of law? When we say that infusion of natural justice into an administrative decision making is what forms the, one of the integral backbones of rule of law. What is natural justice? Where are we getting it from? We are getting those principles from the realms of administrative law. We are simply trying to constitutionalize them. More on rights later. So this is definitely one issue that I would like to flag, that when we are interpreting the constitutional text with references to written and unwritten principles, and principles not just informing our discourses on rights but also on restrictions to those rights, we are infusing standards of administrative governance, principles which have been known to the realms of administrative law over the years. Similarly, a very recent constitutional controversy has been with respect to the ambit of federalism in the specific context of administrative officials. Recently, and I'm sure many of us will find opportunities to discuss this in the coming 2 days. And of course, Mr. Alapan Bandyopadhyay is one of your panelists. So he has had a very personal tryst with, these kinds of issues. This entire conflict between the centripetal federalism in regulation of civil services and the quasi-federal model of constitutional governance has again come to the fore. This controversy has come to the fore in the context of the recent proposed amendments to the Indian Administrative Service Cadre Rules of 1954. This entire thing about borrowing of civil servants from state to center and the tussles therein, this regulation of civil servants by central government, putting them under suspension, putting them under inquiry because they had shown allegiance to the state. So in the context of the widely known principles of federalism, and centripetal federalism in the context of administrative officials. This is a hugely important issue which begs further discussion. And I'm sure this issue will be amply discussed over the next 2 days. Right. So that's one more area where I think there is a very distinct linkage between constitutional law and administrative law, and it requires further discussion. When we talk about delegated legislation is essentially a form of administrative rulemaking. We know about, Justice Sen was mentioning about how Article 13(3), when it defines laws, it takes into account not just statutory laws, but all forms of rules, regulations, bylaws, etc., notifications, and every other thing. But this entire business of delegated legislation, as much as it is an administrative issue, it is also a very important constitutional issue. Everything else aside, if you simply open a constitutional law textbook, if you open Article 245, when it talks about the territorial extent of parliamentary and state laws, you will have an elaborate description of where and what are delegated legislations and what do they stand for, and in what means and in what ways do principles of regulation to delegated legislations work. So, once again, we can't simply put these issues in silos. We can't say that there is a specific domain for administrative law and in silos there is a distinctly different domain for constitutional law. There is a very keen, a very deep interplay between the two. Similarly, again, just referring to Justice Sen's keynote address, this increasing thrust towards tribunalization. We talk about administrative tribunals being set up and their regulation, and we have had the Madras Bar Association series of cases. Now, look at it. The primary objection that people have towards tribunals is that the government gets to get to select the judges, and the government happens to be one of the principal litigants before the tribunals. So, what is it that what is the concern that is being raised? The concern is simply a concern of natural justice. The concern is simply a concern of fairness in the trial process, in the adjudicatory process. And fairness and natural justice, as much as they are principles that inform administrative law, they are very deeply, imbued into the constitutional jurisprudence, be it in Article 14, be it in Article 19, and more importantly in Article 21. So once again, you find a very definitive, correlation between the two. Coming to judicial review of administrative actions. Now, any student of constitutional law would let's take cases like simple cases that all of us are aware of. Ramana Dayaram Shetty, the R.D. Shetty case. What was this R.D. Shetty case about? It was about distribution of largesses. Right? If you're a government body, the issue was about whether International Airports Authority is state or not. But once it was proved that it was state, it was very categorically said that in the distribution of largesses, you need to follow certain due procedures. Certain procedures of fairness. There are certain responsibilities which are inherent in you because you happen to be state. Now, these laying down the procedures of fairness are again standards that are borrowed from administrative law and find reflection in the constitutional jurisprudence. When in Ajay Hasia, the arbitrariness doctrine is used. The arbitrariness analysis had always been a very integral part of administrative law. But we find that arbitrariness has gradually found its place into constitutional governance. Now, let's recollect E.P. Royappa, the very first case where this entire new equality approach was introduced by Justice Bhagavati. What was E.P. Royappa about? E.P. Royappa was about an acting chief secretary who had been refused, permanence. Just the genesis. And subsequently you find all these cases where arbitrariness, just as a matter of recollection, arbitrariness test was used predominantly in the context of administrative orders. to begin with. It was only about 30 years later that we find that Justice Rohinton Nariman in Shaira Banu, in Naftet Johar, in subsequently also in Puttaswamy and many other decisions, has introduced this element of manifest arbitrariness scrutiny of legislations. But the arbitrariness doctrine that we had known from 1970s had primarily been used in the context of administrative orders, executive directions, right? So how gradually an administrative law principle, which was predominantly used to scrutinize administrative orders, had now been elevated to the standards of a constitutional scrutiny of legislations, where that legislations, there is this deference towards, there's this presumption towards constitutionality of legislations and all of that. But the principle of arbitrariness finds a newer reflection in the form of manifest arbitrariness scrutiny of legislations. So how important the arbitrariness test has become in the context of judicial review. Justice Sen was talking about the transition from Wednesbury reasonableness to principles of strict scrutiny and proportionality. This entire four-pronged test of proportionality that was evolved in modern dental and followed in Puttaswamy 1 and Puttaswamy 2, you can clearly see that there is a very distinctive transition, a very distinctive evolution of this journey. Wednesbury reasonableness can be looked at as a starting point. Of course, we had germs of proportionality, over the last 60 years in our constitutional history. If you look at Chintaman Rao's case back in the 50s, if you look at Vijay Rao's case in 1952, you had mentions of proportions and disproportions. But this formalized, structured, four-pronged test of proportionality is ultimately the culmination of a long journey. And this journey is informed once again by infusion of administrative law standards of fairness and rule of law into our constitutional decision-making procedures. So it is once again a very important element of this interplay, and I would like to say a very contemporary element of this interplay. Finally, I would just like to conclude with a very contemporary and a very recent example. Very strictly speaking, this is an example from constitutional law, but since it involves natural justice, and natural justice is one of the very primary elements of administrative law governance, so I thought that it was appropriate to discuss this before a forum. One more caveat that this matter that I'm discussing right now is about a sub judice matter, which is being heard by a competent court of law. But I think in a conference like this, when we are actually academically scrutinizing issues that are of contemporary relevance, I would not be committing any mistake in discussing this matter. You see, very recently, on 8th of February, to be more specific, of this year, a single judge bench of the Kerala High Court has approved the central government's non-renewal of license of this this agency called Media One. Media One is basically a news broadcasting company. Okay, so under the Cable Television Network Regulations Act, every 10 years you need to renew your broadcasting license. So their broadcasting license was due for renewal sometime in 2021, May 2021 to be more specific. This Media One has been on the wrong side of this incumbent government because of its reporting of the Delhi riots, because of which it was suspended for about 48 hours back in 2020. So in 2021, when Media One applied for renewal of its license, the central government refused. The central government denied the renewal and said that the renewal is denied because of national security concerns. That was the one-line response that was given, that you can't have your license renewed. Naturally, Media One, the proprietors of Media One, went to the Kerala High Court before a single judge and argued that this is unfair, this is in violation of their fundamental rights. The single judge wanted the opinions of the central government to come in. The opinions did come in a sealed cover, which is, the order of things these days. And in a sealed cover, it was told to the Kerala High Court that, there is a national security concern. The Kerala High Court, the single judge said that we are satisfied that for reasons of national security, the revocation of the license is legitimate. The issue that was raised by Media One is what about natural justice? We had not been given a fair opportunity before the decision was taken. We had not been given a pre-decisional or a post-decisional hearing. These are very standard principles of administrative decision making. The Honorable Single Judge of the Kerala High Court, and this is the point that I want to emphasize here, said that when it comes to matters of national security, these minor issues like natural justice can take a backseat. Now, this is a very important point that I want to highlight before this August point. Let me just repeat that these trivial issues like natural justice, rule of law, etc., can take a backseat when we come to an issue as important as national security. The councils on behalf of Media One argued that, my lord, since you are raising this issue, let us remind you that last year in the Pegasus leak case, the Pegasus tapping case, the Honorable Chief Justice of India, Justice Ramana, when the central government had said that this is a matter involving national security and therefore you are not to bother here, he said, no, so what? I would nonetheless like to scrutinize. National security cannot be a stumbling block in such cases. Now, what is it that national security plays a role here that you would not be, you would be denying us our natural justice hearings? To which the single judge, surprisingly, said that, the Pegasus case was about privacy. This is about free speech. The two are different. Now, I would just request this August gathering to consider the ramifications of these observations. Is it to say that for matters of privacy, national security cannot act as a stumbling block? Privacy, despite being called a fundamental right, it's nonetheless a right that is unenumerated in the Constitution. And for something as sacrosanct as right to freedom of speech, which has also been looked at as a part of the basic structure of the Constitution, natural justice is of no use. It is of no avail. There were some very, I would say, very cursory borrowings from a particular House of Lords decision of 1985, which the Supreme Court had done in 2015 and then in 2019. And relying on these two cases, relying on these two orders, the Honorable Single Judge mentioned all that he did. Why I wanted to flag this particular case before all of us here is that, even to us, issues like these, issues like natural justice, issues like rule of law, issues like fairness, issues like due process tend to take a backseat when such stumbling blocks like national security are posed before us. And I think, since we are discussing contemporary issues of administrative law, we would also be required to find ways out of these stumbling blocks. Because more and more of these stumbling blocks are posed before us. All the standards of fairness and reasonableness and justness that administrative law has brought before the table and has infused into the Constitution, will kind of take a backseat. So it is also time to reinvent this interplay and this infusion of administrative law and constitutional law values. With those words, I would like to pause for the moment, and I would be very happy to listen to my colleague, Professor Chengappa. Thank you so much.
Thank you so much, sir. You flagged concerns which are really thought-invoking, and I'm sure people will have questions. We'll take those questions. But before that, I'd like to invite Professor Chengappa to share his thoughts on this.
Yes, thank you, Dr. Samit Sen, for laying down very important issues with respect to interface between administrative law and constitution. Shamik rightly pointed about three cases, Manaka Gandhi, Royappa and AD Shetty case. If you look at facts of those cases, all are administrative issues. One is impounding the passport, transfer and the largesse. So now the question is, if you look at the constitutionalization of administrative law, yes, if you look at few of the articles, Article 14, Article 226, 32, 226, 311 dominates the providing the administrative justice to the parties. Now the question arises, how far judiciary promoted administrative justice? Unlike UK, in India, we rely both common law principles as well as the constitutional law. Today, fair play in action or the principles of natural justice dominated. If you look at the series of the cases, be it coal block allocations, spectrum allocations, and so forth cases, are being the question before the Honorable the Supreme Court with respect to violation of Article 14. If you don't follow procedure, if you don't follow principles of natural justice, then administrative action will become arbitrariness. Therefore, arbitrariness and rule of law will not go hand in hand. Therefore, we come across, if you look at 1/3 of the Supreme Court cases, we come across the administrative matters. The government is the biggest litigant before the court. Why these things are happening? Are the administrative officers are not aware about the principles of natural justice? If you look at land acquisition cases, 90% of the land acquisition cases goes to the High Court and Supreme Court for what? Lapse of the principles of natural justice, the procedural lapse. The Supreme Court and High Courts taken a consistent approach. They will not compromise the principles of natural justice. We have seen cases up to 14 years, 20 years. On technical ground, matter went to the court and the court has to quash the administrative action. This is the aspect. If you look at UK, as Justice rightly pointed out, the administrative developed in UK with the support of rule of law. Whereas in India, we have the constitution as well as the common law, the principles contributed immensely for the development of the administrative justice. Dr. Samik Sen rightly pointed out, on the one hand, we have tribunalization. Post L. Chandra Kumar case, R. Gandhi and series of the cases, the Supreme Court of India laid down the various guiding principles that tribunals have to embrace those values. Now the question is, are these independent regulators, they have taken over the judicial functions. The judicial functions, are they following Raj Dharma of independence of judiciary, the separation of the power? Those issues we need to take into the concern, because for the common people may not be able to go to High Court and Supreme Court. Many of the common people are satisfied with administrative decision of the tribunalization. This is one issue. Second, the Constitution talk about access to justice. Are this tribunalization are leaving up to the satisfaction of the people of the country? If you look at few of the tribunals have taken away the power of the civil court, and those tribunals situated in the state headquarters, we don't find access to justice. Secondly, delay in disposal of the cases. We need to think, should we move from the regulated decision making to the mediation or conciliation in order to dispose the cases quickly and expeditiously, in order to fulfill the constitutional role of access to justice and speedy the disposal of the cases. The further, one more important issue I need to flag on, are we referring too much the constitutional provisions in order to solve the problem? Should we really need to invent something in order to solve common problems? No, common people will have a problem whenever they go to revenue department, the municipalities and other local department. Why would they want to invoke only 226? Are there any other strategy to solve the problem? I think Sami can throw light on that. Are we referring too much constitutional principles to solve the administrative issues? Should we really
we are
sort of the dispute redressal mechanism which is independent, impartial?
Absolutely. As in, we are very often unnecessarily using constitutional principles. As in, this is something we see in constitutional law as well. You know, we unnecessarily use high-flying concepts like basic structure for settling minor issues. So the same thing is happening even in settling administrative, disputes. We're very right on that.
Yes, if you look at Vinith Narayan versus Union of India, one such case I find it very fascinating, where for the first time Supreme Court clearly laid down the principles that administrative officers need to be followed. We come across 12 guiding principles with respect to probity in public life. Otherwise, generally what happens, matter will go to High Court, Supreme Court, the court will simply reverse the decision. So, are we laying down some sort of the principles for administrative officers? After all, administrative law will be implemented by the bureaucrat civil servants. Those issues we need to look into it. Or we need to strengthen the regulatory bodies. Then apart from that, if you look at the principles of natural justice, we have explicitly incorporated within the Constitution, and the constitutionalization of principles of natural justice has been happening in our country. The judiciary has taken very, very consistent the stand with respect to that. Secondly, the essential legislative functions. This is one of the areas we come across. On the one hand, mushrooming growth of independent, autonomous regulatory bodies. Because if you look at the role of the state, simply now regulators. Most of the services are being provided by the private authorities. If you look at National Highway Authority, Telecom Regulatory Authority, Power Department, we are moving towards the PPP model. With respect to the PPP model, the administrative law emerging is one of the important aspects for the common people. The common people will have the grievance against whom? Not directly to the state, against the private multinational corporation. So in this the aspect, we need to look into what sort of the dispute redressal mechanism we need to incorporate to solve day-to-day problems the people of the country facing with respect to the state and state entities. Yes.
Thank you so much, sir, for sharing your thoughts on the issue. If we have any questions and if people want to ask it themselves, they can raise their hands or they can put it in the chat box. In the meantime, I would like to put a question to our panelists. Sir, as Chengappa sir also mentioned during his address, that we are constitutionalizing the administrative law principles and invoking them left, right, center in dealing with minor administrative issues. Is it, and this is largely because we do not have, written rules of administrative principles anywhere. Do you think how do you think that is this a need that we must have, that these principles need not be written and the discretion should be given to the courts? Or is it acting, or promoting judicial overreach in some sense? So how do you see this?
The question is to me.
So both of you can answer.
Sami?
You see, so long we have an Article 142 in our Constitution, which allows the Supreme Court to do complete justice. So these, what you call judicial overreach, I would rather say that this is, if not an overreach, at least proactivism on part of the judiciary. This is bound to happen. We do not have very distinctly demarcated, points of difference, realms of difference. There can't be, actually. So for that reason, you will have these kind of one transgressing onto the other. But
I don't consider these transgressions to be absolutely irrelevant transgressions. Just like we have evolved standards of arbitrariness into constitutional law jurisprudence from the administrative law principles. So if these transgressions are actually helping us towards going towards the path of rule of law, I think that is accepted. Check up.
I think Abhirup Mukherjee is having question. Yes.
Yes.
Hi, Dr. Nekappa. Good to see you, and good to see Shamik as well. So, although I am scheduled to speak much later today, but I could not help just participating in this wonderful discussion that's happening. So, just on the point of tribunalization, or on the point of a very pertinent question, I think, Dr. Chengappa, you raised that for small issues, why do we have to knock on the doors of a constitutional court, whether the High Court or the Supreme Court, when we have authorities or tribunals or people at the lower level to deal with these issues? Actually, unfortunately, my experience on the other side, and this is very interesting, like most of the people who are speaking, apart from the academics who are there, most of the people who are speaking, the bureaucrats, the administrators, unique position of being on the other side. And unfortunately, the rampant tribunalization of justice in this country, which of course they say is to lessen the burden on the judiciary, on the constitutional courts, that is the hallowed objective. But if you look at the composition and the series of decisions passed on or rendered by these tribunals, in most of the cases, I dare say not in 100%, but majority of the cases, even the basic concepts of the Wednesbury principles, basic concepts of administrative law have been given a burial long time back. If you look at L. Chandrakumar, if you look at Madras Bar Association, one of the basic tenets there was that a tribunal, which is a quasi-judicial authority, will not only be headed by a judicial member, but there shall be a majority of judicial members in a tribunal. I will give you just two examples of how it is being blatantly disregarded. And in my very humble submission, even the constitutional courts, although some of these cases are pending before, challenges are pending before various constitutional courts, but till now, even one constitutional court has not come down heavily on the government for blatantly disregarding these principles. Two examples I'll give you. The one example, again, a sub judice matter, but this point is being deliberated upon, so I will touch upon this, is the National Anti-Profiteering Authority, which under GST law had been set up by the government with very laudable objectives, I may say so. But if you look at the constitution of that authority, there is not even one judicial member in that authority, let alone there being a majority or let alone it being chaired by a judicial member. And it is adjudicating disputes worth hundreds of crores of rupees, and it is giving decisions. The second is also the National Consumer Protection Authority that has come up recently. Not one judicial member. This is one aspect. The second aspect is when a tribunal which is bereft of, I would not say the administrators are bereft of judicial knowledge. Many of them are qualified lawyers as well. But when they wear the hat of an administrator, how impartial or how unbiased these people can be and how much can they respect the principles of natural justice is something which we seriously need to think about. And the blatant example, the most blatant example, like my friend Dr. Sen said, that even if in the cases of right to free speech, if a judge says that natural justice things are small things, principles are small principles, that is alarming. So people going with economic disputes before the courts, we stand way back in the line. If free speech is not protected by natural justice and the principles thereof, how can a commercial dispute try to get that protection? So these are very important points. I'd like the young students to read up, discuss and deliberate these things in your academics. You write a lot of papers and all that. And also for the learned professors, the administrators to look and ponder upon these things. Because the Supreme Court can set laws. It can lay down laws, Article 141 and all that. But whether we choose to consciously disregard it is something which we seriously need to think about.
Thank you so much, Abhiroop sir, for your observations, and I'm sure students will take you from that and discuss it further. If there are any more questions, we can take them, or else we'll have to wrap up the session. All right, we don't have any other questions. I'd request Shamik sir if he would like to make some closing remarks for the session, and then we'll conclude this session.
As a closing remark, I would thank Abhiroop for raising a very important issue. I'm sure, when he speaks later in the day, he will touch upon this entire problem with the tribunalization exercise, because he sees things live on the ground, and the realities are much more sordid than what we read on the books. So naturally, I think it's a nice beginning. We have been, both Chengappa and I, we have been able to flag a few concerns, and I'm sure in the sessions that follow, all of these concerns will be discussed at much greater lengths and depths by all the other panelists. I thank you all. I thank the organizers, the conference organizers, Dr. Chengappa, and everybody who's participating. It has been my pleasure to attend the session. Thank you so much.
Thank you so much, Shamik sir, Chengappa sir, and Abhiroop sir. Without any further ado, I'd request Rajat to kindly take over for the next session.
Thank you, Samarth. For our next session, we have Ma'am Dinesha Samararatne. Apologies, ma'am, if I'm not saying that correctly. She will share her views on tracing the expansion of common law principle and its application in the field of administrative law. Ma'am is a senior lecturer at Department of Public and International Law at the Faculty of Law at University of Colombo. At the university, ma'am has been teaching administrative law, constitutional law, and human rights law. Ma'am is an LLB graduate from the University of Colombo itself, and she is an attorney at law. She reads for her master's degree as a Fulbright scholar at Harvard Law School, and she has completed her doctoral studies at the University of Colombo. Her recent research's work has been in relation to the public participation in constitution making, judicial enforcement of economic and social rights, judicial interpretation of fundamental rights, and the influence of Indian public law in the development of public law in Sri Lanka and access to justice. Without further ado, I would like to call ma'am to share her views on the topic of the session. Thank you.
Thank you very much. Good morning to all of you. I join you from Colombo, where I'm based at the moment. Let me begin by thanking the chair and also Dr. Chengappa for the invitation to speak with you today. My current thinking on the evolution of common law principles in administrative law. I am primarily a student of public law in the Sri Lankan context, as was said in the introduction to this panel. As such, much of my engagement with public law in India, whether in relation to constitutional law or administrative law, has been for the purpose of studying the impact of that law on Sri Lanka. The insights I offered today, therefore, are qualified to that extent. Now, in the time allotted to me today, I would like to make 4 points. The first, I would like to suggest to you that we are perhaps at a stage where the development of the common law in administrative law and its grounds of review must be free from the GCHQ formulation. Lord Diplock's description of the grounds of review as comprising of illegality, irrationality, and procedural impropriety, with the addition of proportionality as a new ground, has, I think, outlived its value. Second, I would like to revisit the constitutional context in which the common law exists in India and Sri Lanka to argue that the ongoing process of constitutionalization of principles of administrative law in both jurisdictions has several implications for the common law. And I'm mindful that you have already begun the discussion on this point. Third, drawing from my own research, I would like to draw attention to the ways in which common law principles and constitutional interpretations in India are influencing the development of administrative law in Sri Lanka. I will use that pattern to suggest that we think broadly and differently about the expansion of common law principles in administrative law. Fourth and finally, I will refer to the right to information legislation in Sri Lanka to highlight the limits to a common law focus or court-centric focus to the study and understanding of administrative law, particularly in this part of the world. So let me begin with my first point. The GCHQ formulation of the grounds of review reflected administrative law as it was in the early 1980s. In hindsight, we know that Lord Diplock's reference to proportionality as a ground of review was accurate for that time. At a time when administrative law was gaining ground as a distinct body of law in the common law, Lord Diplock's formulation helped to clarify and guide the further development of that subject. Today, however, we are at a stage where we can recognize that these traditional grounds of review are not that helpful in clarifying the common law as it is for us today. The current debate on this topic is developing in at least two dimensions. First, we can trace a debate among scholars as to the coherence of the three grounds of judicial review. As I see it, the question that is raised here is, do these three or four grounds of review reflect the current state of the common law? How stable is the distinction between these grounds of review? Due to the lack of clarity, some have argued that a broader and single ground titled fairness would be a more accurate and honest description of the scope of judicial review in comparison with the three or four grounds that have been traditionally invoked. Another approach is to probe the values that underlie judicial review. Recently, Paul Daly has argued in his book titled Understanding Administrative Law in the Common Law World that four values are foundational to substantive judicial review. They are, according to him, individual self-realization, good administration, electoral legitimacy, and decisional autonomy. Drawing from his study of several common law jurisdictions, Daly demonstrates the relevance of his thesis. This argument adds more depth to the ongoing debate in administrative law about judicial deference and the so-called distinction between appeal and review. Joanna Bell, in her recent publication, The Anatomy of Administrative Law, draws attention to the structural dimensions of the field by examining applicable legislation, normative goals, and the nature of the challenge to administrative action by way of judicial review. These recent academic interventions are examples which reveal the depth and complexity of the field, which, I would argue, brings us quite clearly to a post-GCHQ formulation stage in the field. This is also evident in the body of administrative law that is not court-centric, but I will turn to that dimension later. The second dimension of this development is captured quite well in the report of the Independent Review of Administrative Law that was tabled in the UK Parliament in 2021. Prompted by the Miller decision, this inquiry considered the prospects and limits of the scope of judicial review in the United Kingdom. From the perspective of the Commonwealth, it is quite interesting to note the ways in which the former metropole to some of its former colonies to understand the prospects for the codification of the grounds of judicial review. The two options that are considered in the report.
Ma'am, sorry to interrupt, but I think there's some background noise at your end. I'm really sorry.
Right. Yeah, I think I can. Just give me 1 minute, please. Sorry, there's some construction next door, which is probably what you're hearing. Is it better now?
Yes, ma'am. Thank you.
Okay, sorry, it might occur again. And if it's disturbing the quality, let me know and maybe I'll have to pause a bit. Okay, so I was talking about the second dimension of the development, which I see is a post-GCHQ type of development. And it's captured quite well in the report on the independent review of administrative law that was the report that was tabled in the UK. So in that report, the committee considered two options for the codification of grounds of judicial review. One was a statement of general principles. The second was a detailed list of the main grounds of review, and they consider both options. But more broadly, it's considering the approach to the common law. The committee considered the following options: making specific provision for preserving the common law, containing a clause permitting any other ground of judicial review, maintaining an silence on the subject, or seeking to abolish the common law. So 4 different options. Now, it is useful for us to consider these developments in the United Kingdom from the perspective of our own legal systems. When we add the historical dimension to it, I think it becomes even more interesting. We are familiar with the ways in which we critique the forced introduction of aspects of common law by the British Empire in its colonies.
Apologies, ma'am, but I think that background disruption is still continuing. So, it's difficult to follow the discussion.
Right. Now it's not the sound. There is no background noise here. Shall I switch my video off and try?
Ma'am, I think it's
not me. It's somebody. It's anybody else's mic.
No, I think it's the fan or something is there. Because of that, it's happening.
Earphone one can use, no? Tell.
This voice will still be captured. I think.
No,
it's because
How is it now?
Yes, ma'am, it's fine. Thank you so much.
Okay. Sorry, I've not had these disruptions before. I'm sorry about this. Okay, so where were we? So as I was saying, looking at these approaches to judicial review and the review of the role of common law in judicial review in the United Kingdom is interesting for many reasons. One of which is that in considering its approach to review, the UK, the committee appointed to look into this review looks at its former colonies in trying to understand the different models that may be adopted. Now, we are familiar with how the common law was received by the colonized states, colonized peoples, and the territories. But when these models and principles and institutional arrangements traveled from the metropole to the colonies, they changed in some form or another. As these legal ideas took root in each colony, they changed and adapted yet again, producing unique legal forms. Today, we are witnessing the ways in which the dynamics in the common law world thus created are changing, and the metropole is seeking some guidance from developments in its former colonies. Now, be that as it may, that is not the topic I'm discussing today. What I have tried to argue so far is that the scholarly debates on the grounds of review and the renewed interest in the debate on codification of the grounds of review suggest that the common law has developed well beyond the GCHQ formulation of the grounds of review. That's the limited point I wanted to make first. Let me now turn to my second and third points.
The constitutional part,
which is about the implications for the common law of the constitutional context of our jurisdictions and the Indian influence in this sphere. In India and in Sri Lanka, the writ jurisdiction and therefore the body of common law that informs judicial review is constitutionalized in the broadest possible terms. For reasons that are not very clear to me as of yet, our constitutional drafters chose to vest these judicial remedies with constitutional status. In Sri Lanka, unlike in India, the writ jurisdiction was constitutionalized only in 1978. The original writ jurisdiction was vested with the Court of Appeal, but was extended to provincial high courts when they were established in 1989. In what ways does a written constitution impact the development of a public law remedy found in the common law? Here, I would like to draw on developments in Sri Lanka, and I hope during the discussion to hear your views on whether you think the Sri Lankan developments resonate with the developments in India. The constitutionalization of this remedy, in my view, has allowed the judiciary to expand Sri Lanka's fundamental rights jurisdiction to include the principles of common law. Mario Gomez has documented this development as it unfolded from the 1990s. I will use two examples to illustrate this development today. Both developments involve references to corresponding developments in India. One is the expansion of the right to equality to include the Indian formulation described at the time as the new doctrine of equality developed in the Royappa case. Although the adoption of this doctrine was initially rejected by the Sri Lankan court, I demonstrate in my article published with the Indian Law Review in 2018 that the judiciary began to use the same reasoning in its subsequent decisions. A more recent and highlighted use of this concept was in the decision of the Supreme Court in Sambandhan versus Attorney General, which resolved Sri Lanka's constitutional crisis in 2018. The scope of the right to equality in Sri Lanka today is very broad. This development is problematic to the extent that the administrative law-based approach or the common law-based approach has eclipsed the human rights dimension of the right to equality in Sri Lanka. The human rights approach to the right to equality and non-discrimination has been eclipsed to the extent where jurisprudence on that dimension is hard to come by in Sri Lankan law. For instance, we have very few cases in which interpret the right to be free from non-discrimination and the right to equality. Much of the jurisprudence on Article 12 involve the judicial incorporation of principles of common law, such as the rules of natural justice, legitimate expectation, and reasonableness. As I argue in my article in the Indian Law Review, the use of Indian jurisprudence by the Sri Lankan court reveals an interesting trend. Moreover, it challenges the received wisdom in Sri Lanka that the common law as developed in the United Kingdom is the source of law for its administrative law. My second example is the development of the public trust doctrine in Sri Lanka. You are probably very familiar with the public trust doctrine as developed in India for advancing environmental justice through litigation. In my early work, published in 2011, I have demonstrated that the public trust doctrine as developed in Sri Lanka is distinct from its counterparts in the United States, and the Sri Lankan judiciary has used the concept of the sovereignty of the people, recognized in Articles 3 and 4 of our Constitution, the right to equality, and the directive principles of state policy to develop a much broader concept in its reach. The Sri Lankan judiciary rely on the public trust doctrine in their review of the exercise of discretionary public power, in reviewing executive action on natural resources, and in its management of national resources such as public corporations. It has also relied on this concept when engaging in pre-enactment review of bills that seek to weaken parliamentary control of public finance. Unlike in India, the Sri Lankan constitution prohibits judicial review of legislation. Interestingly, the public trust doctrine is used in Sri Lanka's writ jurisdiction as well as in its fundamental rights jurisdiction. Excuse me. Sorry. Again, another difference between the Indian and Sri Lankan constitutions is that we have two distinct judicial remedies in the form of fundamental rights and writs. In the example of the Sri Lankan public trust doctrine, yet again, we see the Sri Lankan judiciary develop its common law-based judicial remedy by looking beyond the traditional body of common law, looking into its own constitutional basis, as well as to other Commonwealth jurisdictions in developing a new ground of review. Now, I would argue that the public trust doctrine is still at its early stages in Sri Lanka and is yet to be consolidated, but I think this point largely remains true. Excuse me. Now, there are other examples which demonstrate this pattern. I have in mind here the examples of public interest litigation and the expansion of the scope of natural justice. Again, was discussed previously. I will not go into those examples in the interest of time, except to note that the Indian experience with public interest litigation has been controversial, dynamic, and led to numerous debates on the scope and limits of judicial review and the judicial mandate. The Sri Lankan experience with public interest litigation is much more limited. In any event, the point is this. In places like India and Sri Lanka, the common law is inherently located within a written constitution which is specific and unique. At the same time, the broad formulation of the judicial remedy permits the judiciary to draw from the common law world in developing that remedy. This unique combination throws up interesting prospects for the development of the common law, as shown in the examples I discussed. It could potentially have knock-on effects, some progressive, some perhaps not so progressive, as evidenced in the ways in which Sri Lanka's right to equality jurisprudence has suffered. This brings me to my final point for today, which is about the limits of a court-centric and common law-centric focus to the study of administrative law. In the report on the independent review of administrative law in the UK, the committee notes that 90% of the petitions subjected to judicial review in the United Kingdom from England and Wales relate to immigration. In my own work, I have established that more than 90% of the petitions determined under Sri Lanka's fundamental rights jurisdiction are petitions where public servants are challenging recruitments, appointments, or transfers, or petitions regarding admissions to state schools. Now, I would be interested to learn from you the corresponding empirical trends that you have noted in India. But this data from Sri Lanka and UK affirms what we already know. Petitions that seek a judicial remedy for administrative wrongs are not a fair representation of the functioning of the administration. But the examples I gave you go a step further and suggest that the judicial remedies are mostly used by one sector or another. In that case, it would logically follow that the development of the common law principles in administrative law represents perhaps one aspect in an exaggerated form. Arguably, the view we get is a lopsided one in that it builds off particular types of petitions. It is necessary then to bear in mind that a common law focus on this subject is a limited one. A court-centric focus must be understood in its limited sense. The developments with regard to administrative justice in South Africa and global developments on the right to information are two examples of relatively recent developments in the field which speak to the broader issues in the subject. Allow me to illustrate this further with the example of the right to information. Sri Lanka has been inspired to a great extent by the right to information movements in India. Sri Lanka's only reform of its fundamental rights chapter in 2015 was to incorporate the freedom of information as Article 14A. Of course, prior to that, the Sri Lankan judiciary had recognized explicitly in the Goldface Green case of 2005 that the freedom of expression includes the freedom of information. In any event, the adoption of the Right to Information Act in 2017 has set in motion what I would describe as a ground-up movement to strengthen administrative justice. This movement is led by domestic and international civil society actors, by journalists, by activists, and other publicly engaged citizens and institutions. Sri Lanka's first Right to Information Commission was guaranteed its independence under the 19th Amendment of 2015. Since 2020, however, that has changed significantly with the adoption of the 20th Amendment. Nevertheless, the legislative mechanisms for the right to information remain an active site for seeking administrative justice. Unlike the judicial remedies in administrative law, as we all know, filing an RPI is not expensive, not constrained by geographical location. Much more assistance is available for filing an RPI, and the procedure is intellectually and socially accessible as well. A study of some of the key orders by the RTI Commission suggests that the Commission is adding to our understanding on concepts such as public interest and public benefit, and giving real meaning to accountability, transparency, and responsiveness of public institutions. Arguably, the reach of the RTI regime, therefore, is very significant. This is but one example that suggests to us that as scholars, practitioners, and students of administrative law, we ought to broaden our perspective to more fully appreciate the developments on the ground. Let me wrap up now. Today, I have sought to suggest 4 points of analysis or deliberation when thinking about the evolution of common law in administrative law. First, I suggested to you that we are perhaps at a stage where the development of the common law in administrative law and its grounds of review must move beyond the GCHQ formulation. Lord Diplock's description of the grounds of review as comprising of illegality, rationality, and so forth, I think has outlived its value. Scholarly debates and the recent independent review in the UK illustrates this point. This seems to be a moment in which we can review the idea of 3 grounds of review and think more about conceptual advancements made in the field since the GCHQ case. It is also a moment in which the place of the common law in institutional arrangements in legal systems can be reviewed from the broader perspective of the Commonwealth. Elsewhere in public law, there is renewed interest in studying the field from the perspective of the global south. And I think jurisdictions like India and Sri Lanka have much to offer in this regard. Secondly, I suggested that appreciating the constitutional context in which the common law exists in India and Sri Lanka is central to our understanding of the field. Through the example of the development of the right to equality jurisprudence and the public trust doctrine, I suggested that the ongoing process of constitutionalization of principles of administrative law in both jurisdictions has several implications for the common law. Third, and relatedly drawing from my own research, I drew your attention to the ways in which common law principles and constitutional interpretations in India are influencing the development of administrative law in Sri Lanka. I used that pattern to suggest that we think broadly and differently about the ways in which common law principles in administrative law evolve. I would like to just say that it's I think, necessary to perhaps think about what I have tried to describe as the indigenization of the common law. Fourth and finally, I use the right to information legislation in Sri Lanka to remind ourselves of the limits to a common law focused or court-centric focus to the study of administrative law. I'm always wary of the weight that we attach to the common law, because I'm mindful that we are, by doing so, we might perhaps be unnecessarily exaggerating the significance of the common law in when we think about administrative justice more broadly. So with that, I will end my remarks. I would like to thank the West Bengal National University of Juridical Sciences for this opportunity to engage with you on a topic which I think we have much to discuss from the perspective of our two jurisdictions. And I look forward to the discussion. Thank you.
Thank you so much, ma'am. If any attendees have any questions, you can take that up.
Thank you, Dr. Dinesha, for your informative session. Since you have worked with respect to public trust doctrine, how would you think about public trust doctrine can improve the administrative aspects?
I didn't catch the last part of your question, Dr. Marka.
This public trust doctrine, which imposes stewardship with respect to the governing agencies.
Yeah, so that's a good question. Also a question that requires some discussion about what we understand by stewardship. If you look at the private law, the English common law and the private law, we have the idea of trusts, which bring in this idea of trusteeship, that even in the law, we might recognize that while legal ownership lies with one party, the benefit of that ownership should accrue to another. Now, when we think beyond private legal relationships and look at the relationship between the state and the world at large, the significance of this idea of trusteeship is much more serious. And if you think about the moment in which we are living in today, we are living through a pandemic, and if we hadn't realized before about the importance of public health and the trusteeship role of the state with regards to public health, it is apparent to all of us today, right? We are living through the experience of that realization. So all this to say, Dr. Chengappa, that in Sri Lanka, the courts, I think, have taken on that task of interpreting what it means for the state to be a trustee. And in the Eppavala case of 2001, the court went one step further and said, look, steward, it's not only trusteeship, it's also stewardship, and that's the word you use. And stewardship is not only between the state and its people, but it could also be between two individual parties. And the court develops this idea in the context of natural resources and in relation to sustainable development. And I think that was a very progressive development that we could see in Sri Lanka long before the UN introduced sustainable development as a global standard. We had this small court in Sri Lanka recognized that trusteeship and sustainability were important aspects of the nature of the state. Of course, the court relied on the directive principles of state policy as well, but over time, what we can see is the thickening of this idea that the state is a trustee. And that would mean that there is a qualitative dimension to the responsibility of the state. And then for our purposes, what it has meant is that the judiciary will interpret the common law within the constitutional framework to uphold those responsibilities of the state as trustee or steward.
Thank you.
If anyone else has any questions, if not, I think then we can move to the next session. I would like to thank Dinesha ma'am for her insightful views and giving the coherence between Indian and Sri Lankan administrative view. And I think it has given food for thought to many attendees to, create like some contrast between the administrative law of two jurisdictions. Thank you so much, ma'am. And for the next session, I would like to call Pallavi Mishra, who will take us to the attendee, the speakers for the next session. Thank you so much.
Good afternoon, everyone. It's a pleasure to have you all here. I am Pallavi Mishra, your moderator for the session. This is the third session of the conclave, on which we are going to have the discussion on dynamics of common law principles and its application by the judiciary. We have two administrative law experts as speakers, and this session will last for 45 minutes. The audience is supposed to post their questions in the comment box, and I will take it accordingly. And please keep your audio muted. So now, without wasting any further time, let me introduce you to our first speaker. Our first speaker is a renowned name in the field of constitutional, administrative, and election laws. He has been actively contributing towards a more just and rule of law abiding society. He is an advocate in the Supreme Court of Bangladesh, practicing in the areas of constitutional laws, administrative laws, and election laws. His work also encompasses academia and policy. He has been widely published in the areas of constitutional law, criminal law and history, and international law. He completed his LLM from the Patris Labamba University in Moscow, a second LLM from the University of Pennsylvania, and he also holds his PhD from the London University. It is a matter of prestige to have you here, sir. Please welcome Dr. Shadeen Malik. Dr. Malik, do we have you here?
Hi, I'm trying to get him connected, but I'm just going to. Can we just pause to one thing? Just let me just check where he is. I think he's having difficulty connecting. Just give me 1 second. So sorry about that. I have just made sure that he's coming online in a second. But our presentation is going to be in 2 parts, and I am going to actually do the first part, and then Dr. Malik is going to do the second part.
Okay.
So he's actually just connected. So Dr. Malik, I think you've just missed your introduction, but here he is. So I will let you kind of say hello to everybody, and then I'll do the first part of the presentation.
Good afternoon, sir. So you've missed the introduction, so I would like to do that all over again. So everyone, this is our first speaker, Dr. Shadeen Malik. So he's an advocate in the Supreme Court of Bangladesh. He practices in the areas of constitutional laws, administrative laws, and election laws, and his work also encompasses academia and policy. He has been widely published in the areas of constitutional law, criminal law and history, and international law. He has completed his LLM from the Patris Labamba University in Moscow, a second LLM from the University of Pennsylvania, and he holds his PhD from the London University. It is a matter of prestige to have you here, sir. You may please begin your session.
So I will be doing the first part of the presentation, and then Sir will conclude. So I just wanted to quickly say, first of all,
just let me introduce you first then.
Okay, sure.
Okay. So now as the positions have been changed, our first speaker is Dr. Cynthia Farid. She is also an advocate in the Supreme Court of Bangladesh. Her research areas focus on legal history, law and development, and constitutional law. She was previously a research consultant at the Overseas Development Institute and also a justice project consultant with the UND. She completed her LLB from the University of Hull, LLM from the Cornell University, and she holds her PhD from the University of Wisconsin-Madison, and also bar at law from the Gray's in London. It's a privilege to have you here, ma'am. You may please begin.
So yes, as I was saying, thank you and good afternoon, everyone. I've been listening into the conversations this morning, which were very rich and interesting. So I especially thank Professor Chingappa, who I had previously met at another conference a couple of years ago. So thank you so much for inviting me. So for our presentations, we will be primarily discussing the trajectory of common law principles within administrative law in the case of Bangladesh. But I will sort of begin by settling the historical background, and then Dr. Malik, who is in every way an expert in this area, will be elaborating on some of these developments in Bangladesh. So the transfer of principles of English administrative law in South Asia, as some of us heard this morning as well, is deeply connected to sort of its long history, colonial history in particular, so which has further developed through the adaptation and innovations under post-colonial political and legal arrangements. So we heard Justice Sen this morning, who had very eloquently elaborated on the legal and historical evolution of administrative law, not just across colonial times, but also pre-colonial times. So my intervention in legal history will be much more humble in comparison to his. My point of departure is basically that the administrative apparatus in the region matured and consolidated prior to adoption of constitutions. And similarly, if we look across administrative jurisprudence, there's a significant focus on the role of courts in settling administrative jurisprudence. Now, this is markedly different from Euro-American approaches that look to sort of administrative agencies and or quasi-judicial institutions much more than courts. So just to kind of go back to history a little bit, the introduction of high courts in 1861 with sort of geographically limited power to issue writs and supervisory authority over lower courts consolidated then prevailing administrative law in British India. The operation of English legal principles under colonial conditions did actually pose difficulties for the exercise of reasonably autonomous judicial power. Interbranch tensions between the judiciary and the executive, which was already prevalent before direct British rule in 1858, intensified further after 1861, and particularly with the professionalization of the bureaucracy and also increasing agency of Indian lawyers in the legal profession. What we then further see is that between 1861 to 1935, significant constitutional reforms had progressively strengthened the independence of courts in British India in response to Indian agitation and other political pressures. So in addition to to efforts that were directly trying to apply English legal principles, that objective would often be at odds with the larger colonial project, right? So it would force departure from English procedure in ways that suited the objectives of the colonial government. So Queen versus Pura and kind of the advent of secondary legislation and delegated legislation is a case in point. I think at the time, even the Calcutta High Court in its first decision basically surmised that it would have been decided very differently had it been decided in Britain. So with the expansion and consolidation of the colonial state, Indian high courts were actually attempting to settle administrative matters by assuming jurisdiction and exercising powers of review. Common law doctrines featured quite prominently in cases that facilitated institutional consolidation and accountability of public officials. So there were further sort of innovations. I'm sure all of you have heard of justice, equity, and good conscience, which allowed for somewhat creative interpretations and expansion of judicial sort of power in areas where perhaps codified law wouldn't allow that sort of expansion. So in British India, what we see by the sort of 1920s is that there's a distinctive jurisprudence, particularly to do with administrative law, that began to develop in British India within the imperial constitutional framework. So in this context, I want to discuss two scholarly contributions of the early 20th century as examples, and also particularly because we are sort of, even if it's virtual, we are operating out of West Bengal. So these are the two Tagore Law lectures of 1917 and 1919, both of which were titled Comparative Administrative Law. And these lectures were actually conducted by two Calcutta High Court lawyers, Dwarkanath Mittar and Nagendranath Ghosh. Both sets of these lectures emphasized a strong role for the courts. Mittar's account refused to draw a rigid line between administrative law and constitutional law due to their many points of overlap. By his account, the difficulty of threading the maze of administrative statutes in England is mitigated or was mitigated by the continuity of administrative traditions, whereas in India, there was no similar continuity. Mittar attributed the lack of administrative tradition in India to practical matters of governance. So, for instance, civil servants and key officials, such as, for example, the law member of the council, responsible for advising the Governor General and Council, there was a high rate of turnover as they pursued career ambitions within a limited term and often had very little knowledge of Indian administration. So Mittar presented a paradox within Indian governance. He stated that no government is better provided than the government of India with an administrative machinery by which extreme dangers may be faced by extraordinary remedies. Yet, let these not lead anyone to suppose that the rule or supremacy of law does not obtain in India as it does in England. He further stated that in India, one is struck by the extraordinary respect for legality which animates the government of India. Mittar also seems to be cautious of the respect for law easily degenerating into rigid legalism. But it relies on the extension of judicial power combined with institutional autonomy, which sets at naught the dogma of separation of powers. So we can see that courts played an important role in making officials accountable for their conduct. And Mittar attributes this role of the court to have earned both reverence for the bench and also popular confidence, right? So this is a conversation that's happening in 1970. So Nagendranath Ghosh, who was also a barrister, he gave the second lecture in 1919. His corpus of work not only covered aspects of administrative regulation in India, but also comparative administrative laws extending beyond the confines of Euro-America to places as far away as New Zealand. So the comparative exercise entailed testing principles of administrative law under colonial conditions in India. The breadth of this book, of this undertaking, was so impressive that it reportedly caused Justice Felix Frankfurter of the United States to recommend it as one of the most helpful books in English on comparative administrative law. Now, this is instructive for two reasons. First, what we can see is that American reformers, looking beyond Europe, suggested an east to west circulation of ideas of administrative law. Secondly, while the West was preoccupied with debates between scholars such as Dicey and Goodnow, Indian jurists actually had a thorough appreciation of the nature and requirements of the Leviathan that was the colonial state. So in correspondence and letters between Nagendranath Ghosh and Ernest Freund, who was then chair of the Commonwealth Fund's Administrative Law Project, Ghosh responded to he was given a gift of a book by Gerard Henderson, the Federal Trade Commission. So this book was published in 1924. So Ghosh was gifted this book by Ernest Freund, and Ghosh pointed out in response to a letter to Ernest Freund that he pointed out the unsuitability of independent commissions to Indian conditions. He said, the transference of judicial powers from courts of law to quasi-judicial administrative authorities has not been taking place in such rapid strides as in India as your own country. In India, the discretionary authority possessed by the executive was so much more absolute than in the United States that it was unlikely to be exercised in a judicial spirit. Expositions of the various ways in which absolute discretionary authority could be tempered through courts lay at the heart of these two lectures. These lectures reveal historical legacies in modern administrative law. Anxieties about checking absolute power continues in the post-colony, where courts are constitutionally envisaged to have a central role. So now kind of jumping through time and sort of coming to Bangladesh, it's a case where the Supreme Court plays a central role in the shaping of administrative law. Its two major political ruptures during the partition of India and Pakistan in 1947 and independence from Pakistan in 1971 makes for a complicated case. and complicated case study. As the eastern wing of Pakistan, and given the expansion of economic plans and against the background of military rule in the first few decades of East Pakistan, the courts had to contend with significant expansion of legislation, and at the same time, their powers were curtailed. Thus, the beginning of this oscillating power of the judiciary had already begun even before the creation of Bangladesh. And also the courts were motivated by the need to claw back judicial territory from the executive. And this kind of oscillation continues in Bangladesh. I think Dr. Malik can expand more on this. So I'm going to hand it over to you, Dr. Malik. Thank you. You're muted. We can't hear you. I think he's just trying to figure out the device.
Yes,
with him a second.
Sorry, can you hear me now?
Yes, sir.
Oh, sorry for the glitch. I wish Cynthia had talked longer, so I wouldn't have to speak much. I'm feeling really unfortunate that I could not attend the first session. See, my problem is, if I agree with other speakers and my clients were present, they would not hire me second time. Sort of by practicing lawyer, I had to acquire this skill of good or bad, not agreeing. My other limitation is that for last quite a few years now, since my primary engagement is as a lawyer, the disadvantage of which is that we're always busy with tree, in the sense that the case in hand, and we lose sight of the forest, the larger issues. The whole idea of finding a coherence in any field of law is almost anathema to a practicing lawyer. Yes, I mean, laws are settled in many issues and instances, but mostly our task is to unsettle the settled law. Because if I agree with the settled law, maybe I can hardly offer any relief to my clients, and clients don't come where the law is absolutely settled. We have to find a gray area to establish my clients or our clients as a lawyer claim. So even if the law is settled, we always try to unsettle it to the advantage of clients, obviously through proper ethical and legal arguments. The idea of sort of the constitutionalizing administrative law and sort of borrowing common law principles. At the theoretical level, I'm uncomfortable with the whole notion, though I know this is very dominant sort of strand in the academia. And what Cynthia had just mentioned, this idea of introduction of this concept of equity, justice, and good conscience in late 18th century India, sort of the first tool. I think that was the most powerful colonial tool of dominance, that our laws does not correspond and respond to justice, good conscience, and equity. And we had to be taught how our law principles should conform to these ideas. And this project, I think, is still has a great sway over our discourse about law. And again, the whole idea of that how we are borrowing common law, how we are being shaped by common law. And we see that as a good thing. And I'm not always comfortable with these ideas. There are a lot of reasons. My sort of maybe wrong understanding of development of law in a broader scale. Okay, I'll make a sweeping statement, which I'm sure most of you will not agree. Of all areas of law, the two broadly in broad brush, last 200 years, the law which emerged as completely different from 18th century, the beginning of 19th century, is the criminal law. I'm thinking in terms of property law, contract, and all other civil law transactions. They have gradually evolved, but they did not make a clean break with the past law. We still rely on Roman law. Globally. So criminal law was a great break in the early 19th century, and our penal code is a very good example. And second area of law, which has a great break, is the constitutional law. And constitutional law basically started in 1950s, yes, barring one or two exceptions like America. The idea of constitutional law is very new for almost all the states, and I'm also thinking of Europe. States like Greece, Portugal, Italy, or sort of erstwhile East European country. For them also, this constitutional law is a very new area of law where we are trying to inject new ideas. Yes, we are in Bangladesh also, Supreme Court, we are borrowing certain, I would hesitate to say common law principles, because certain notions of right and wrong are universal. Obviously, we talk about judicial review, checks and balances on executive power, administrative power, and like other particularly neighboring countries. We see this as a gradual judicial review as a gradual process of reining in, as it were, the executive power. But most states, not only in our part of the world, as I said, Europe and others, the whole idea of putting certain brakes on the executive orders or executive decisions, and that has to be checked by someone else. As broadly, this is not a new idea, and this is not exclusively common law principle. There's certain inherent idea of right and wrong, fairness and arbitrariness, which we all abhor. And the path that a country or a judiciary of a country follows, I think we proceed often from the assumption that that should also be uniform, forgetting the peculiarities, the sort of the societal context. If we accept that we should all follow certain common law principles, then we have to me, it sounds like we take law as a societal. The administrative apparatus in England or America, and in comparison, as opposed to Bangladesh and in India or Pakistan or whatever, if we assume that we should follow their examples, then by implication, we are also assuming that laws are asocietal. So that gets to this larger debate of how far law is a product of the society and how far law should be universal. So for me, these are all disturbing issues. I'm thinking of these underlying presumptions that there should be certain check in certain context, society, state's role, even if it is arbitrary, maybe people are happy with that. I mean, sort of example of China comes in, I mean, in recent times, foremost to our mind. So what I'm trying to say that, yes, we do, I wouldn't say borrow or follow, but we may arrive at the similar conclusions that sort of quote unquote developed Western societies had 100 years ago. Yes, there may be certain coincidences. We may also arrive at similar principles and similar sort of guide or governing ethos, but that we have to follow that or we are influenced by that ignores the latest method of imperialism or neo-colonialism, that you guys are not following our principles and you are bad, and you would be good if you follow our principles because we are good and better. I don't want to fall into that trap. Again, as I said, I'm not totally ignoring that we should totally deviate and try to invent a new path. We obviously should all learn from each other's experience. But to systematize that experience and even suggest that we should follow the route the other countries have taken, I think it's taking it a bit too far. Last 10 years, just broad average, I've not really counted, but on my broad average, last 10 years, our parliament on the average have enacted about 50 laws every year. So varied, 40 in some year, 50, 60, 70, 10, but I think broad average is about 50. And of those, roughly out of the 50, every year 20 would be amending laws and 30 would be new laws. And compared to the last 40 years, I mean, Bangladesh 40 years, 71 to 2010, we hardly had what we call executive authorities, statutory organizations, regulatory bodies, laws created by the statute, which has certain executive power. So out of the 30 laws that our parliament enacts every year, roughly 20 would be creating this new statutory body with semi-state powers and who take a lot of administrative decisions. I'm thinking about sort of zoning authority, swearage authority, flight control, air aviation authority. So last 10 years for Bangladesh, last 10 years, we have started to create this legal structure of administrative state. It's practically last 10 years. Before that, I mean, the last 40 years before that, again, 71 to 2010, we had these statutes creating authorities, but I think they would average about 2, 3, 4, 5 a year. So there is a boom in the administrative creation of administrative apparatus or expansion of administrative apparatus, and which is also normal because state is now intruding in ever more number of areas. I mean, in America, they started with zoning laws, I don't know, more than 100 years ago. But we are at the very first phase of creating zoning laws. So anyway, the point I'm trying to make is that the legislative intervention for creating executive, semi-executive authorities with certain state powers and obviously powers to take decisions in their own area of operation is quite new. And broadly, exercise of power by these authorities are coming to court just very recently. I mean, we have had, say, some authority created 10 years ago, and there had not been any litigation about their exercise of powers. and then questioning that whether they are working or carrying out the function within the limits set out by law. So I think this, for us, it would be rather 10 or 20 years before we take these exercises of power by these sort of limited authorities, the limited sphere of operation. So we have our first environmental law, 1995, which created the Department of Environment. And we do have an environment code, but there's hardly any case in the environment code questioning the decision of the Department of Environment. I mean, allowing certain project, not allowing certain project on environmental grounds. So, and this is, I mean, I don't think Bangladesh is different, because this expansion of state power in countries like ours, India had been a state somewhat longer. So, I mean, you are about to sort of celebrate your 75 years. So much longer, but I mean, most other sort of countries of the South, these are new experiences. And how far we will follow the common law established principle? Yes, in certain matters we do. I mean, let's say about 10 years ago, the first legitimate expectation principle was used to ensure permanent jobs to persons who had worked in a project in semi-government organization for 10 years or 15 years, and then the project was shut down. So they finally came to the court saying that they had a legitimate expectation of taking as a permanent sort of government employee or permanent employee of that particular organization. And this legitimate expectation was first used in 10 years ago. And courts were quite liberal on sort of about giving judgment. Yes, these guys have worked for 5, 10, 15 years, and they are no longer eligible. So we had a lot of legitimate expectation-based employment issues decided in favor of employees until 2020. So sort of 2010 to, I'm just giving one example, 2010 to 2020, we had a heyday of legitimate expectation in employment matters. But in 2020, in two sort of lengthy judgments, the appellate division, the apex court, has come down heavily and practically sort of deleted the issue of legitimate expectations. The legitimate expectation is no ground for expecting a more permanent and sort of employment. So legitimate expectation in employment matters, we practiced that for 10 years, and then now it has sort of been thrown out of the window. So we are, because I mean, the point I suppose I'm trying to make in a very roundabout way is that the intrusion of state in our kind of state is a new phenomenon. Even banking laws are relatively, we hardly have any litigation. I mean, Bangladesh Bank or the sort of the Central Reserve Bank of India, they're issuing a lot of orders, and hardly banking sector people are unhappy, but they're hardly thinking of going to the court. So I think the limits of this understanding of administrative law would be tested more in next 10 years than they have been so far. And again, this is, I take that this is a normal sort of development phase or phenomena of every state which is expanding its, say, I mean, our sort of state budget, I don't know exactly the figure, but increased more than 20 times, I think, in last 10, 15 years. And compared to Western state, I mean, with intrusion of Western state into every sphere of life, it started much longer, centuries ago, particularly if you take America. And obviously now the sort of the quote unquote developed state or northern state has intruded into the citizen's life. I think I'm just saying it as just 100 times more. So how now I'm obviously basing my most experience in Bangladesh. Our state has just the first phase of intruding into every spheres of our life, and how we would react or how judiciary would react, how much control they would try to exert is a story yet to be written. But given the somewhat fragile state of judiciary now, because of larger political issue, larger state of democracy, at this stage, I mean, as a lawyer, we do talk about a lot of issues, and clients do come up, and I can clearly see that legally I have a good ground to challenge the sort of the administrative authority's decision. But we always hesitate because right now, last 5-7 years, we have on these matters, our confidence on the independence of judiciary has somewhat eroded. So obviously, again, every state goes through these phases. You have strong judiciary, weak judiciary. I mean, we are all aware of sort of Indian decisions of first Gopalan, I think, Keshavananda and Maneka Gandhi. So one can sort of term this as a weak phase of judiciary, strong phase of judiciary and all that. So, but I would be more comfortable trying to fashion our principles. Yes, when there is necessary, and it's much easier to argue a case when I can refer to British cases, and obviously we are all trained in British system, and we have grown up to think that the common law is the best legal system ever mankind has created and all that. So citing examples of higher British cases makes it easier. But again, I think our courts are also becoming reluctant since it is, in some cases, obviously they have, but they're also struggling with this idea of how much to borrow and how much not to borrow. So this is an evolving phase, and my take would be that if we place too much emphasis on being influenced by common law principles, we may expose ourselves or be willing victim of, I don't know, it sounds strong, and because I think it stems from my first sort of phase of education in 70s Soviet Union. But I cannot deny those influences. So it may be our pandering to new imperialism, and I would add some caution. And we should be proud of whatever good in our society we have, and emphasize that in our legal development. I think I've been a bit incoherent, but thank you for inviting. And thank you for giving me this opportunity to speak. Thank you. I'm grateful.
So before we wrap up the session, I have a question for you. Keeping in view what you just said, what reforms would you suggest?
I don't have a solution. I'm not an academic. Sorry. I'm trying to skirt that question. No, it's just, yes, Western principles are good, and obviously we learn. But I would urge a caution that we look at our society also more closely. What are our traditions, our practices? And because we are countries of the South doesn't mean that, these are the societies, most South Asia. We have been longer societies than most Western Europe. Sometimes when I get angry, I ask my Western friends, if I've been to sort of Europe all over, find me a code with the building says established. I'm sure it's quite common in sort of larger cities of India. Actual building, court building, main district court building, it says on the top, established in 80. And we are continuing in that same building, our judiciary, for 150 years. There are not too many Western countries who can claim the same sort of heritage. So we have a stable system. We have our good and bad. I just let's not taught bad part of our society take privilege, or we allowed to take that privilege that we don't have our own heritage, our good practices, and we have to borrow everything good from the West. Sorry, again, very confrontational response.
So can I interject and kind of add to your response a little bit? I wouldn't exactly say reform, but I think I think in the past the way administrative law had been taught, had been written about, the way academics would do it, I think was much more isolated and somewhat doctrinal. But I think that it's expanding. You are actually, you have historians studying administrative law. You have, it's beginning to be a lot more interdisciplinary. And I don't think it's just administrative law, but I think it's academia in South Asia itself, like legal academia. And I think that expansion is welcome. And it will probably produce different facets of how we study the law. So I think, a glimmer of hope in, we may perhaps find within academia and perhaps more interaction between academia and practice. So I'm just going to leave it there. Thank you.
Yes. On behalf of NUJS, let me sincerely thank Dr. Saeed Malik, the Senior Advocate, Supreme Court of Bangladesh, and my friend, Dr. Cynthia Farid, for having finding out time and sharing your innovative strategy. Dr. Malik rightly pointed out, time has come to innovate some traditional principles which meet Indian standard or Bangladesh standard. Rather than heavily relying the common law, the principles, the time has come to look into the principles. What are the gap? Whether those principles can find the solution to administrative issues, those things we need to look into it. See, for instance, some of the principles like the public participation with regard to decision-making process, wherein most of the conflict can be eased away, where people sit with the government authorities in order to overcome the problems. Yes, over to Pallavi.
Thank you, sir.
आपको कौन सा फोन है ये? OnePlus है?
Sorry for the disturbance, sir. So, Shadeen, sir, Cynthia, ma'am, thank you so much for joining this and taking time out of your busy schedule. It was a delight to have you here and listening to your wise words. Thank you so much for being here, sir, and ma'am. Now,
Thank you. Grateful.
Thank you.
Yeah, thank you very much.
Now, I would like to wrap up this session. And now, Shrijaya Singh, she will continue from here and she'll continue the next session.
Thank you so much, Pallavi. I see that you've given us 10 extra minutes, and thank you very much for that. Good afternoon, everybody. I am Shrijaya Singh, a student from the third year. Having listened to Dr. Malik and Dr. Farid on dynamics of common law principles and its application in the judiciary, we are now moving to the fourth session of the day on the administration of land acquisition in India. For this session, we are honored to have Dr. Namita Wahi with us to share her thoughts from her rich experience in the field of public policy in India. Ma'am, it is my proud privilege to welcome you today. Ma'am is currently a senior fellow at Center for Public Research, where she helms the Land Rights Initiative. She has pursued her BA LLB honors from National Law School of India, University, Bangalore, subsequent to which she pursued her LLM and Doctor of Juridical Sciences from the Harvard Law School, where she wrote her dissertation on the right of property and economic development in India. Ma'am has also worked as an associate at Davis, Polk and Wardwell, and she has also taught as a visiting professor at National Law School, Bangalore, and here at West Bengal National University of Juridical Sciences in the field of land rights. Today, Dr. Wahi would be speaking on the administrative law considerations surrounding land acquisition in India. And with her experience in this field and her vantage point from public policy, she is perhaps one of the most qualified persons to be speaking to us on this topic. So without delaying any further, I invite Dr. Wahi.
Good afternoon, everyone. Thank you, Srijaya, for that warm introduction. Thank you, Professor Chengappa, for organizing this conclave and for inviting me back to speak to your students and faculty about land acquisition in India. Can I share my screen to share slides? No, it doesn't work.
Ma'am, you should be able to see one of the options with a square with an arrow facing upward next to the raising hand icon.
Okay. Can you see my screen now?
Ma'am, we're not able to see it. Do you want to message it to me? I'll immediately open it in mine.
Okay, sure, because the share button seems to be grayed out. Can you share your email address, Srijaya?
Yes, ma'am. Should I send it? Should I send it to you on WhatsApp?
Yeah. Okay. So I've shared the slides with you. Okay.
Ma'am, it will just take me a minute. You could start. I'll be sharing it alongside.
Okay, sure. So the title of the presentation today was about the administration of land acquisition in India, but we cannot really talk about administration of the law about the law, especially in the context of land acquisition law that has undergone a drastic transformation after a very long period of time. And it would not be wrong to say that this transformation is ongoing actually, because we had the Land Acquisition Act of 1894, which was in force for a period of 120 years before it was repealed and replaced by a new law of land acquisition called the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. And it's been almost a decade since this law was enacted. But I would say that the process of transformation envisaged by this law is still ongoing because there has been a lot of contestation around the law itself. Can you share the slides, Srijaya? Yeah. Great, thank you. So then we are going to talk about the law and administration of land acquisition. Next slide. And the first question when we think about land acquisition is, why do we need a law of land acquisition in the first place? So we're going to talk about that. We're going to talk about the transformation within the law of land acquisition in India, the contentious provisions in the Land Acquisition Act of 1894. Why is it that we had to go through this dramatic change in this regime, and why is it that this regime is still not stable after the enactment of the new law? In particular, what were the changes instituted by the law, as well as the rules which are delegated legislation that were enacted pursuant to the law? And then I'm going to talk to you about a study that we did at the Land Rights Initiative, where we looked at all Supreme Court cases on land acquisition, a study of 1,269 Supreme Court cases from 1950 to 2016, so over a 66-year period, which we brought out in a report in 2017. And the changes that have happened in the 5 years, it's been a pretty momentous period for this law, even in the last 5 years. So I'm going to talk about that as well. Can we go on to the next slide? Yeah, the next slide. So as we know, land is an extremely important resource, an economic resource, and central to the livelihoods of 60% of all Indians. So over 600 million Indians today depend upon land for their livelihood. But land is not simply an economic resource. It is central to community identity, history, and culture. What we call land acquisition is essentially a power that the state in a liberal democratic society has as part of its sovereignty. It's called the eminent domain power of the state, which allows the state to forcibly acquire people's land. And because it is a forcible acquisition, therefore it is to be done only in accordance with the rule of law. And that's where the administration of land acquisition comes in, because the way land has to be acquired has to be very much in accordance with the letter of the law, with the rule of the law. And what does this rule of law requirement, not just in the Indian constitution, but also in countries all over the world? There are three main components to this rule of law requirement. The first is that there should be a validly enacted law, that this law, pursuant to this law, an acquisition must only be for a public purpose, because what is happening is that the state is taking away private land for a public purpose. If it were to take away private land for a private purpose, then it would not be acquisition at all. And then, it is a land grab, really. So for a valid land acquisition to take place, it must be for a public purpose, and it has to be upon payment of just compensation, because of the belief that no individual in a democratic society should have to disproportionately bear the burden of supporting the public good. So the idea behind the eminent domain power, which allows land acquisition, is very straightforward. It is that, of course, the state may need to take away people's lands for doing things for public purposes, but nobody should be disproportionately burdened, and the administration of this must be in accordance with the law, because otherwise it will amount to an arbitrary exercise of power. Next slide, please. So if you look at the trajectory of the law on land acquisition, first of all, there is no law of land acquisition. There are many, many laws of land acquisition. Srija, you can also make this in slideshow mode so that it's a little bit bigger. If you click on the button below where it shows slide share, just at the bottom, you see the icons at the bottom, the fourth icon, just click on that. It's the slideshow. Yes. Yes, so it's a little more easily visible now. So when we had the Land Acquisition Act of 1894, it was not the only law of land acquisition. There were many laws. This was the law within, the British the areas that were directly under British rule, but also the princely states had their own acquisition laws. And apart from the Land Acquisition Act of 1894, which provided for acquisitions generally for land, there was specialized laws for acquisition for particular purposes, like in coal-bearing areas and so on. In 1950, India goes through a dramatic transformation. We go from being a subject, a colonial state, to an independent democratic state. We adopt a constitution, which for the first time, after demands for rights amongst the citizens, first of all, we go from being subjects to citizens, and for the first time, people are given and guaranteed rights. The constitution, however, pretty much keeps the same distribution of powers between the federal government and the state government. And we see that across subjects. In the case of land, land was a state subject or a provincial subject under colonial rule. It remains a state subject. Acquisition and requisitioning of property was also a subject in the concurrent list in the Government of India Act of 1935, and it is continued to be as a subject in the concurrent list. So on land, nothing really changes with the adoption of the constitution. We may have gone overnight from being subjects to citizens for the first time being having rights, but not really much changed in 1950 with respect to the administration of land. And what we find is that there were about 100 central and state land acquisition laws, and also a lot of amendments to the Land Acquisition Act. This is something I realized when we were working on the land acquisition report. That you know, there are more than at least more than 100 laws of land acquisition across India, probably about 200 laws of land acquisition plus state amendments. So nothing really changes between 1950 to 2013. I mean, there are some amendments made to the Land Acquisition Act in the 1980s, certain important amendments, but insofar as the overall regime of land acquisition, nothing really changes. So say from 1894 to 2013, but you know, within that 120-year period, there is you know, a lot of time between 1950 to 2013. So like 63 years that, you know, really nothing much changes in the way we understand land. But then we go through a decade-long process of trying to make changes to this law, which starts with the introduction of two separate bills to amend this law in 2007. One is the Land Acquisition Amendment Act, and the other is the the Rehabilitation and Resettlement Act. Then it is decided that these two things have to be read together. You can't first acquire the land and wait for rehabilitation and resettlement to happen. So then it is passed as a consolidated law in 2013. It comes into force in January 2014. But soon after it comes into force, there's also a change in the government a few months after that. And there is, again, immediately an attempt to repeal this law. So the government, 6 months after the government comes into power, it tries to amend the law through an ordinance that they introduce in Parliament. The ordinance has to be re-promulgated twice because there isn't enough support to pass this amendment in Parliament, and this ordinance would eviscerate the law of its main content. Finally, the ordinance lapses and the government realizes it doesn't have the numbers in Parliament to pass this, and it basically says, because this is a concurrent list subject, it allows states to amend the law. Next slide, please. So I want to tell you about the Mapping Indian Land Laws project that we started in 2017. And as part of this project, so by the time we finished working on the land acquisition report, we realized that there are over 100 laws of land acquisition in India. But that also made us wonder how many total laws there are on land in India. And that's what led us to go with the Mapping Indian Land Laws project, where essentially for the first time ever, we've created a comprehensive repository of all officially authenticated land laws, all central land laws, and all laws from 8 states. And just that number, and of course the website, which is now live at landlawsofindia.org, it is a free website, so all of you should feel free to access it. We have categorized all laws from these 8 states and central laws, with about 500 laws across 31 major categories and 151 minor categories. Of these 31 major categories, there are 4 major categories in which most of the laws, which have the maximum number of laws, and no guesses and no surprises there. Land acquisition is one of those categories. And I can tell you that just under land acquisition, just the central laws and laws for 8 states, we have over 100 laws of land acquisition. So, this is a screenshot of the website, where we have essentially categorized acquisition of land, obviously, but within land also subcategorized based on the purpose for which land has been acquired. So whether it is for industry, for town planning, for whether it is acquisition of forests, whether it is acquisition of land for minerals, for infrastructure. A lot of land has been taken over for irrigation projects, and water has been taken, but water is on land, and land adjacent to the source have been taken, all of your dams and so on. Land has been taken also for rehabilitating people. It has been taken for creation of markets, for wastelands, and so on. So just to give you a sense that what I thought was the laws of land acquisition, there's actually beyond that, because one is to acquire the land in its entirety. The other is to acquire also specific rights of use with respect to land, which is how acquisition happens. This is not even understood as acquisition in the way we would understand our case law. Basically, like how urban areas are created. Essentially, if you look at the laws, you find that people are told that they cannot practice certain activities that they were practicing in that area. For example, stone quarrying, pottery, things like that. So insofar as you have deprived them of their ability to use the land for those particular purposes, you have also deprived them of their livelihoods, right? So you've not directly taken away their land, but this indirect process of acquisition is also happening, and there are a lot of laws of land acquisition. Next slide, please. But going back to the hero of our story, which is the Land Acquisition Act of 1894, which is the law under which most acquisitions happen. And just so that we know how draconian this law is, we should know that there is no such similar law in the United Kingdom, which, the British state had passed this law in India, but there is no sort of standalone law which allows the government in the UK, for example, to just take away people's land as a standalone thing. No, instead they have to do it on a case-by-case basis and make laws for those purposes. It can't be that just one law is there and all you need to do is to pass executive orders and you can do it. So the process of justification is a lot greater in the UK. It's not what they followed in their colonies. In the colonies, it was like the government asserted its powers in a much more extensive and draconian fashion than they did in their own country. So the new Land Acquisition Act is passed. The central government tries to amend the law, but it fails to do so. It tells the states to do it because this is a subject in the concurrent list. And what we see is that between 2015 and now, most of the states in India, about 7 of them have actually passed amendments to the law through state amendments. And others have actually done something which they are not permitted to do, which is to dilute the provisions of the law through delegated legislation. So as we know that we cannot alter the provisions of the Parent Act through delegated legislation, that's a basic principle of administrative law, right? But many of these states have actually done that. So next slide, please. So this map just shows you which all states have diluted the provisions of the Act. And you can see that pretty much everyone has. So what they could not achieve through the ordinance in 2015 for all of India, over a period of time, they managed, the government has managed to achieve this through states. And this desire to dilute the provisions of the law cuts across political lines. Basically, this was the 2013 Act for the first time was taking away some of the powers of the government, because the powers of the government were so extensive and draconian that they were completely incompatible with the provisions of a liberal democratic state and the rights of the people. But the government doesn't like to lose power. So what they've done is they have diluted the provisions of the RFCT LARR Act, which is a short name I'm going to use because the law has such a long name. It has done that for almost all of India. Next slide, please. But what this means is that, this is what they wanted to do. They could have done this in 2015. They couldn't do it in 2015. It took them much longer to do it, which meant that for a long time, the law was unstable. And nothing really was happening because they were not acquiring anything under the new law. So now, what are the changes that have been made under the new law and how are they important from an administration purpose? So the process of land acquisition under the 1894 Act was straightforward. The government under Section 4 had to notify that land is needed for a public purpose. Then the collector, who has been entrusted with the power of acquisition, would hold an inquiry into objections. People could bring objections that this land should not be acquired for, first of all, that this land should not be acquired. Second of all, that maybe this is not a public purpose, but whatever, this isn't a public purpose, this isn't feasible for the project that the land is being acquired, that there is alternative land available, don't take our land. These were the kinds of objections that persons interested could bring. The government was supposed to conduct an inquiry. And as we know, how administrative law mandates an inquiry to be held, the principles of natural justice have to be followed, right? So you have to give a hearing to the people. You have to hear them out. There has to be no arbitrariness. There has to be an application of the mind in the decision that is to be given. And whatever procedure has been outlined under the rules to the law, that has to be followed, right? So the government was supposed to complete its inquiry based on these administrative law principles and issue a final declaration that land is being acquired for a public purpose. The collector would then proceed with the acquisition, which would involve physically going and marking and measuring the land. The collector would then, so there are two inquiries. The first is whether the land should be acquired at all. The second inquiry would now start when the collector has in fact decided post the inquiry that land would be acquired, and the collector now would hold an inquiry about compensation claims to everyone who should be compensated and pass a final award of compensation and then apportion it between multiple claimants, because we know 60% of all Indians are dependent upon land for their livelihoods. We know under family law that amongst the Hindu community, we have the Hindu undivided family. Multiple claimants, even unborn children have a right, in the land, technically speaking. So there are multiple claimants with respect to the same land. And the compensation has to be apportioned between the claimants. Government then, after these two inquiries have been completed, government goes ahead and takes possession of the land. Then, so taking possession is the next step. Then it has to actually pay the compensation. One is to decide and give an award. The second is to actually do the act of paying. And once the compensation is paid, the procedure closes. However, there was also an urgency exception in the law, according to which the government could dispense with this procedure in situations of urgency, which is not defined in the law. Next slide, please. Now, what were the contentious provisions with respect to this procedure, this 6-part process? First of all, the people who could be compensated were not livelihood losers. Only title holders could bring claims as persons interested, as well as they could be compensated. Secondly, over a period of time, what we found was that there was a very inclusive definition of public purpose. It had been expanded under Chapter 7 of the Act to include acquisition for companies. But again, the idea was that even these acquisitions for companies, there should be a very clear public purpose, like the construction of a road or highway, the typical instance of land acquisition. But unfortunately, what was happening was that land was being acquired for many things where it was not entirely clear whether the communities living in those areas, or generally, whether even malls, for example, shopping malls, were held as important for public purpose. Thirdly, what was happening was that the government wasn't really paying market value compensation. So the law actually allowed the government to pay market value compensation. And it didn't say that the government only has to consider circle rates in the giving of the compensation. But typically, the government was only following circle rates. Circle rates are typically a lot lower than what the market value of the land is. It sometimes ranges from like half to 1/10 even of the value of the land. And so people were not getting a fair compensation. And we have to compensate because no one should disproportionately bear the burden of the public good. So moreover, it was a completely non-participatory procedure. I mean, it was not designed for a democratic state. It was designed for a colonial state, which was basically trying to get as much value out of the land and didn't really care about the people, right? So there was no consent, obviously. It's a forcible acquisition. It's meant to be a forcible acquisition. There were protracted delays and there was no accountability. In the process. And we know that, again, administrative law principle of laches and all are applicable in the sense that you can't delay beyond a reasonable amount of time. There was rampant misuse of the urgency clause. The government would merely say that there's an urgency. They would not justify that there was an urgency, and the courts were very differential. They would not expect the government to justify that there was an urgency. And of course, as we've talked about this, there were multiple laws of land acquisition with differential procedures. Sometimes the government would, in the same project, apply one law for a certain part of the project, like they would apply maybe the 1894 Act. And there's this case called T.N. Vajravelu Mudaliar from the 1950s, where essentially for the same project, the Madras government had applied the Madras law for part of the project, the central law for the other part of the project, and was paying different compensation. So, the complete arbitrariness, whereas we know that, there has to be, at least for the same project, we have to have, the same people cannot be treated unfairly. Article 14, people within the same class, there cannot be any discrimination, and administrative law principles deriving from that were being completely violated. Next slide, please.
Little open the window.
So this is what led to the enactment of the new Land Acquisition Act. And the idea behind this was that this came about due to a massive public movement on the ground to create a culture of justification as opposed to a draconian culture of authoritarianism. and to recognize a legal enforceable right of rehabilitation and resettlement. The previous law, it was possible for the collector to rehabilitate and resettlement, but he had no obligation to do so. So it was up to him or her to do it. So it was kind of ad hoc. If they wanted to rehabilitate, they could, but mostly they were not. And there was no way that you could force them to rehabilitate you. And also to conduct a social impact assessment and to create a legal obligation for doing so of the devastating consequences of land acquisition, and to identify all people affected by the acquisition and to give them a voice in the process of their displacement. Next slide, please. So it was to effectuate all of these that certain important changes were made by the new Land Acquisition Act. Section 3 broadened land losers, which is the term that is used in the 2013 Act, from simply land title holders to persons interested in the land, including livelihood losers, such as tenants and sharecroppers. Secondly, to redress the issue of an expansive listing of public purposes, it tried to provide a listing. And within that listing, with a view to narrow down the definition of public purpose, but this was again a very contentious provision in the drafting, and essentially they included a definition of infrastructure, which included things like sports and tourism, which were some of the contentious issues in the practice of land acquisition in the previous regime. So the eventual definition really didn't help in reducing or minimizing or restricting public purpose to what would be generally understood as public purposes. It retained provisions relating to calculation of market value, but it increased the compensation payable. So under the previous Land Acquisition Act, the government had to pay the value of the land, plus they would pay a 30% solatium payment. Solatium is a Latin word which means solace, and essentially it was an additional payment because nobody wants to sell their land, they're being forced to sell their land. What the new law does is that it increases this value to 100%. So that now you have to pay twice the value of average of registered sale deeds in urban areas. And because in rural areas, the prices are even lower and the dependence upon the land is even greater, it was 4 times in rural areas. It also introduced resettlement and rehabilitation awards, including the provision of housing units, land for land, developed land and employment or annuity awards. Next slide, please. Moreover, remember this was a forcible acquisition process where there was no people participation. So the new law introduced requirements of consent of affected families and persons interested in case of acquisition of land for public-private partnerships and companies. So remember, the very idea of eminent domain is that the state must have the power, because the state is our representative in a liberal democratic society, to sometimes acquire power forcibly. So you have certain powers, like you have the police powers. These are forcible powers, but they are exercised in the greater good. The problem with land acquisition, the way it was being practiced, was because land was being acquired for public-private partnerships, for companies, and it wasn't entirely clear what was the purpose for which the land is being acquired, how that is going to benefit the public good. Therefore, there was a lot of discontent and outrage. So there is still no requirement of consent when government itself is acquiring land, for example, for its own purposes. But there is now a requirement of consent of affected families and persons interested in the land in the case of public-private partnerships and companies. Further, the law introduced requirements for social impact assessment of the proposed acquisition, and in line with administrative law principles, there has to be a public hearing and there has to be an application of mind. There has to be a reasoned order as to why the land is being acquired, why, after the social impact assessment, they still decided to go ahead with the land acquisition. And there would be an environment impact assessment, which was already happening under the EIA notification. That would now be considered as part of the social impact assessment. So basically, this shows a mindset shift which has happened, because at the time of the EIA notification, they were only concerned about protecting the environment. Now they've realized that people who are living on the lands, are living in harmony with the environment. And communities are responsibly and sustainably taking care of the environment. So social impact assessment, environment impact assessment has to be a part of the social impact assessment, because many of these traditional communities, they actually, the environmental ecosystem of that region is sustaining their livelihood, right? So you cannot divorce the people from the environment. And that's why it has to be a part of the social impact assessment. So very progressive provisions have been introduced under the new law. Moreover, because of rampant misuse of the urgency clause, it limited invocation of the urgency clause to situations involving India's defense, national security, or for emergencies due to natural calamities, and these have to be approved by Parliament. So other than defense, national security, or emergencies due to natural calamities, everything else has to be approved by Parliament. Whereas, because what we see was what was happening was they would acquire land for anything like housing. They want to construct housing for economically weaker sections. They would say, we have to do it urgently, so we won't follow any of the procedure. Without any justification for like why was this urgent? Why were they sitting on this earlier, right? Like, there was no justification for that. So they've tried to limit the urgency clause. And this, please pay attention to this because this is the most contentious provision of the new law, which is that it retrospectively applied the new law to pending acquisitions under the old acquisition law if certain conditions are met. Now, Mr. Jairam Ramesh, who was the minister in the government under whose, he spearheaded this law through Parliament, like if you speak to the people who were behind this law, they would say that because it took so long for the law to come into force, like the two bills were introduced in 2007 and then in 2013. So what about the people whose lands were acquired during that period? They said we wanted to do justice to all of those people because it took us so much time to steer this law through Parliament. So we retrospectively applied this law. And we will go through section 24 in more detail, but essentially it applies to acquisitions within 5 years previous to the passing of the law, with this motivation in mind. However, as we know as lawyers, as an important principle of administrative law is that not only must the law be certain, but also it must apply prospectively. The government cannot come to me and say that I am making this law today, but yesterday you had I'm making this law today as per which you have to pay a tax of something. And, so even though, yes, you bought a house yesterday, I'm going to impose this property tax law to you retrospectively and make you pay tax, right? So usually we frown upon retrospective application of rules. But in this particular case, this was the government's justification for introducing retrospective application. Next slide, please. So now, the process, if we see the 8 points that we discussed, what is the new process under the 2013 Act read with the rules? So the central government notified rules in 2015 under the new Land Acquisition Act. And basically the points in red are the two additions to the process. So let's go over that 6-part process again. Remember, section 4, government notifies land is needed for a public purpose. Next point, section 6, collector holds an inquiry into objections raised by persons interested to public purpose, feasibility, and alternative land. So far, the procedure is the same. But now, before the collector can complete his or her inquiry based on persons' interest, and remember, persons interested has now been broadened to include livelihood losers. So not just title holders, but others can bring claims. Now the Administrator of Rehabilitation and Resettlement has to create a draft rehabilitation and resettlement plan based on the social impact assessment report. So that has to be conducted simultaneously, and the social impact assessment has to be conducted simultaneously based on only once the social impact assessment has been completed will the Administrator of Rehabilitation and Resettlement create a draft rehabilitation and resettlement plan, as well as the panchayat and government records to list the affected people, their infrastructure and land holdings, and the landless people. So really comprehensive map of who are going to be deprived if this process moves forward. Then the procedure is similar to the previous law. Upon completion of the inquiry, the government will issue a final declaration that land is now being acquired for public purpose. It is possible, however, that with the new provision that has been introduced, the new procedure, they may realize that, no, we can't rehabilitate and resettle these people. Maybe they'll realize the environment is going to be very adversely affected, and therefore we should not go ahead with this acquisition. But if after doing all of this work, they think that they do want to go ahead with this acquisition, then, the government will issue a final declaration. The collector will then proceed with the acquisition, marking and measuring the land. Again, this is similar to the earlier law. And then the second inquiry will begin. Remember, there are 2 inquiries here that have to comply with administrative law principles. Plus, now there is this additional requirement of the rehabilitation and resettlement and the social impact assessment. The second inquiry, if they do decide to go ahead with the acquisition, is to essentially conduct an inquiry on compensation claims. Remember, not just title holders, but all livelihood losers can bring compensation claims. So this is going to be a much more elaborate inquiry. People will have to show that they're losing their livelihood, and then they will pass a final award of compensation. Plus, this time they also have to pass rehabilitation and resettlement awards. And then those have to be apportioned between various claimants. After which, next step is that the government will take possession of the land, and then it must pay compensation to the claimants. Remember, there's a big gap between passing the award and actually in practice what we find is that the award of compensation may be passed, but the compensation has not been paid for like years, sometimes even a decade or more after the award has been made. And government can now dispense with the procedure under the urgency exception, but it's a very limited urgency exception. Next slide, please. In addition, what they have introduced again as a progressive provision, because much of the land was being acquired in scheduled areas, which are geographically demarcated areas under the 5th and 6th schedules of the Constitution. I hope that you have read about the 5th and 6th schedules. In another report of Land Rights Initiative, we have for the first time mapped how much land in India is in the scheduled areas. And I can tell you that 13% of India's geographical area is in the scheduled areas. So that's a lot of territory, right? And these provisions were specifically included in the Constitution itself because of the unique connection that Adivasi communities have with the land. And as a result of which, this law has for the first time recognized this and has mandated that as far as possible, no government should acquire land within the scheduled areas. And if such an acquisition has to be done after taking into requirement all of those procedures, the social impact assessment, all of that, it must be done only as a demonstrable last resort, which is a pretty high bar, right? Like no government shall acquire as far as possible. It has to be a demonstrable last resort. Demonstrable, you're administrative law students, so demonstrable means that you have to justify through reasoning, through application of mind. You have to demonstrate, right? So in case, after you have complied with all of these stringent conditions, in case land is acquired or alienated in the scheduled areas, prior consent of the concerned Gram Sabha or Panchayat or ADCs must be obtained. Remember, with respect to the general population, this requirement of consent is not there with respect to government acquisitions. It is only for public-private partnerships and for companies. But within the scheduled areas, the prior consent of the concerned Gram Sabha or Panchayat, or in the 6th schedule area, we don't have, we don't have Gram Sabhas or Panchayats like we do in the 5th schedule areas. We have ADCs, autonomous district councils, that has to be obtained in cases of land acquisition, including in all cases of urgency. So it's stricter both in the process of land acquisition, it's stricter even with respect to government, and it's stricter with respect to urgency exception as well. There's no urgency exception. You have to follow this procedure. You have to get consent. And the affected Adivasi families should be resettled preferably in the same scheduled area as a compact block to retain their ethnic, linguistic, and cultural identity. Plus, the government is required to provide free land for community and social gatherings. So remember, a stricter condition for rehabilitation and resettlement as well. You can't move them out of their area. And secondly, you have to provide them from your side land for their social and community gatherings. Next slide, please. So now, let's look at the practice and administration of land acquisition and why was it so contentious? Why was it leading to so many disputes? So as I mentioned, we looked at 1,269 Supreme Court cases between 1950 and 2016, all decided cases during this period. We found that the Land Acquisition Act, most of the litigation was with respect to the Land Acquisition Act of 1894. So, next slide, please. So, hopefully, the issues that we would have uncovered, we can see if the new law, which is replacing the 1894 Act, would address that. So the first thing that we saw was that if we did a decade-wise distribution of initiation of land acquisition proceedings, we found that the numbers keep going up actually, and it also the numbers keep going up between the 1950s and the 1980s. This is the initiation of land acquisition proceeding. That is Section 4 notification. From that time, how many cases that were initiated during these decades then led to disputes. So the numbers are constantly rising. The reason why they're falling in the 1990s onwards is because it will be clear from the next slide where I talk to you about the time it takes for a matter to be decided. Because remember, information is based on decided cases. And because the time period between the initiation of the land acquisition proceedings to then it creating a dispute, to then it going to court, and then it getting decided is so long, this number should also go up. It's just that these cases have not been decided yet. So the general point is that there is a general increase in the number of land acquisition proceedings that are leading to litigation and dispute. Next slide, please.
Harappa will go for food also.
So
somebody should be there in this.
Who is bringing land acquisition dispute? What is the government doing wrong in the administration of the law, which is why there is a dispute? Is there a problem with the law, or is there a problem with the administration of the law? So we can safely say that there is a big problem with the administration of the law. Because of all the disputes that we found, there are two major sets of disputes. One is that the government is not following the procedure for acquisition properly. So they're not challenging the legitimacy either of the law or of the land acquisition, but they're saying whatever the procedure for compensation has been given has not been followed. 2/3 of all cases, 63.4%, are about the procedure for compensation. The other group, which is 1/3 of the cases, they are saying that you have not even followed the basic procedural requirements of administrative law in all the 6 steps. So not just compensation, throughout the process. Now, within those who have challenged the procedural irregularities, again, it's not really about the law. There's only 5% of the people who've said that, okay, the law itself is unconstitutional or a provision of the law is unconstitutional. Most of them are actually saying, is that there are procedural irregularities in the process of acquisition, whether the notice has not been circulated properly, there are defects in the notice, the hearing was not conducted at all, or it was not conducted in accordance with the principles of natural justice. Then there are those who have questioned the legitimacy of the purposes for which land is being acquired. They're saying, you were supposed to acquire land for a public purpose, you have not acquired land for a public purpose. And then, of course, there are those who are saying you've invoked the urgency clause, but there seems to be no urgency in this matter. So why have you invoked it? Right? So there's no reasoned justification of invocation of the urgency clause. Next slide, please. And not only is it clear that the government is the challenges are coming because of irregularities in the administration of the law.
They have some credit courses.
It's also clear from the research that we did that the government is mostly losing.
That's why they are not able to come.
Which means that litigants, because litigants are winning, if we are to assume that, obviously there are instances, there are cases where there can be an error in judgment, there can be cases of bias and so on, but that's when we do a systemic study, a comprehensive study like this, we are able to account for these biases. And if it is the case that the government is mostly losing, I think it is safe to assume that the government is actually committing a lot of irregularities in the administration of land acquisition. So if you look at this table, this marks, for the compensation claims, as the previous slide showed, 2/3 of all reasons of irregularities for which people are going to court involve compensation. They are saying that the procedure outlined in the law for calculating compensation was not properly followed. As a result, I was paid less than what I deserved to have been paid. And the court seems to agree. So between the original compensation award, now please look at the red line, between the original compensation award to the reference court. The reference court is your civil court or your first level court that you will go to contest the compensation. The civil court is giving, in 86% of the cases, is going to enhance your compensation. And mostly what we found was that because the government is following the circle rates, when the law very clearly says you have to say market value compensation. Even the 1894 Act very clearly said even the 1894 Act very clearly said market value compensation. But because, they are still following the circle rate, which is grossly undervalued, so the reference court will look at the sale deeds and give a higher compensation. But the other thing about the government is that not only they're not necessarily following the law, but they also will not give up appealing. So they will go and appeal to the High Court if they have lost. So remember, if 86% of the cases they are winning, both parties can go. Sometimes even the parties who have got an enhancement of compensation, they may want a further enhancement of compensation. And of course, if the government is losing in 86% of the cases, they're also going in appeal. And what we find that even after that, even after they go in about 50%, there's a huge incentive to appeal, because in almost half of all cases, you're still likely to win and get more compensation. From the High Court to the Supreme Court, now hoping that the High Court has fixed all the irregularities, ideally we should not see any enhancement from High Court to Supreme Court, but even there, in 1/3 of the cases, you are likely to win. So generally, between what you got from the government and whichever level of court you ended up at, between original award to Supreme Court, there is, in almost 90% of the cases, you are going to get more compensation. And that is simply because of one very clear provision, which is saying that the government must pay market value compensation, but the government only follows circle rates in the payment of the compensation. Next slide, please. So we also looked at, now let's look at the second category of cases where they're not specifically challenging, or most of the cases actually involve a challenge to both things, but leave the compensation challenges aside. Let's look at the other kinds of procedural irregularities. We saw that only 5% of the cases, the statute itself was challenged as unconstitutional. The court found this, mostly the court does not have a problem with the law. The law is usually found to be constitutional. That's your green area. In 63% of the cases, the court finds the law to be constitutional. But see, it completely shifts when we take the challenge not to the law, but to the administration of the law. Because when you are challenging on the basis of procedural irregularities, and as I said, lack of notice, lack of public hearing, irregularities in the notice, defects in the notice, irregularities in public hearing, irregularities in no application of mind in the decision that has been given, classic administrative law challenges, those the government is likely to lose in almost 60% of the cases. Again, on public purpose, the government is likely to win. The court is very differential on public purpose. In 83% of the cases, the court has upheld public purpose. Next slide, please. Okay, so there were 1,269 cases, but we disaggregated the cases and they amounted to 13,884 individual petitions, because courts, both the High Court and the Supreme Court especially, will bunch together similar petitions on issues of fact and law. So actually, the numbers of cases that we have looked at are actually far greater than 1,269. It's actually 13,884 petitions. And what we then did was to try and disaggregate these petitions across purpose of land being acquired as well as the states from which the litigation is coming, so that we can get a deeper sense as to which states are doing better or worse on the administration of the law. Because now it's very clear to us that, most of the challenges are to the application of the law, not to the law itself. They are administrative law challenges, either with respect to the following the procedure on compensation or other procedural requirements. Next slide, please. So if you look at the purpose-wise distribution of judgments, the gray bar indicates cases where we did not have information from the judgment as to what was the purpose of acquisition. So leave those 30% of cases where we don't have the information, leave them aside. In the remaining 70% of the cases, the top 6 purpose categories, which constitute more than half of all cases that we looked that were decided by the Supreme Court. Planned development, which is a euphemism for urbanization, basically a lot of projects for urbanization, that is causing the maximum amount of litigation. Then we have housing, industry, highways, bridges and power, defense and educational institutions. These together, they constitute over 50% of all petitions, right? But very interestingly, see some of the other purposes like dams. Our Land Rights Initiative report on scheduled areas, which we published in 2018 after this report, we found that dams were predominantly concentrated within the scheduled areas. And, so the intensity of dams is highest, is about 2.5 times more in the scheduled areas as compared to non-scheduled areas. But we see very little litigation here, right? And also mining. We also found in the scheduled areas report that maximum amount of mining, about 90% of all mineral royalties are coming from the scheduled area states. Yet we are seeing very little litigation on dams and mining. Why is that? Well, the reason for that is that remember, this is litigation under the 1894 Act. Under the 1894 Act, only title holders can bring claims. And mostly communities who are living, like Adivasis in scheduled areas or other traditional communities, they do not have title to the land, which allows the government to actually displace them without them even having the right to go to court against that displacement. At least that was the regime under the old law. Now, of course, we talked about Section 42. But it took like so many years for this kind of protection to come in. Similarly, there's a lot of land acquired for forests, but because until the 2006 Forest Rights Act, people could not actually bring written documentation of claims that, they were living on the land for generations in the forest, but they did not have a forest patta. So they could not bring a dispute against the government if they were displaced. So we see very low numbers here. We see higher numbers where land is being acquired for urbanization, for industrial development, for infrastructure like highways, bridges, and towers, and of course for defense. Next slide, please. If you look at the state-wise distribution of number of petitions, then 6 states again are accounting for more than a majority of the litigation, and the states are Haryana, Uttar Pradesh, Karnataka, Punjab, Tamil Nadu, Delhi, and Gujarat, right? Now, state-wise, it doesn't tell us much, so we disaggregated this further into district-wise distribution. Next slide, please. Yes, although before that, on the state-wise, the interesting thing that comes out is that the blue bar here represents the compensation challenges, where people are going to court saying that you have not given us the right amount of compensation. The orange bar represents the other procedural challenges like notice, hearing, things like that. What we find is that Haryana is the highest in the compensation challenges, and so is Punjab. So Haryana, UP, and Punjab. Like if you look only at the blue bars, it's Haryana, UP, and Punjab, right? If you look at the orange bars, then it's UP, Karnataka, and Haryana is actually not that high in the other procedural irregularities. So what's going on here, right? Next slide, please. So it becomes clear when we look at the district-wise distribution. So Gautam Budh Nagar is actually the name for Noida. So Noida, so these are the 20 districts in India. So when we think about pan-India, the 6 states that we talked about, which have a majority of the litigation, but actually that litigation even within those states is coming only from certain districts. And only 20 districts in India are contributing to more than half of all land acquisition litigation. And what are these districts? It's Noida, Cuddalore, Mysore, Bathinda, Gurgaon, Faridabad. So look at Noida, Gurgaon, Faridabad, Ghaziabad. These are all within the NCR, the National Capital Region. So when it says UP, Haryana, Punjab, UP is basically all around Delhi, right? And the other are either state capitals. You see Jaipur, you see Chennai, or industrial hubs like Nagpur and Meerut and Amritsar. So basically wherever urbanization, industrial development, infrastructure, all of that is happening, that is where this litigation is coming from. But also, it's very easy for people who are losing these lands because the property value, so the government acquires land at a pittance because they're paying circle rates. But the moment you change the land use from agricultural land, say, to be used for industrial purposes, the value shoots up. And what is immediately obvious, because these people are still living there, right? They've got their compensation, but they're still living there. And suddenly they see that their land, which was taken from them at a pittance, really, they were paid at circle rate, is going at 20 times. And, it's being used for various office projects, for malls, for, everything, for roads, highways, bridges. Suddenly their land is so valuable, but they didn't get the value of their land. And they also want a share of the value because, as we discussed in the beginning, the whole point of the law of land acquisition is that no person has to disproportionately bear the burden of the public good. So that's why the litigation is coming up. Next slide, please. This just shows the distribution of geographical area litigated across the states. And we find that in places like Rajasthan, where there isn't a lot of individually owned land because there isn't a lot of fertile agricultural land, a lot of land is acquired under the litigation. Next slide, please. So then we now have the new act that was passed, and we also looked at litigation under the new act. So within 2014, the act comes into force. Within the 3 years of 14, 15, and 16, and 2017, a few months in 2017, nearly 900 petitions had been filed. Compare this with 13,884 petitions filed in the previous 66 years. So there's a lot of litigation happening. Why is this litigation happening? Next slide, please. Again, not surprising, the state-wise distribution of petition is again Delhi, UP, Karnataka, Haryana, Maharashtra. Again, if we disaggregate this, it would be those districts that we mentioned. Next slide, please. Yeah, so this was the state-wise distribution of petitions under the Land Acquisition Act. So pretty similar, where the new petitions are also coming from. Next slide, please. I think, yeah, next slide. This is the same. Yes. So now so this is a comparison of the litigation under, and you can see that, most of the districts are similar. So Delhi, Ghaziabad, Bangalore, which was also there in the previous slide, is there. But some other interesting, Gurgaon is there, Chennai is there, but some other interesting places like Rupnagar and Sonipat, which is also in Haryana, are now coming up for litigation under the new law. Next slide, please. And what we find is that all of this litigation is around Section 24. 97% of all of these petitions are in Section 24. Next slide, please. Now, what is Section 24 of the new law and why is it so contentious? Remember, this is the retrospective application provision. It says that the law applies retrospectively to acquisitions under the Land Acquisition Act. It outlines, 5 scenarios. The first is when, at the time the law comes into force, there has been no award of compensation made. Remember, there are 2 processes. First, the collector has to decide, conduct an inquiry that land is needed for a public purpose. Then they must go ahead with the compensation inquiry. So that second inquiry has not been completed by the time the act comes into force. They say that, basically land users are entitled to the processes under the new law. That means the social impact assessment, all of that. Everybody who needs to be compensated under the new law, which is far greater than the old law, that is the case. The second scenario is that an award of compensation has been made. That second inquiry has also been completed. Award has been made, but 5 years have passed and the government has not. Remember, there are 2 steps. First, there is one inquiry whether land must be acquired for public purpose. Second is the compensation inquiry. Only after that is completed can the government, take possession of the land, and it also must apportion the award between the claimants. So what they're saying, if you come to an award that, okay, I'm going to give this much compensation, but after that, nothing has happened in terms of taking physical possession of the land, then in that scenario, then acquisition proceedings will lapse. And you have to reinitiate the acquisition. And this was essentially to hold the government to account, because you cannot continue a process indefinitely where people are losing their lands, right? So under the 1894 Act, if you had followed each step in the way that it ought to be followed under administrative law, you should have completed this process in 5 years. And because you have not been able to complete it, you, the government, you need to justify, and because we are now forcing you to account for your administrative lapses, therefore we will ask you to reinitiate the acquisition proceeding. The third scenario is that the award has been made, but compensation has not been paid. So in this instance, it could be 3 possibilities. Either the award of compensation has been made, but physical possession has not been taken and compensation has not been paid. That's one scenario. Second scenario is that physical possession has been taken, but compensation has not been paid, right? And the third scenario is that compensation has been paid, but physical possession has not been taken. So these 2 blue points cover 3 possible scenarios, plus the 4th scenario that we discussed, that the award itself has not been made. And the final scenario, which has been the most contentious, which is that award has been made, but the government has just deposited this in the government treasury. It hasn't actually given compensation to the beneficiaries, either because the government hasn't done it or because a majority of the beneficiaries have, due to pending litigation or for some other protest, have not accepted the amount of compensation. then all beneficiaries, because what may have happened is some may have accepted, others have not accepted. If a majority have not accepted, then they will be entitled to compensation under the new law. Because remember, the new law is 100% solace. It's doubling the amount of compensation. It's giving compensation to a large number of people. So, you'll be given compensation under the new law. Next slide, please. Now, we talked about the fact that laws must be prospective in application, that is consistent with the internal morality of law, which mandates that laws should be of general application. Basically, the internal morality of law safeguards against arbitrariness, because the whole definitional meaning of a law is that it applies generally. It is certain. We know what it is. And for us to know what something is, it has to be prospective. I can't be expected to know that my actions in the past will be covered today. So to that extent, retrospective application is frowned upon. But the reason, the reason why the government decided to do it is because they had been talking about this issue. So it wasn't, and the person who's going to be disadvantaged is not the individual, but the government. And the government itself was bringing about a progressive law. But this is the interesting thing that we are seeing, is that the government is not a monolith, or it's a behemoth with many groups, and the certain progressive section wanted to bring about this law, and many people didn't want to bring this law. So even though they have passed this law, they made it retrospective, they actually don't, the government itself doesn't want it to continue. Next slide, please. So when we looked at the litigation under the new Land Acquisition Act, we found that 97%, as I already mentioned, is litigation under Section 24. Within that 97%, it's this blue thing, the figure in the third point, where acquisition has been made under the old law, and compensation has been awarded, in the sense the award has been made, but 5 years have passed and compensation has not been paid, right? That is the maximum number of cases. 76% of those cases fall under this category. The others, the 5 points we've also discussed. So this matter went up in litigation before the Supreme Court. Next slide, please. Now, also, just to get a sense of how the courts were deciding, again, people were winning. Everyone who was bringing those petitions before the High Court, because we were looking at Supreme Court decisions, it doesn't always have the decision of the High Court. Wherever cases, 50% of the cases where we did have the decision of the High Court, the blue is where they're invalidating the acquisition. So it was creating a panic amongst the government, because after the Section 24, people were going to court and winning, because government had been not following the procedure. And so this new law had empowered them. It had given them rights. And so they were going and they were winning these cases. At the Supreme Court level, 92% of all cases, they were winning, and acquisitions were being invalidated. Next slide, please. So this interpretation of Section 24, when it first went to the court in Pune Municipal Corporation, it was a 3-judge bench case. It centered around the definition of the word paid in Section 24(2) and money deposited in the accounts of beneficiaries in the proviso to Section 24(2). Now, in the Pune Municipal Corporation case, a 3-judge bench decision said that paid means that the compensation must actually be received by the beneficiaries. Therefore, if the government simply deposits the amount of compensation in its treasury, that's not paid. And if it's not paid, then the government must pay as per the new law, right? And however, in 2018, the Indore Development Authority, another 3-judge bench case, ruled Pune Municipal Corporation per incurium. Per incurium means that they felt that there was an erroneous interpretation. They were not bound by it. And the court said that deposit means deposit in treasury and not in the court. So basically, the law itself is clear that deposited in the accounts of beneficiaries, but in Indore Development Authority, a 3-judge bench of the Supreme Court said that deposit means deposit in government treasury. Like, these words in the law are meaningless. So now there are 2 conflicting 3-judge bench decisions. So in 2018, this matter was referred to a 5-judge constitutional bench decision. The judgment in this case was really important, because 97% of all Supreme Court decisions since the law was enacted are on Section 24. 76% of them, as we've discussed, turn precisely on the interpretation of this clause. The court referred this matter to a constitutional bench, and the decision was given in March 2020 in a a 5-judge case called Indore Development Authority versus Union of India. Next slide, please. Now, remember, what is Section 24? Now, in previous decisions of the Supreme Court in 2016, in Sukhbir Singh versus Delhi Development Authority, the court said that through Section 24, basically the legislature is telling the executive, you've got to get your house in order. You have to administer this law properly. If you do not do so, you will have to bear consequences. Simultaneously, there was also an appeal filed before the Gujarat High Court in Reliance Industries Limited versus Union of India, where Reliance Industries argued that Section 24 was unconstitutional. The Gujarat High Court read, because now everybody is panicking, and the biggest beneficiaries of land acquisition, in the sense that the biggest users of land through the land acquisition process, are government and companies. So Reliance argued that Section 24 was unconstitutional, but the Gujarat High Court said, no, it's constitutional, but it will not apply to land acquisition by companies, which goes against the entire logic of the new Land Acquisition Act. Right? Like the whole point of the new Land Acquisition Act, the RFCT-LARR Act, was to make land acquisition more difficult for companies and public-private partnerships. But here it said, no, it applies to government, but for acquisition for companies, we won't apply it, right? So this matter also went to the Supreme Court. It was supposed to come up for hearing in March 2020, but as to the best of my knowledge, it hasn't been heard and the case has not been decided. So we don't know how the Supreme Court, Section 24 is constitutional for now, but right now the High Court decision stands for Gujarat. Other High Courts and other states can decide differently, of course. Next slide, please. Now, what did the Honorable Supreme Court do in Indore Development Authority? They basically wrote a new Section 24. So they interpreted the provisions of Section 24 to now say that even though it was very clear that if an award of compensation has not been made on 1st January 2014, there will be a lapse of proceedings, they said no. Compensation has to be determined under the provisions of the new law, but there will be no lapse of proceedings. As regards the second point, in case the award has been passed within the window period of 5 years, this was an important issue, that if the matter has been held up because of litigation in court, then what happens? The court said we will exclude the period where the matter has been held up in court. And very, very strangely, they basically changed the word or in Section 24.2. Remember, Section 24.2 said that if land has been acquired for acquisition, but compensation has not been paid, or physical possession has not been taken, or both of them have not happened, they said, no, it means and, or means and. So only if possession has not been taken and compensation has not been paid will this provision apply. They then went on to say that the expression paid in the main part of Section 24.2 does not include a deposit of compensation. They overruled Pune Municipal Corporation, and they said that, essentially, even if the government deposits the amount of compensation in the government treasury, that's okay. And they further went on to say that the mode of taking possession is the drawing of an inquest report, a memorandum. Again, completely rewriting Section 24, physical possession is not required, even though the section actually says physical possession, right? And then in Section 24.2, it does not give rise to a new cause of action to question the legality of concluded proceedings of land acquisition. So also a case where people had brought up the Raisina Hills case 50 years ago, the land was acquired, they were reopening that. They said you can't reopen that. Next slide. So, yeah. So this is where we are right now. We are between 2007, actually between 2000, actually it took many years even to get those bills to. For 20 years, we've been trying to change this law, and we've been in this unstable environment where first it took a long time to change this law, then the law did certain things, and between 2014 when the law came into force and now till 2020, for 6 years, we were still trying to figure out what this law would mean. We were diluting it. We were changing the interpretation when we couldn't do it. What we couldn't do through Parliament, we did it through state amendments. What we couldn't do in state amendments, we did it through dilution, through delegated legislation. And what we couldn't do with all of that, we then did it through the Supreme Court, right? So essentially now we've pretty much gone back on because most of these dilutions that we haven't discussed in great detail, most of them basically followed what the ordinance had done, which was that to do away with consent and do away with social impact assessment, and to exclude a huge number of projects where land is to be acquired by the government, infrastructure projects and so on, industrial corridors, things like that. Basically, the new law has now been rendered pretty much without the content, it's been really eviscerated of its core content. So we've gone from 2007 trying to bring about this transformation to 2020, where we are back to pretty much square one. Not entirely, but pretty much square one. Now, why did we go through that process from 2000 to 2013? Because we were trying to redress a huge imbalance of power, which must not exist in this way in a democratic society. Because the older law was a colonial law, and this was trying to but this was a law which was more suitable for a democratic state, because it was trying to expand the category of claimants from title holders to livelihood losers, to bring compensation provisions in accordance with current realities, introduce rehabilitation and resettlement as a legal entitlement, and introduce provisions for consent and social impact assessment, right? Next slide, please. Now, what our work has shown is that the vast majority of legal disputes are due to administrative non-compliance with the existing procedures. Even the new law would not have been enough if the government were not to also bring about administrative reforms, including greater transparency and accountability to act in accordance with the law, and administrative and bureaucratic capacity building, including skills training. If the government wanted to apply this law, the government didn't even want to apply this law. So, even the changes in the new laws have all been done away with. So even if the government had wanted to comply with this law, it needed to further do a series of administrative reforms. But now, of course, we are in a situation where the government doesn't even want to apply this law, and we are now pretty much back to square one. But if the government at a future point of time does want to actually bring about and redress this imbalance of power, then apart from these administrative reforms, they must also improve land records. They must work to remove title disputes and record property rights of livelihood losers in the government records. And there has to be a much more accurate price reporting in circle rates and in the registration of sale transactions. Now, these are some issues that the government is working on. Next slide, please.
Evening, we can have coffee.
Now, what has happened is that following the five-judge bench decision in Indore Development Authority, the vast majority of land losers under pending acquisitions will now lose their ability to file claims. We may still see some continued litigation as people may try to take benefit of the provisions of the law on a case-by-case basis, but the court has basically squashed the possibility of litigation under the new law. And has taken the government stance on everything. In fact, gone even way beyond perhaps what the government was arguing in court to assist the government in its interpretation. But this has obviously caused outrage again. So in September 2020, former Chief Justice Bobde mentioned that many questions have not been answered by the Constitution Bench and will require revisiting. So even 6 years after, we have been changing the law and we still may require changes in the law. Now, litigation means essentially rights and enforcement of rights, especially where a government doesn't follow administrative processes. This is not just limited to land acquisition. We see this in criminal law. We are seeing this in misuse of administrative processes across the board, right? Litigation is not maybe inefficient, yes, because it is delayed, etc., but it is not necessarily iniquitous. However, we have to note that most of the litigation is urban area centered due to geographical and financial access to courts. We saw that most of the litigation was coming from 20 urban districts. And we are not seeing litigation in rural or scheduled areas, even though there is substantial land acquisition. And that's because of both reasons, both the financial and geographical access to courts, but also because these people didn't have the rights. Maybe 20 years down the line with the Forest Rights Act, you will see litigation on behalf of forest dwellers and Adivasi communities. So litigation in itself is not necessarily a bad thing, especially when the administration is not complying with the rule of law. Land acquisition has been and shall remain a highly contentious issue, threatening economic development and political stability until we are able to sufficiently come to a consensus that we are not constantly in this process of back and forth. Do we want to redress the imbalance of power between the state and the people? And if we are agreed on doing that, then we can do it through a stable law and ensure compliance with the rule of law. So I'll stop there. I think there were some questions in the chat. Maybe we can take a few.
Yes, ma'am. Ma'am, I think we can quickly take a few questions in 5 minutes.
Yes. Can you read the questions? I'm unable to see them actually. Yeah.
Yes, ma'am, sure. Ma'am, one question is that in a previous session, Advocate Malik had mentioned that there is no solution to this, and he said that he's not an academician. Since you are one, he asks whether it's high time to provide access to law practice to academicians to enrich the legal system, and if there is a serious lack in India regarding this aspect due to Advocates Act, etc.
Sorry, access to law practice, you mean to academicians to enrich the legal system?
Ma'am, so
Sorry, I'm not sure I understand the question.
Ma'am, actually, I think it's in reference to how professors cannot litigate.
Oh, right. Well, I think that I don't think that you actually have to be in court. I mean, in the Indore Development Authority matter, I both sides actually reached out for assistance. The government had cited our report before the Supreme Court in support of their claim, so the other side had reached out for assistance, and I did help them with research and advice. So I don't think that you necessarily, I'm also not teaching at a university, so I can actually go to court, but you don't necessarily physically have to be in court. You can advise on, and I do that in many legal matters with the work that we are doing without actually being in court. So I don't think, I mean, that's a separate question as to whether we need an amendment to the Advocates Act. I don't think that that is within the scope of this session.
Ma'am, if you allow, we could take one last question from Astharat. She is asked whether there have been instances where upon the receipt of collector's inquiry report that enumerated ample negative impacts that the concerned land acquisition project was actually abandoned, or is this procedure treated as a mere formality?
Thank you, Asta. That's a great question. And I'm not sure that there is a clear answer to that because, as I've tried to explain to you, that over the last 6 years, the government has been trying its best not to follow this law. So this law wasn't, I mean, I didn't even know of a single instance where this law had even been applied up until like 2 years ago, 2 or 3 years ago. And there was one acquisition that was going on in Delhi where they were following this procedure, but the procedure itself takes a certain amount of time. So the answer to this is that we don't know, but as to the best of my knowledge, basically the government entire effort was to not follow this law, but to bring it back to the old law through all the amendments and dilutions. So now we may see things being followed, but the dilution is that they have done away with the consent in SIA. So not only is it the fact that the project is likely to be abandoned if this SIA, now there is no need to do an SIA for many of these projects. There was one acquisition that was happening in Delhi, which, after the Delhi government had notified rules, where they did conduct a social impact assessment. To the best of my knowledge, the process has not been concluded yet. So I cannot say if the project is been abandoned or will be abandoned in the future, but it certainly hasn't been abandoned right now. So, yeah. I think judging by what we are seeing, if the government has no intention to actually really go ahead with this change, and we are seeing this across the board, right? We saw the map. 20 states is not even across political lines because these states are ruled by different political parties. The government is united in its, in its agenda that they do not want to give up the powers that they have enjoyed for the last 130 years almost. The new law was a progressive law that was trying to redress the imbalance of power, but the government has fought back, and it has fought back in every mechanism possible. Like I said, through parliament, through state legislatures, through delegated legislation, and through the Supreme Court. So for now, I don't see a lot of hope for progressive conduct of social impact proceedings and the related positive provisions of the new law.
Right, ma'am. Thank you so much for this extremely insightful session and sparing your valuable time on a weekend. I also thank the audience and everybody who raised questions. And now, as per the schedule, we would be moving for a lunch break until 2:45 p.m. Thank you, everybody. Thank you, ma'am.
Thank you, Shrija. Thank you, everyone. Bye-bye.
in Delhi where they were following this procedure, but the procedure is
Oh, you got it.
so sweet of you. I could have gone down.
Bring the water. You don't have something to eat? So we had lunch. Oh, you had lunch? Yes. Thank you.
Yes. What happened?
Is it frozen?
Just see.
The conference is not. I think, sir, now it's a break, sir. Half an hour break.
Just Dr. Wahi just finished. I think you're on the lunch break now.
Yes, sir. Lunch
Correct,
break.
correct.
Everybody is not.
Could not deliver water.
Okay. Device calling. Doctor. Do you need an extension or something?
I think this should work good enough.
Yes, if you need extension, then hello.
Shall I give password?
Yeah, that also will work.
Yeah.
I just remove the system.
So how to remove? I think flower 1, 2, 3, 4.
1 second. Just let it catch. Room number 107.
Yeah. Flower. Just type it. Flower 1, 2, 3, 4.
All small? 1, 2, 3, 4.
Yeah.
Should.
I think.
Yeah, it is. Thank you so much.
Take.
Thank you.
Have
What about you, sir?
I just add very light food.
Okay.
Anyway, you please have.
Thank you so much.
I think next week onwards everything will be opening.
So, Mr. Chatterjee will be coming here.
Yeah, he will be coming.
So, he's also presently based out of Kolkata only.
He's in, I think, Delhi.
Delhi. So, he's coming down for that.
Yeah. No, he is coming to Kolkata.
Okay.
I think he said he won't carry the laptop, all those stuff. Then I said you can come anywhere here.
Easy actually. So what's the present occupancy of the hostel and all, sir?
Occupancy around 150 students have arrived.
Oh.
Another 1 week, almost all it's full.
So physical class.
Shall I add one more dosa?
I'm good, sir. It's good. Daytime it's better to have.
Okay.
That's fine. You sure you don't want to?
No.
So Dr. Achita, she's gone to chamber or she's
No,
at home?
she came back.
Oh. No, because she was saying no, different days she has different.
Yes.
At least you are lucky that way. You won't have to come. How are things at home?
Yeah.
In Kurk?
Good.
Did you go for the Harvest Festival?
No.
It happened, I think, two months back.
2 months.
2 months.
Looking at camera, total strain, right? So much headache. Continuously when we watch.
Oh yes, absolutely. Your message saying that he will come, I thought I will also come. It is best to be here and
correct.
So
I really liked your morning question.
So
the series of the Supreme Court, R. Gandhi versus Union of India, Madras Bar Association.
And there's several Madras Bar Association.
Yeah. From the Madras High Court to Supreme Court. Then, see, few more cases also had to come. NGT also they challenged it because High Court has no original jurisdiction.
Correct.
Because of that, some recruitment happened, press interview happened, but still, if you look at consumer, the bodies, all political entities are being appointed as a social worker.
They have no clue whatsoever.
At least NCLT, all those things, at least someone retired people will be there. They can understand some procedures. Consumer bodies are pathetic only. And important, the chairmanship also. If you see in Karnataka, those who are not satisfied with ministry portfolio, they all been given chairperson of various boards.
Sir, Karnataka is not an aberration, sir, everywhere. I think every state, what they are doing is people they can't accommodate in the ministry. They are giving them chairmanship.
Person who doesn't understand environment will become made as a pollution control chairman. They think pollution control board is to give license.
Correct.
Last session we can have conversation only. That would be.
Yeah. So tomorrow, sir, 11 o'clock, Mr. Shanmugha will be here.
Yeah.
So he will be speaking from here only.
Yeah.
So just make sure somebody is there. He's a very senior person.
Correct. We will arrange lunch also.
He's not too fixed about food and all, but because he hasn't come here too many times. Correct. Just if somebody is there, I have told him that Dr. Chengappa will make sure somebody is there.
I will be there.
I would have come. I have another meeting with some external lawyers for some work matter at 11 o'clock only. So that's why I wouldn't be able to come here.
No problem.
So I told him that don't worry. I will.
Yeah. We will manage.
So you managed to gather a very impressive panel.
Because of you only. I told yesterday about you. It's good that BC was also there. When you were, posing questions.
Okay, he was there.
Yeah. Okay. Yesterday night I told, Sir, Abhirup Mukherjee is a very good person. He gave me a lot of contact. Because of you, I could be able to invite.
Next time, sir, what we will do is this time we have invited Dr. Mr. Alapan Bandopatya.
Yeah.
He's also very, very senior.
That BC sir has to know.
What we will do is next time, sir, the current chief secretary, he's also a doctorate in finance. He is Dr. Hare Krishna Dwivedi. So his daughter is working with me in ITC. So he's also a very erudite person, very academically oriented. So if you have a seminar, high profile seminar, we will invite him also.
Definitely. One more, in the month of August, we will be having on wetland. Senior IFS officers.
Okay.
So just few people I will invite.
Sure.
For law, Google link, virtual will be more convenient also.
See, for people who can come,
it
is the best to come.
Yeah.
But otherwise, now all of us are used to this online mode.
I feel, we have to follow both.
Yeah.
Those who want
the
to
hybrid
come,
mode is very good.
Very good.
Because many people, although they want to join, but for them traveling to Calcutta and going back is a problem. So for them, it's easiest to join from wherever.
Correct.
Like I think Justice Shen in the morning, he was from his home office.
Yeah. True.
So Justice Anirudh Bose is coming tomorrow.
Yeah.
Only Dr. MP Singh, I think, some.
Yeah, last moment he said classes started in Jindal.
No, problem. But I think between you and Shamik, the session went on very well.
Because, Jindal very strict.
Oh, is it? Please.
We'll ask student to.
Hello. Yeah, please, sir.
No.
Please,
No, sir.
Yes, sir. Come, you also.
Yeah. I will join from there, sir.
Okay.
So we'll operate the camera and pan it on you.
I just join.
So you don't need to join the meeting. So speakers are here and we'll pan that camera on you. So you don't need to join through your device. Because if you join, then the voice will leak.
Okay, no problem. That's fine. Thank you.
This one, I think.
Right? So when we switch on this one, this camera will open. Okay. That's fine. Next. Also, so if possible, you need to reduce the volume on your phone, sorry, iPad also. Because again, if volume comes out of it,
It will not come because I am on mute here.
so when you speak, right, volume will come out of it, like the volume that they will receive, the speakers, moderators who are in their homes and they will speak, or other judges will speak, that voice will come out of this.
Okay, so I reduce the volume, no problem. Yeah.
Just
Got it.
Good afternoon, sir.
One minute. Where is the moderator? They can speak.
Good afternoon, sir.
Good afternoon. Am I audible?
Yes, sir, you are audible, sir.
Hello, Virup.
Good afternoon, sir. How are you?
I'm fine.
Pleasure to see you.
Nice to see you too. Yeah. Am I okay? I don't know.
Absolutely.
Audible and visible, as we say. Are we audible? Am I audible and visible?
Absolutely, sir. Crystal clear.
Thank you.
Asta is there, sir.
Let us begin with the session then. Thank you, Dr. Chengappa. Good afternoon to everyone gathered here in this call today and to those watching us on YouTube. I hope you all had a filling lunch and are ready for the second half of the day. I welcome you all to the fifth session of the first day of the International Conclave on Contemporary Issues of Administrative Law. I am Swagata Mukhopadhyay, and I am honored to be a moderator for this session. We have with us for this session a most illustrious guest. I would like to extend a very warm welcome on behalf of the Conclave and the university to Sri Vikramjit Banerjee, the Additional Solicitor General of India. Sir will speak on the topic of shift from public liability to individual liability in the administration. And now for a very brief introduction to a man to whom no introduction can truly do justice. As a senior advocate in the Supreme Court of India and Advocate General for the state of Nagaland, Mr. Banerjee has had a long and illustrious career as a legal practitioner in India. He graduated with an LLB from NLSIU Bangalore and an LLM from the University of Leicester as a Chevening Scholar, with the former achievement making him the first NLU graduate to hold the position of Additional Solicitor General. Mr. Banerjee is also enthusiastically connected to the more academic side of the profession and has authored and edited several books and pamphlets, articles and monographs in leading journals on a variety of topics, and he regularly lectures at think tanks and universities. We are grateful and delighted to have him with us today. Before we proceed, as has been the rule through the previous sessions, please drop any questions that you might have during the course of the session in the chat box, and I will present them to Sir during the Q&A session at the end of his lecture. The session will last for a total of 45 minutes. Without further ado, I hand over the mic to Sir to begin with the session that we've all been waiting.
Thank you very much. Thank you, Swagata, for that wonderful introduction. But I think the most important part of my curriculum vitae you omitted, and which I would hold you to account. I taught for a year at NUJS, and that's been some of my most treasured times which I have had in my life, and I can assure you that it was a wonderful, wonderful time, and it was fantastic. So that being said, and I'll get back to the topic, I think that still remains on top of the stuff which I consider my achievements. But we'll discuss that for another day. Coming back to the topic, I think, thank you for this one invitation, and thank you for being asked to be a speaker in this very, very, very interesting seminar, and with extremely eminent people who are part of that seminar. So thank you for considering me to speak on the topic. And it's a pleasure to be here. It's a pleasure to be, Kolkata is my hometown. I have taught at NUJS, and I consider that's the only place I have ever taught regularly. So it would have been a pleasure to be back, but maybe next time when Lord Ram and pandemic willing. But be that as it may. Coming back to the topic which I'm supposed to speak on is the shift from public liability to individual liability in the administration. I think it's important for us to first acknowledge the sort of history in which public liability in administration arose. I think that's extremely important for us to mark. Throughout history, and there has always been, liabilities have always been personal. If you look at the Arthashastra, liabilities are personal. So that if an official fails in his duty, he is held personally liable. Any public duty. Similarly was the case in common law. I don't know how many of you still study common law history, but common law, if anyone studies common law history, would know that in British common law, in English common law, whenever the people were grieved, or not even factions were grieved with any of king's officers, they were usually either brought to justice by the king personally, and they were held liable personally, or even at some point of time, king's closest advisors, when the king wouldn't act on them, were tried and executed on the orders of the parliament. Because the parliament has always been extremely important in British law through history. Similarly was the case in Roman law. Similarly was the case in Greek law. Roman law, we know that all the consuls and the censors and various different institutions which worked under the Roman constitution, all of them were held personally, and sometimes personally means they were physically attacked. And in Greek law, anyone who looked at the legal regulations of the Athenian democracy knows that people were held liable personally. Throughout Indian history, I think before the coming of the industrial age, people were held personally liable. If you look at even the time of Aini-Akbari, you would know that if an public official was found guilty of maladministration, he was held liable personally. But the product of the so-called immunity from personal liability was a product of the industrial age, because the industrial age produced unleashed very interesting and very powerful forces in society. One was there were huge finances available to, organized society was organized, which led to organization of everything, which meant again huge powers were unleashed in society. And the state was an invention. The way we perceive religion was an invention. The way we perceived our rights were an invention. And the reason why we invented the conception of rights is because when this huge power of the state was unleashed, and which was in many ways unknown to human history, then we had to find something to sort of check it. And so that's why in many cases rights were sort of invented simultaneously with the invention of the modern state and the industrial economy as we know it, to sort of balance both things. This is not new. Parallelly, I would just flag it for an interesting commentary. Parallelly, there was the entire conception of limited liability in companies were also invented, because then companies, previously, there was nothing known as a limited liability company. It is during the course of the industrial age when limited liability companies were invented so as to protect basically the individuals from liability. A most interesting anecdote, which I'm sure all of you are aware, which shows how it worked in India, is when the East India Company was for the first time granted the Diwani of Bengal, the Mughal emperor was not used to granting a limited liability company a Jagir. It's never happened in the history of India. So therefore, when he referred to the East India Company, he referred to the company as the East India Company Bahadur. So when he wrote the Jagir, he wrote it as personified in a person and gave it. So, it's at that point of time, sort of the East clashed with West. And this entire concept of limited liability, was the first time discussed. Now, even during the East India Company, and I would say this for large parts of Indian history, even during the East India Company, the question or the Raj, before what is called the British Raj, which happened after 1858, there was very limited concept of public liability, of the state not being responsible, even though the rudimentary sort of offshoots of protection, including Section 197 of the CRPC, had sort of been floated. But nonetheless, all of us who know history at that point of time would know the Raj officials or officials of the company were law unto themselves, and they basically liabilities attached to them as a person. There's a long, long history of that. But be that as it may, let's in short discuss this, that the product of this entire concept of the individual not being liable and the state being liable was a conception which was a product of the industrial age. Now, the products of the industrial age was extremely successful, and it produced the means of how the state acted, which was the bureaucracy. Of course, the Chinese had a bureaucracy long time before that. There were rudiments of bureaucracy everywhere because you can't run any state without some form of bureaucracy. But nonetheless, the bureaucracy, the way we see it today, was largely invented in Europe at similar to the time of the industrial age, when there was a need to move from feudalism to modernity as we see it. And the most interesting part is that supposedly in European history, the most successful bureaucratic state was the Prussian state, as we all know, it's been greatly discussed. But it's also interesting to sort of flag that this Prussian state which eventually morphs into the Weimar Republic and then eventually, in Nazi rule, there is this entire, which is the source of what happens later, whereby personal liability on officials becomes extremely important after the collapse of Nazi rule after the Second World War, when individual officials were fixed with personal responsibility for the actions of the state. Now, all of us who studied history again, and would know that both in the Tokyo trials as well as in the Nuremberg trials, the biggest defense was that I was a part of the state and I acted on behalf of the state. But I think from that point of time, the question of individual liability of officials sort of became an acceptable international norm. I'm sure it existed before, and I'm sure we can trace it to even common law. I'm sure we can trace it to other facets, which possibly, as I said, it had arisen. But in the law as we know it today, saying individuals cannot take the defense of the fact that they were acting on behalf of the state, sort of arose in and around the time during the time of 1945 and thereafter, where individual officials were largely held responsible. Now, coming to the question of, in the Indian Constitution, if we look at the Indian Constitution, it would be interesting to say where is this concept of individual liability of officials. I had an interesting discussion with some people and some academics and administrators over this. It is my conclusion as well, and I tend to agree with them, that the Indian Constitution does not actually provide for individual liability of private officials. The Indian Constitution, its fundamental rights, and it gives a large number of individual rights. It gives the right to freedom, equality, religion, culture, education, right to life, and right to constitutional remedy. And it balances it with largely the directive principle of state policy, which is basically an idea, an obligation of the state. So to secure a social order for the welfare of the people, for a better distribution of resources of the people, to procure a living wage, uniform civil code, improve public health, and organize and animal husbandry, amongst very many different other conceptions. But there is no conception to that extent of fixing individual liability on those who exercise power. Now, if you even see how the way the power is exercised in the Indian state, because we take the Constitution as sort of the framework on how the Indian state functions, we see it, and I'm there for every sort of article I suggest, I sort of mention here, there is a parallel provision, and I mention it for the Union. There are parallel provisions for the state. For every Article 53, which says vest the power of the Union in the President, there is a sort of power, Article 76, which exists for the state. Now, for every 74, which says the Council of Council of Ministers to aid and advise the President, there is an Article 163. And an Article 166 of the states has a parallel to 77.3, which says rules to be framed for, for conventions for performance, for exercise of these powers. 75.3 says upholds the principles of collective responsibility, and which makes the Council of Ministers responsible as a whole to the Parliament. And there are parallel provisions of Article 164 too. Now, none of which actually affixes any sort of personal responsibility on public officials. Now, if you look at the sort of provisions which deal with the bureaucracy as such, which are these articles which start from Article 300, which says, the power to file suits under Article 300, basically there are no individual rights to file suits against any person. It's by the union against state and state against the union. And if you go specifically to Article 308 to 313, 309 talks about regulation the recruitment and conditions of service appointed to public service, those who are in public services and posts in connection with the affairs of the union. In 310, it talks about the tenure of service of public servants. In 311, it talks about, how officials can be removed and what should be, what is their tenure and so on and so forth. But again, nothing very specific about fixing any specific personal liability. In 312, Article 312, which talks about creation of an All India service, and it says that in various All India services could be created, including subsequent to the amendment Indian Judicial Service, but that's where it stops. In 312A, it says that you can, of course, conditions of service can be changed, can whatever be amended. But the fact of the matter is, in any case, if you have a close look at the Indian Constitution, the Constitution does not actually provide for a method whereby you can hold public servants or anyone who's acting in a public capacity or performing public duties to be held personally liable. Now, there is a long history. Some can even link it maybe to the sort of pre-British fact and the things which we discussed as when we had a very, very powerful company, which actually ruled India for nearly 100 years. And then we had the British Raj, which was a colonial enterprise. So maybe the immunity which was given famously under the CRPC, as we all know, saying that you cannot sanction someone who's a public official without getting sanctioned from the government, was a result of this sort of a mentality which tended to protect the people who were governing the country rather than across the board, rather than the people. Now, we know also that this sort of arose because of the fact which has been largely been discussed a number of times, that it was felt imperative that officials needed to be protected from frivolous litigation which arises and which we know from practical day-to-day life that it still exists. So it's not that officials are, every prosecution launched against every public official is bona fide, or for that matter is for the best intent and purposes and for prosecuting a public cause. There are various different reasons in which they are filed, and if one appears in court every day, one comes across different types of litigation. A lot of the public litigation is bona fide, there is no question, but there are one-off cases where they're motivated for other reasons, for sometimes pushing back against a public official who's been doing good work, sometimes for harassing, sometimes for various different reasons. So that is a genuine concern. And so therefore, this protection against personal liability given under Section 197 is, I think, in some cases valid. But nonetheless, as we have seen over a period of time in the jurisprudence of the Indian Supreme Court that has followed, the Section 197 has been continuously narrowed, so that the court, even on personal criminal liability, has been continuously narrowing this provision to the extent where there have been a number of judgments of the Supreme Court which basically says that if you are caught in any wrongdoing, then it obviously cannot be in the course of your duty. So you should be, if it's a criminal act, it's not in the course of your duty. So, in XYZ cases, Section 197 won't even apply. So you can't even take the defense of Section 197. Of course, there have been other judgments also of the Supreme Court, which takes a contrary view. But nonetheless, I think on balance, the scope of being protected from individual liability is continuously being whittled down. Now, of course, we also have the All India service rules of, which govern public servants, but nonetheless, I do not think there is anything which makes people in any specific way liable for any wrongdoing which they may have done during the course of their performance of their duties, which I think in many ways is valid because in many ways it would be, I would think, as someone who's been part of the government, that in some cases it would be disruptive if such things happen. But I also value the sort of latest consideration which has increasingly taken hold, that there should be some method of holding public officials accountable for their actions. And in the case of India, this has largely come through the Indian Supreme Court. I don't know how many of you sort of follow the jurisprudence of the Indian Supreme Court, but I'll just mark a few sort of judgments, which according to me, and this is, I'm sure everybody, all of us can come up with our own judgments, which we think are path-breaking on this issue, because there are a large number of path-breaking judgments on this issue, some which, when I was young, we even studied at the law school itself, because it sort of narrowed down the entire concept of what used to be called the sovereign immunity and made individuals liable. Now, a very interesting aside on sovereign immunity before I address those points points raised by the Indian Supreme Court is the question of sovereign immunity itself. The sovereign immunity supposedly arises from the principle that the king can do no wrong. So king is above the law in some ways. But in the modern state, post-industrial revolution state, this sort of protection, which was only limited to the king, was then extended to everyone in the state supposedly acting on behalf of state power. So which then became, sovereign immunity became available, or the defense of sovereign immunity became those exercising state power rather than the king himself, which was an inordinate expansion of that power, of the people who had the ability to wield the power. So when now sovereign immunity is as a defense which started being put out in common law, became a completely different beast than what it was originally sort of envisaged as. So in many cases, as I said, because the state itself, as we see it, is a product of post-industrial age, power has been both magnified as well as diversified. So there have been various people who can exercise power in the name of the state, as well as the power of the state has been much more magnified. The rights as such, the conception of rights that we use today, which we think is fundamental to the governance of society, is also interestingly invented or discovered at that point of time, depending on what one thinks about fundamental rights. They are invented and discovered because it is perceived that there has to be a check on this exercise of sovereign power, and rights and an independent judiciary seems to be the best bulwark against such misuse. Neither the question of independent judiciary is, again, independent judiciary to implement those rights may be a new concept, but the fact of a judiciary and sort of the judges being in a position to judge sovereign action is not, again, unknown and was not unknown in history. In Indian jurisprudence, as we've always said that the question of dharma is above the king. And as we know from even common law history, we all think the common law is a king can do no wrong, but that's not always been the case. In common law, there have been numerous times, especially in common law, of the fact that of judges having ruled against the king's interests. And law has always been above the king in many, many ways in common law, even though theoretically may not be so, but practically it has always worked towards that. All of us know that the first place where I think in history where the king was tried and was executed was under the auspices of the common law. So it's not something which was unknown to common law, but of course, the entire conception, and it is my view that industrial age completely changes the complexion of the state. So the way we sort of conceive things had to be completely reinvented and reformulated. Now, coming back to my original point of discussion about the Indian Supreme Court, I think the first time where this issue sort of came up for discussion, according to me, was in 1964 in Kasturilal Railaram, which all of us who've sort of studied in any law school, at least during our time, knew by heart. It was part of any tort law course, if I recollect, because when it said that misplacement of jewels and jewelry and precious stones and the police being responsible and the sovereign power being taken as a defense, and the court upholding sovereign power in some ways, but leaving the scope open for future whittling down of those powers, but upholding sovereign powers, in exercise of sovereign powers in some ways. So that I think is the first question when these sort of Supreme Court started grappling with these issues. But again, this is another case which all of us who've been done that famous taught one course, if I remember correctly, and possibly know by heart, is the case of Rudul Shah, which again held the state liable for the acts of its officers, which was a huge break from the jurisprudence of that time, because in the entire conception of what is sovereign immunity was like really whittled down, because as I said, the entire conception of sovereign immunity became part of trying of an immunity of state action, which in Indian constitutional law, I perceive that Rudul Shah was a break. Of course, it may not have gone the whole way, it may not have gone the whole 9 yards, as we say, but it did, in some ways, destroy the edifice of complete sovereign immunity, which the state would put forward. So I think we pretty much settled it. It started off in Kasturilal Railaram, which was like really close to independence, and then when 1992 in Rudul Shah, the course of individual liability, the course which would then come to exemplify individual liability of public officials, had already been set in motion, because then you had held the state responsible for the acts of its officers and basically done away with the entire conception of sovereign immunity. Another case which we were very used to is Nilabati Behra, where the state was held explicitly liable, made liable for the wrongdoing of its employees. And basically the entire logic of Kasturilal Railaram was put to rest, and you said you are explicitly liable. Now, this was again upheld. That was Nilabati Behra was in 1993. So when we studied Tort 1, I think we studied Tort 1 in 92, 93 also, where that's how old I am. So that was very much a part of our curriculum. It was like cutting edge law. But so the teachers would teach us. This is the latest decision of the Supreme Court on this point. Subsequent it was, and we studied, I think, Tort 293, and thereafter, no one gets to study in law school tort except if you had a moot to prepare for. So, but then, which was subsequently followed, as we know, by Nagendra Rao in 1994, and in 1994 also another thing happened, and I think which is, and it's interesting, and I'll come to this question as to why I think that all this happened in the 1990s. In 1994, the Lucknow Development Authority case also happened, and where the court for the first time sort of came up with the idea of misfeasance in public office, which basically made public servants liable, expressly liable for illegal violations of private rights of citizens. So this is, this is where things take a turn to hold people individually liable. Now, again in 1995, you had Vijay Singh Shirke, where the court again uses the principle of tort of vicarious liability, which I think the roots of which would have possibly, would have been, if I trace it back today, I would possibly think it sort of lies in the tort jurisprudence which the Supreme Court was trying to formulate to sort of deal with Bhopal during the Sri Ram gas leak case. But I think which was headed off by Charanlal Sahu, the subsequently what happened and the settlement and thereafter, whatever. But the fact that it was sort of trying to hold people vicariously liable and trying to bring in vicarious liability in Indian jurisprudence was, I think, was taken up and used in Vijay Singh Shirke to make the state vicariously liable, which I think as we, it used to be discussed in our classrooms. I don't know how much of it is discussed now, that in India, we have a severe lack of tort jurisprudence. Unlike the common law in Britain, where there has always been an explosion existence of tort jurisprudence. In India, we have used tort jurisprudence through constitutional law. So somehow or the other, that used to be a topic of discussion. I don't know whether that still is, but I think this exemplifies it. The vicarious liability was also trying to be brought in through constitutional rights and for violation of constitutional duties. And it was brought in context of the state. Now in 1996, both in Common Cause and Shiv Sagar, the court relied on this misfeasance in public office as a ground to impose personal damages on public servants. This was pathbreaking, and this is my take on why this happened in the 1990s, and this is my personal take, so don't take it too seriously. My personal take of why it happened in the 1990s is because 1990s, India opened up. India opened up to the rest of the world. There was liberalization. There was a growth of the entire conception of individual rights jurisprudence. I studied in law during the 1990s. So I remember going to law school in 1992 and I graduated in 1997. So I know this entire grappling of individual rights and of holding public service, public officials accountable, and as well as, this explosion of individual rights jurisprudence. And before that, in my father's generation, state was taken to be a very, very benign organization. And because I work within the state, I think it still works for the good of the people, and it always has the interests of good of the people at heart. I'm not a person who's skeptical of the state, but this entire confrontational idea with the state starts off in 1990s, for good or for bad. That's how it is. That's how the cookie crumbles, and that's how it pans out in that case. So now today we are in a place where you can hold public servants personally liable for damages for violation of public rights. Now, as we also know, and I'm sure we know this, that it has its antecedents. There are foreign judgments from Canada, from Australia, even close to home in Sri Lanka, who have sort of gone down that path of considering public servants responsible for violation of public rights. And in Canada and Australia, it happened in 1959 in both cases. One, I think, is Farrington versus Thompson in Australia, and in Canada is that famous Collier's case, where all of these things were being discussed. And I think these things happened in Canada and Australia for a different reason, as I said, because they were directly out of the milieu of what happened in 1945 and the trials of Nuremberg. So in the West, in Europe, there was a different it was a different time which influenced this jurisprudence. And in India, we still consider the state to be benign. And I think for large parts of India, it is still a benign institution. But I think this explosion of individual rights jurisprudence, which happens in the 1990s, and which the law schools, it's a treasured heritage of all law schools. They all treasure being, great defenders of individual rights. So I know, because I've taught for a year at NUJS, and which has been a great experience, and I studied at the National Law School in Bangalore. So I know how great, how protection of rights is treasured. So I think because the law schools, again, are a product of the 90s, and they are a product of the 90s. So I think, this is their heritage, and that is where they come from. I understand it completely. Now, I'll conclude. I think I've gone on enough. In conclusion, I think the sort of jurisprudence which we are speaking of today, and this I say with a lot of thought, the conception of state that we have today, the conception of state that we have today, the conception of law that we have today, the conception of rights that we have today, the content of state power that we have today, the content of rights that we have today is fundamentally changing. When we are moving from the industrial age and entire industrial age, all these institutions that we know today, rights, the state, everything, our social organizations. And I don't want to go to controversy, so I won't mention those state organizations, but let's take the state, rights, companies, corporates. Everything is a product, as we see it, of the industrial age, directly product of the industrial age. And in the internet age, the rules, the regulation, the framework, the values will radically change. And it will make people individual liability, because the internet age is an individualist age, for better or for worse, whether we like it or whether we don't like it. As I was discussing with someone yesterday, there were people who didn't like the industrial age. Mahatma Gandhi had I don't know how many of you read Hind Swaraj, but Hind Swaraj was clearly, against the conception of industrial age. But there was no way out. The industrial age was the truth. It had to be faced. Similarly for the internet age, that is where we are going. That is what is going to happen. And in internet age, there is a huge thing of individual responsibility. And therefore, I think the judgments of the Indian Supreme Court, however much I'm not quite comfortable, and I must say this, I'm not quite comfortable of holding public officials responsible personally for violation of private rights of citizens, because I've seen the wrong edge of that as well. But I personally think that is the way where we are going. That's the jurisprudence which the Supreme Court has adopted. That's the jurisprudence it has adopted, and that's the jurisprudence because that's the sign of the times, because that is the decision of the times. That is the way. That is the order of the age and of the internet age. So I think this is here to stay now. And this question of, holding public servants responsible, and through this entire conception of misfeasance in public office, is here to stay. And it is a difficult role. Increasingly, it would be a difficult role for public servants to navigate these strong undercurrents. And do I have any answers as to how it will turn out? I don't know. But I think by rubbing against, and the power of the state keeps on getting narrowed by not only the sort of independent judiciary throughout the world, but it also gets narrowed by the technology which is upon us. And I'm saying technology upon us is because we can't do anything about it, however much we want to. So it would be in future even more difficult. And I'm sure it has always been difficult for government servants to function in public life, but it would become even more difficult in future. Thank you very much.
Thank you so much, Dr. Banerjee, for that incredible session. I would like to now invite any questions that the participants might have.
Chayota, one more clarification. I am not a doctor.
Yeah,
I don't have a doctorate.
That was my mistake. I apologize.
I've just missed it. That would do. Thanks.
Thank you so much, Mr. Banerjee. I would like to invite any questions that the audience might have. Yes, Agniva has had a question, so you would invite
Yeah,
Agniva.
sir, I'm Agniva from the 4th year.
Hi, Agniva.
Sir, so my question was a little off script, and I just wanted to ask because I've been following your tweets for a long time now.
Yeah.
And you had tweeted about Lord Sumption's trials of the state.
Yeah.
So do you feel that an increasing trend has been seen in the Supreme Court jurisprudence where political questions are being couched in a legal language and have been adjudicated?
No, there are two things. First of all, I couch it with this my personal thing, and what I'm saying is personal. It does not reflect any stand of the government. It doesn't, and I'm being very clear on that. But my reading is that's what's been happening for the last 20 years, and Lord Sumption is not the first person. There is, I think, there was Rand Herschel who wrote about judocracy, who also wrote about the fact that how increasingly large constitutional questions, and he, of course, attributed to malafide elites, saying that who couldn't get their work done through parliament anymore because the country had become, and he says this in not only context of India, he says in the context of America, he says in the context of Israel, and he said the elites couldn't get their work done anymore, their values were not reflected among the people, so they sort of shifted it to the judiciary, and they sort of, they say sort of created a circle around it on the ground of independence of judiciary, and they used the judiciary to decide these large questions of constitutional law, which would otherwise have worked against them. Lord Sumption has a different take on it, saying that these questions should be left largely to be worked out. I would urge, these are big political questions. These should be decided in democracy. And I think more than the judiciary, it's democracy which resolves these questions finally. And resolve these questions, finally is a wrong word to use because no question in history is ever resolved finally. Everything is a semi-final. But be that as it may, I think these broader questions should be resolved in the democratic domain.
Thank you. Thank you, sir, for a very informative session. Sir,
thank you.
You rightly pointed out Constitution doesn't impose us any individual responsibility. Don't you think that, sir, there are so many cases against the state, the government is biggest litigant. We had a previous session wherein land acquisition cases goes to the High Court and Supreme Court. 70% of the cases were public servant not following the principles of natural justice, where the poor person has to fight case in Supreme Court and High Court.
I'll take that question. I think it's very interesting. We tend to, at the end, whom are you going to hold responsible? It's rhetorically nice to make that comment. And I've been inside it, so I can assure you that it goes through various layers of responsibility. It comes to me to decide. I'll give you an example of how a very minuscule person, and I'll sort of illustrate it so that you better understand. A point to be argued in Supreme Court, how does it sort of, on something which is a pension of a very small, insignificant person, how does an additional Solicitor General of India appear in that matter? Now, that's a question which we face from the court every day. So this is not a new question. Now, I'll tell you how it actually happens. There will be various notings for and behalf within the department. Some will say release the money, some will say not release the money. Some will say this is an insignificant amount. Some will say there is a large question of law involved. Then the legal department will refer it to me and refer a very persuasive note ensuring that there is a huge point of law involved which will have huge repercussions down the line. And that will be placed to me for a legal opinion. So the entire continuous struggle is, don't look, sometimes, and rightly so, I'm not saying that people are not don't have genuine grievances, but these genuine grievances also need to be at times balanced with public interest. And that's what the courts are for. And I think that courts balance that. And I think a lot of us, as individual public officials or officers deciding on lines of litigation, don't necessarily get it right all the time. So you can also, on the flip side of that, you can say that, shirking responsibility by taking the hard decisions. But then the fact of the matter is, and I can also assure you this happens, is as a public official, when you're signing on every file and anything, you are scared out of your wits. You don't know when that signature will come back to you. So that's how it is. So, we all tend to think, if the court decides, well, that's out of my hands. So fine, I'm saved. So that tends to be, but, it's tough. It's not as easy as you think it is. It's easier. The perception of how powerful the government is a perception which is cultivated easily from the outside rather than from the inside. People, when you work in the inside, that it's an illusion. And don't let anyone on the secret. It's an illusion.
Thank you.
So much, Mr. Banerjee. If I might ask a final question.
Thank you.
When you introduced the idea of personal responsibility, you kind of drew a historical picture of how personal responsibility was introduced in various forms of government. And the thing that struck me the most was often the way that these public officials were held liable was through like an internal structure, like the government itself, the executive branch, or whatever. The system itself held these public officials liable instead of the people having to kind of go to the judiciary, etc. So now the perception of the state is as a monolithic entity where whenever a public official messes up, you sue the state and you get money from the treasury, which then raises questions of why is the state paying for the mistakes of public officials and all of these controversies. So do you think there is a possibility of an internal like check and balance system or a mechanism of kind of accountability to be implemented within the government?
There is, no government, according to my perception, no responsible government, and definitely not in a democratic society, wants to do anything wrong. They try to do the best under the situation. So, but of course, things happen, and I'm not saying that we live in a perfect society, we live in a perfect state. It's not possible. Things do go wrong. The whole question is, how do you hold, the wrongs accountable? And the government has its mechanism to deal with that. But eventually, even those disputes eventually end up in court. Because as I said, the British always used to, they've always said that India was an extremely litigious society. And, you've heard those criticisms in all British colonial tropes. But I personally think the 1990s, with the sort of profusion of the consciousness of rights, it has become very difficult for government in many ways to function. So I think in many ways, as I said, the easiest way to do it is let the courts handle it. But of course, the government has its ways and means, and the government tries its best. to ensure that any wrongdoing is addressed. But no system is perfect, and we all have to realize that we live in an imperfect world, and we work in imperfect systems, and that's the truth of the matter. People can tell you that's how it should be, but realism is something which we should be used to, and I'm trying to put it as sweetly as possible.
Thank you so much, Ms. Banerjee, for that answer. I would like to take this opportunity to again extend my sincerest gratitude to you, sir, from the Conclave and from the university, for expanding our perspectives on how personal liability for public duty plays out and what it means in the context of the meaning of the state and the wider understanding of authority, not just in the present, but throughout history, the driving factors for these developments, and also what kind of future we have to look forward to as we move into a more atomized future. I would also like to thank all of the participants in this session for your attendance and engagement. With that, I bring the 5th session of the International Conclave on Contemporary Issues of Administrative Law to a close. Thank you very much.
Thank you very much, sir, for your valuable time. Our Honorable Vice Chancellor also here.
I know.
Thank you, Bikramjit. After
Yes, Professor.
time in the virtual mode.
I know, Professor.
Hope to see you physically.
Professor Chakraborty is a very, very dear elder of mine for a very long period of time.
After long gap.
Yes.
দেখা
হবে স্যার, নিশ্চয়ই দেখা হবে।
Sir also taught at NUJS, sir.
নিশ্চয়ই।
Okay.
ধন্যবাদ।
Thank you.
Thank you.
I now hand over the mic to Agniva, who will be moderating the next session. Thank you, Agniva.
Thank you, Swagata. We also have our Vice Chancellor, sir, on the call. Thank you, Vice Chancellor, sir, for attending the session. Chenkappa, sir, if I may proceed.
Yeah,
and
please.
start the session. Greetings, everyone, and welcome to this session of the International Conclave. In this session today, we have with us Mr. Alapan Bandyopadhyay, a distinguished civil servant who is presently serving as the Chief Advisor to the Chief Minister of West Bengal. Mr. Alapan Bandyopadhyay has been a National Talent Search Scholar in 1978 and continued his studies in the prestigious Presidency College in Calcutta, and then secured a gold medal in his MA examination from Calcutta University. Prior to joining the service in 1987, Sir was an eminent journalist with Anandabazar Patrika, which is a noted Bengali daily. Sir has served as an administrative functionary across the state of West Bengal in different roles, and today we hope to learn from his administrative experience as well as his dealings with the realm of law. Without further ado, I would like to request Sir to begin the lecture and share with us his experiences as a distinguished administrative official.
Honorable Vice Chancellor, am I audible?
Yes.
Honorable
Yes,
Vice Chancellor, members of faculty and students of the West Bengal National University of Juridical Sciences, distinguished participants, ladies and gentlemen. I thank the Vice Chancellor, Professor Dr. Nirmal Kanti Chakraborty, and the NUJS authorities for inviting me to speak on administrative law and decision-making, experiences of an administrator in the implementation of law. Normally, administrators are not invited to speak on matters juridical or legal. They are seen typically as a lower, inferior substratum of the executive. Mindless tools of implementation are necessary even at best. I've always argued against such compartmentalizing and very degrading schema, and I've tried to plead that a 360-degree pursuit of knowledge should be organically holistic, and you must allow the administrator's gaze in discussions on administration. even if such discussions are in the realm of laws, norms, or principles. A subconscious conception of divorce or hiatus between knowledge and action, between jnana and karma, law and implementation, is Platonic, Brahmanical in origin, aristocratic in temper, and in India's context, colonial in nurture. British guardians would shepherd us, and subordinate Indians would be mere complicit compradors, subaltern elite. Such was the ruling mindset in colonial India. And if for nothing else, at least for the sake of decolonization, we should dismantle the artificial walls that stand between norm setting and norm implementing. Let the difficulties and constraints of implementation be appreciated by the framers of paradigms in all fora. I have written a book with the title Amlar Mon, arguing that the mind of the bureaucrat needs empathetic reading. I thank Professor Chakraborty for allowing an administrative gaze on matters juridical, which are finally nothing but matters human. If Plato has been one ancient inspiration behind the scheme to keep setting of norms distinct from and superior to implementation of the same, in modern times, Montesquieu has certainly been another beacon. The great 18th century thinker that Montesquieu was, famously authored the doctrine of separation of powers and urged all people in pursuit of liberty to keep the legislative, the judicial, and the executive domains away from each other. In the age of American and French revolutions, the credo had a revolutionary fervor, and ever since then, the overarching mission of the legislators, the jurists, the judges, and the freethinkers has been to protect liberty from the clutches of executive despotism. Distancing administration from discussion on administrative law has a root there also. But the age of such deliberately limited governments for protection of life, liberty, and property is over. We have entered an age of welfarist populist regimes that are politically propelled and technologically enabled to reach out to every aspect of human life with schemes for administering too many things at too hurried a pace. Multitudinous anxiety to get things from administration, as distinguished from patrician anxiety to protect things from administration, is the dominant drive in our polity today. Organic integration of purposes of different branches of state for meeting the anxieties from below may be the real need of the hour today, rather than the philosophies associated with what Macpherson had described as possessive individualism. There is, however, pervasive skepticism about such organic integration, and much of it has its genealogy also in the evolution of European parliaments. It is with great difficulty that the parliaments of Europe threw out the king's men from legislatures, and the elaborate anxiety with which civil servants are barred from casting their shadow in the houses of Indian legislatures underlines the memory of those bitter stripes. Recalling a civil servant, as you do today, to a jurist platform performs a disruptive function today. Disruption is indeed called for, I argue. The legal fictions of the legislatures legislating in somber, sovereign tranquility and the executive executing them in earnest, implementing anxiety have long been busted. Ancient Greek titans like Pythagoras, Plato, and Euclid stuck to some axiomatic propositions, theorems, forms, and geometric abstractions and deducted much of what they wrote from those abstract postulates. Our jurisprudence, I argue, has been influenced by this genre of a priori thinking for too long a time, but I suspect that the democratic populist disruptions in polity today call for corresponding disruptions in our epistemology, philosophy, political thought, and legal sciences. Inductive logic and a posteriori thinking would excite us to explicitly acknowledge the reality of party systems and appreciate that in an age of dominant party systems, particularly in the parliamentary democracies, the executive and the legislature are inextricably interwoven, existentially stitched, with the declining legislatures often being mere extensions of the strong executive. Judiciary stands alone, separate to the extent practical, to guard against executive excesses. In this battle against executive excesses and tyrannies, which the judiciary is ordained to fight, notwithstanding attempts at organic synthesis of pro-people visions, it is possible for the judiciary to locate an ally which it has hitherto neglected or inferiorized due to old Platonic Brahmanical a priori samskaras or due to training in Montesquieu, etc., as I argue. In the compartment of executive, an a posteriori approach would observe there actually lie two distinct compartments. One, the political one, and two, the permanent one. The parliaments of Europe had been fighting the king and his permanent servants till the 19th century, and they had gradually and painstakingly secured the support of the jurists and the judges on behalf of the then ruling political classes against the arbitrariness of the executive. Capital needed legal rational authorities, as Max Weber, the German philosopher, would say, and reason alone could create a regime that could predictably secure life, liberty, and property. It is this reason that generated modern bureaucracy too. People recruited increasingly through impersonal written examinations to execute the rational laws in a faceless manner. Like the ascendant parliament and the slowly evolving independent judiciary, the modern bureaucracy has also served modern capitalist reason, late 19th century onwards particularly. They were all siblings born of the same womb, unfortunately separated at birth due to jurists and legislators' legitimate anxiety to keep the king's men at bay, even while the judges and juries themselves were king's men to begin with. In India, during the colonial times, the Raj was heavily bureaucratized, and their over-bureaucratization alienated the thinkers and the masses alike. But post-independence, the canvas changed, and yet scarce did the jurists and the legislators and the judges note that the bureaucrats, born out of the same mother reason, were fundamentally anxious to conform to the legal rational. That was their design and DNA. They were scared to do otherwise at the instance of their entrepreneurial and enterprising political bosses. Seeing only greed and tyranny in them, the guardians of law have underutilized a potential ally of theirs in the post-colonial polity. Today, Once we accept the politics of party systems to be a reality, and once we understand that overwhelming desires to please and serve the hungry multitude will remain the abiding existential passion and imperative for the democratic polity, we shall understand how we should redevise our strategies to battle against possible excesses of aggrandizing elected power without, of course, destabilizing the mandate of democracy to reach unto the last. The mandate of democracy is radical, and the safeguards that we plan through law to conserve life, liberty, and property against the tyrannical overdrives of democracy's popular radicalism must be creative, smart, and ingenious. It is here that administrative law can come to our advantage, and it is here that a new coalition of judges, jurists, and permanent administrators may be useful. Old mistrusts must go, and new syncretic combinations must evolve. Functionaries trained in stratagems of legal rationale may make a united front against potential excesses of the enterprising political. In view of limitations of time, I would rather interact. I shall now straightaway come to some specific recommendations formulated on the basis of my 35 years of administrative experiences, too long a time, which include intense interactions with members of all three branches of state, legislative, executive, and judicial. I have 4 recommendations. I will say one by one. 1. Administrative law should be seen as an enabler rather than only a deterrent exercise. Too many times have we heard that administrative law is a law that relates to the control of governmental power, etc. I was reading a couple of books on administrative law for preparing myself. Everywhere the whole emphasis is on how to control governmental power, how to control administrative power, how to combat excesses. This healthy skepticism or mistrust about executive administrative excesses, which I can understand. As I said, for too long a time, we have been really trained to think that way. But that should be combined now with, I argue, I submit, with a genuine appreciation of the difficulties that the cutting edges of developmental administration face in delivery of public services in the field. The idea of enhancing the utility and efficacy and efficiency of the retail administrative service providers at the grassroots level should inform our legislation and judicial scrutiny. Jurists' distrust was well applied to the police state or the old aristocratic state, but anxiety to perform the developmental or the welfare functions should equally worry the modern welfare populist state. Recommendation 2. Delegated or subordinate legislation should be valued, respected, elevated, encoded, and properly publicized. I read a bit of disrespect in the current discussions on rules, regulations, bylaws, etc. That is delegated or subordinate legislation. Typically, these are exercises initiated by permanent administrators, but equally typically, they have little clarity on these subjects. Textbooks on administrative law, have I become too boring? Too many people are leaving the meeting. I'm reading out from a script because I thought that would be a good thing to do in the seminar, but I could tell you our examples also. But okay, let me complete in 10 minutes. Textbooks on administrative law usually skip detailed discourses and bracket everything from rules to notification in the same cohort. Practices about making of these subordinate laws widely vary across the globe and certainly in India, with the union government and the states having a variety of models to pick up from, and there being no crystallized clarity which process to exactly follow, in which case and in which manner. When do you make rules and when do you seek regulations? How do you make bylaws and which process do you follow to amend them? In the age of plethora of subordinate laws that have come to stay and rule and prosper, we need standardization and clarity on the processes. Subordinate legislation should also be based on wide-ranging discussions with stakeholders, interest groups, societies or firms in the field, etc., and may be kept compulsorily in publicly accessible portals, both before and after finalization of drafts. Media, including social media, which is so powerful today, discussions should be promoted. The hollowness of in-camera discussions that often characterizes parleys in legislatures should be complemented by intense sectoral discussions, stakeholding in nature, in the case of delegated legislations, and that will also enhance the dignity of the latter and may probably forestall time-consuming judicial reviews. Social rather than judicial audit by affected stakeholders of the subordinate laws could save precious judicial time and prove to be locally more effective, even while the option of judicial scrutiny must remain there as a final resort. Recommendation 3. Delegation of powers should be the cornerstone of administrative law. I argue that even in the delegated legislation, the fulcrum should be how can we elaborately delegate powers in a multi-scalar manner. In all administrative matters, appropriate and well thought out delegation of powers for efficient and effective delivery of public services at the grassroots level should be the objective. For several thousand years, governance has been an aristocratic proposition globally. Elite institutions like parliaments, state assemblies, courts, or elite functionaries like ministers, secretaries, etc., have been seen as repositories of power and authority and dispensers of justice. Even when decentralization or delegation of administrative power has been conceived, only the singular heads of the subordinate bodies, like the collector of a district or the commissioner of a municipal corporation, have been empowered to take decisions on incremental basis. Such a fine and narrow and aristocratic scheme of maintaining an elite core of decision makers from top to bottom may have served the polity of yesteryears, but they are certainly inadequate in the age of explosion of demands in populous democracies like ours. Honesty and brilliance do not lie in individual stations of high offices or ranks or aristocratic lineages of institutions. They would rather lie in safeguards and institutional arrangements of transparency. In fact, by making a public official, even at a lower level, precisely accountable, I was hearing a lot of discussion on liability of public officials, and by fixing responsibility on him, making him liable, yes, we add to his integrity quotient. He who signs remains scared. He who signs knows he can be caught, particularly if his pensions and postings and reputation are at direct stake. In any case, the superior officer blindly signs on dotted lines. I think Mr. Vikramjit Banerjee was also basically saying that. we all sign on dotted lines without application of mind, I can assure you, offered to him by his juniors. There are just too many cases and too many contingencies to receive individual application of mind from any senior officer. If that is so, why not empower the juniors to pass the order? Let the junior be responsible for his signature. This direct correspondence between the man who understands, or the woman who understands the subject, who is putting up a note, who is taking a decision, and who is signing, this direct correspondence will lead to 80-20, the officer being within given lines. If we still cannot trust a junior officer due to, I argue, our aristocratic superstitions, let us repose faith in plurality. Let us make teams of officers plurally and collectively responsible for each tax concession, each motor vehicle case, each land acquisition payment finalization. Sanctity would lie in numbers. Charlie Chaplin's famous line, sanctity lies in numbers. You murder one guy, that is murder. You murder thousands, that's a war. Reshuffle the officers' pack, break syndicates, make complicity difficult. Let officers from diverse sets be brought to the empowered delegated authorities. But let there be structured delegation to field officers at the lowest levels for preventing issues rising upwards. Let the Panchayat model of collective governance and Lok Adalat model of dispensation of justice by consensual conciliation be attempted for administrative service delivery too. In open forums, in full glare of publicity, in front of social media gaze if need be, let the empowered boards of field officers with powers delegated systematically in administrative laws and rules and regulations keep on giving services and justice speedily and on any time, anywhere basis as digital technology permits. Let the laws, the judiciary, the superior officers be sentinels only. Let them maintain the boundaries, but let our distrust of power not prevent us from decentralizing power for serving the multitude. Service from the state in seamless ecosystem would prevent excessive concentration of powers and travesty thereof at higher levels, which should be the final aim of the legislators, the jurists, and the courts, and which in any case is the final aim of the doctrine of separation of powers, which keeps on haunting us. Fourth and final recommendation, taking back power to people should be the final mission of administrative law. Finally, therefore, the mission is to dismantle the unnecessarily huge edifice of structures of power and to make administration of things easy, simple, available at people's level for most elementary aspects of life. If people in democracy are the original repositories of power, let power to administer go back to those fountain heads to the extent practicable. At least that should be the objective, in the light of which we should recast our efforts, vain as they are in most cases. India is to subalternize the exercise of administrative power. Power once resided in kinship groups, communities, neighborhoods, traditional structures where there was cooperative arrangement of sharing of power. Colonial statism brought every exercise of administration in the fold of structured statist power. Exercises may be initiated to strike at the root of such thoughts so that administration may go back to people to the extent practical. At least let that vision illumine us. That was a little written script. I would rather interact in case people have questions or suggestions, whatever.
If anyone has questions, they can raise their hand. Yeah, Asta, go ahead.
So, hello. Actually, I had a question with respect to the second prong of the suggestions that you had in terms of how we essentially should also legitimize or give better authority to delegated legislations. And in terms of that, I just wanted to know if there is a certain model that you have in mind in terms of public participation in delegated legislations, because as we know, even public participation in terms of bills is also not very transparent, as we can see an example of the environmental impact assessment bill. So you open for comments of the public on a website, but we're never really given an update on how exactly those comments are incorporated into the amended bill and those things. So in terms of that, do you have a model in mind?
Okay, I had given this little script of mine for a pre-review to one NUJS student, my former NUJS student, Mohima Cholera. I don't know whether you know. She assists me in some of my cases as they keep on. You must be knowing about my cases. So she was telling me that I should give examples from my career to enliven the discussions. In Kolkata Municipal Court, I was Municipal Commissioner, Kolkata Municipal Corporation for about 4 years. So in Kolkata Municipal Corporation, I didn't want to say I too many times, so I was avoiding examples. So there I found that every single file used to come to the Municipal Commissioner because the Act is structured on 3 layers: the corporation, which is a house, which is the highest body; the mayoring council, which is a cabinet that governs the corporation, which has certain powers, and below that the municipal commissioner. In any case, even in order to go to the municipal corporation, you go through the municipal commissioner. So thousands of files literally were coming to municipal commissioner, and there was absolutely not a single file which could be disposed of by anyone below the municipal commissioner. So I asked my predecessor the day I was joining the post of municipal commissioner, how do you manage? There were hundreds of files pending in his chamber. I said, how do you manage? He said, oh, you don't know, you have to do. I said, why should I have to do? No, I'm not an idiot. I will sign all these files, keep staying in office till 11. He used to stay in office till 11 p.m. now. I said, why should I all do? You know, I have no idea what kind of stealing and pilferages and all the corruption level and all those. Apparently every single corporation official is a thief and can't be trusted and all that. So this foxed me. On the one hand, all corporations, all civic corporations across the country are known for corruption and all that. On the other hand, this is extremely inefficient to bring every single file to you, and I am not the last custodian of honesty. There must be honest people everywhere. So there, I thought that there must be a delegation. The Act indeed had a much concealed section toward the end of the book, which says the municipal commissioner may delegate. So I took resort to the delegation structure, and I'm a student of political science. I also used my knowledge that the entire structure of governance is actually delegation oriented. Theoretically, as per the model of crown or as per the model of the monarch in India, even today the president rules the country. In the states, the governor rules the country. The governor has merely delegated his powers by rules of business. Theoretically, the entire cabinet model of the state of West Bengal even today stands only on delegation from governor to the minister on the strength of rules of business. So whenever we say governor, we basically mean governor as he stands denuded through delegation of powers. So the same model could be applied in case of municipal commissioner also. Municipal commissioner is just a name of a node. But there was huge resistance. Whosoever would be delegatee or delegate, I found both the words are correct. Whosoever would be the delegatee or delegate would resist the delegation because it's always easy to save one's back by saying, my boss had also signed the file. So contrary to my predecessors' nightmares, the delegates actually did not want those powers. They said, sir, unless you sign, we are not safe enough. There were people, councillors and others, who thought I was scared. So, a डरपुक है, इसीलिए कायर है, इसलिए delegate कर रहा है. So I evolved elaborate sessions. Then Department for International Development, Government of United Kingdom was giving us some grants, which enabled us to fund these exercises. I envisioned workshops where in each case the departmental officers, typically the engineering head, the financial head, every department had a financial kind of head. They were coming, and the stakeholders, people who were getting services from those departments, who were the victims of the ruthless delays which this elaborate system was resulting in. Together, in each case, we evolved a delegation structure, something like this. This power of the municipal commissioner would be exercised by the chief engineer of the department, provided he gets concurrence from the finance head and maybe gets concurrence from the internal auditor. Such a group of officers model was actively supported by the service receivers who said, sir, please do this, that's the best thing. Unnecessarily files go up to the municipal commissioner, get delayed and all those things. This kind of delegation would keep transparency or integrity reasonably taken care of, while things will also be fast. So I've tried this in a number of cases, other things also, but I'm saying in transport, similarly, I had discussed with the dealers who are the most powerful clientele in the case of transport department to see how motor vehicles inspectors could be given delegated powers so that the typical problems faced by dealers or owners of vehicles in the regional transport offices could be disposed of. So it's from my personal experience that I say that a thoughtful, stakeholder discussion oriented delegation in writing could actually generate speed and could be effective without promoting dishonesty at the lower levels, as we often kind of allege.
Mr. Bandyopadhyay, Obhirup Mukherjee here, a former student of NUJS and now working for ITC Limited in Kolkata. It's a pleasure, as always, to hear you and a very deep and very insightful paper that you, or the discussion that you presented. Sir, a very interesting point about delegation which you were making, and with your erudition and your knowledge, just a kind of an observation which I would like your perhaps your insights on, is that while delegation per se makes life simpler for senior officials in the administration as well as for the public in general in certain cases, but sir, as a corporate lawyer or as a lawyer who usually is on the other side with several cases where we have to kind of challenge various decisions of the government, especially on the fiscal side, where excessive delegation of powers or delegation beyond the scope of the legislation is something which is the first line of attack from any person who's aggrieved. So I would just like to have your insights on this particular issue, because even the UK, from where we have borrowed many of our principles, the Wednesbury principles as far as administrative law is concerned, as well as a principle known as the Carltona principle, if I'm not mistaken, where even the UK courts as far back as in 1943 had laid down certain tests or certain boundaries of delegation in or by public authorities. So in fact, they said, and one of the very important points they had brought up there was that the decision in a particular matter should be taken by an official of appropriate seniority and experience. And you have been one of the senior most bureaucrats in the state and perhaps the country also. So how do you maintain a balance between the avowed object of delegation and the object of kind of having a control where the executive does not go beyond the tram lines in this case, sir?
Wonderful question. Mr. Mukherjee, I'm so glad that you spoke so finely. You have seen these things from another point of view. I was going through certain books on administrative law myself, and the question of excessive delegation, etc., keep on coming. Now, I will give specific examples because I have been brought, I guess, to say things from my experience. A district magistrate, who is the collector of a district, is actually a very busy person. Now, often, many acts say that the collector will sign. Let's say, I'm giving a very simple example. The collector will sign requisition of the district election officer, and the collector will sign every time a vehicle is requisitioned for election purposes. Wonderful. True. It's such a massive travesty, it's such a massive encroachment on individual owners' right to own and use the vehicle. This guy, Dr. Sharma, is using his vehicle. Suddenly, a motor vehicle officer goes and requisitions the vehicle for 7 days for election management purposes. This is a gross violation of all doctrines of right to property in any country. So the court said the district election officer should sign personally. In any election of a major district in West Bengal, roughly 8 to 10,000 vehicles are requisitioned. So typically, in a district where I was district magistrate, South Telegraph organized, typically the district magistrate's signature was either done through facsimile mode or an officer on his behalf would sign. In one particular case, a court held every single requisition would be treated as invalid because the requisitioning officer, which is a collector, which is a DO, district election officer, absolutely right, has not applied his mind personally. That is where I was saying, unless administrative law specifically mentions that here the collector and DO would also mean, let's say, his authorized deputies, let's say unless collector is authorized de facto to delegate this power to 10 officers, everything that the collector does is dishonest. Does he really apply his mind for 7,000 requisitions? No. Can he afford not to sign each single requisition after the court says that the personal signature is required? So unless all the organs of state mutually exercise empathy to each other and realize the practical impossibility of certain dicta of ours to be implemented, we will not arrive at truthful propositions regarding optimality of delegation. Of course, there should be individual application of mind. Then, sir, give 100 district magistrates in a district, or else realize the predicament and then delegate the powers in such a manner that truth is not disturbed. I could keep on giving examples on land acquisition and every such matter where no collector can exercise his mind, but we have refused to authorize the additional collectors or the deputy collectors. You authorize, by the way, the Criminal Procedure Code envisions huge delegation of power to a simple officer in charge of a police station who is often a mere sub-inspector. The kind of powers that Criminal Procedure Code delegated to a sub-inspector of a rural police station in 19th century was far higher than what powers we have given to senior IAS officers in the state also. Few people know that under rules of business, the secretaries are not even mentioned. It's mentioned, I mean mentioned in a substantive manner. Ministers may or may not delegate powers to the secretaries. And in most cases, they do not. If they do not, I repeat, sir, without minister's signature, no secretary can spend 1 rupee to buy a single pin on his table. unless the travesty of non-delegation is understood in great detail, I submit we will keep on discussing excessive delegation and all those things. So there should be occasional churning in this manner to understand the organicity of our delegation structure and the need for that.
Grateful, sir. I guess a perspective from such a senior bureaucrat as yourself is always very welcome, because we always see our side of the grass. So it is very, I think, opportunities such as this by the NUJS authorities, I think this is a very welcome occasion where we can have a very frank and fair exchange of ideas. Grateful for your response, sir.
Thank you very much, sir, for sharing your practical insight into the administrative law. As you rightly pointed out, even in classroom also we teach the administrative law is all about controlling the administrator. From Daisy to MP Singh, the authors have written the controlling the powers of administrative authorities. So do you think administrative law is one-sided?
No, I think as I was trying to say, delivery of justice, the way we have created these structures for that, and the separation of powers that we have followed, all these things together have often, due to historical reasons, complex historical reasons, have often kept the practitioner administrators out of the discussions. But as we all know, unless the practitioner and the theoretician occasionally meet and share each other's point of view, results for the citizens will suffer. Finally, democracy is all about citizen centricity. The voter is the final god. The consumer is the final god. The citizen is the final god. So if state is the temple for that god, then all the organs of the state should appreciate each other's difficulty and thereafter arrive at well-debated, well-deliberated policies and practices. And the evolving world of administrative law does give scope for creative and ingenious solutions. That's all that I was trying to say.
Yes. Thank you.
Thank you, sir, for the question and the answer as well. Sir, so I had a personal question. Based on your experience as an administrator, how do an administrator as being an extension of the executive or working under the aegis of the executive, how do you reconcile your worldview or your conscience with some of the decisions that have been promulgated by the top echelons on you as an administrator to enforce?
Summarily, you are trying to understand whether occasionally I have difficulty in implementing the directives that I receive from my political masters. Is that the question?
Yes, sir. Yes, sir. Yes, sir.
All the jurists, all the lawmakers, legislators, all the scholars of the world have not left any room to me to ask this question. The entire edifice of governance is based on the premise that I, the inferiorized mechanical tool, shall comply. So unless the jurists, the thinkers, the philosophers make room for such creative questions, you will get the mindless bureaucracy that our entire structure has taken care to put there.
Okay, so I think that sort of answers my question. Is there any other question? They can put it in the chat box or raise the hand. VC sir, if you would like to ask a question. I think there's some network issues. So is that, I don't think there's any question reflected on the chat box as well. So thank you, sir. Thank you for addressing the session and the question and answers after that. We are truly grateful for your participation and for the lecture, and we believe that we can host you again in a physical setting as soon as possible, because we really learned and were enriched by this discussion. And therefore, I'd like to hand over my
Thank you very
duties
much, sir, for your insightful
to sir.
speech. Yeah, thank you very much.
Thank you, sir.
I think I can take over then.
Yeah, please.
Yeah, so please go ahead.
Yeah, so Kesh Mishra sir is also here already. So good afternoon, everyone. I'm Astarat. I'm a third-year student at NUJS, and having listened to Mr. Bandyopadhyay on administrative law and decision-making, we're now moving to our 8th session of the day on tribunals and justice delivery system with a special focus on competition commission. I've already had a discussion with sir, and he has really insightful comments, especially on Competition Commission of India and how this entire jurisprudence on tribunalization in the country actually impacts the authority of such bodies. And for this session, we're of course honored to have Mr. Sukesh Mishra sir with us to share his thoughts from his rich experience in the field of competition law in India. And so it is a proud privilege to welcome you today. I'd just like to give a brief introduction for you, sir. Sukesh Mishra sir is the Director, Legal and Advisor at the Competition Commission of India. Sir completed his LLB and LLM from PG College of Law, Hyderabad, post which he started practicing as an advocate in Andhra Pradesh from 2000 to 2004. In 2004, he joined Oriental Insurance Company as a law officer, and in 2006, made the switch to becoming an in-house counsel for companies such as IFCO, Tokyo General Insurance, and Godfrey Phillips. In 2010, Mr. Mishra joined the CCI as a joint director before taking the post of director law in 2015. From 2017 to 18, he was a professor of law at the Lal Bahadur Shastri National Academy of Administration, Missouri. And finally, in 2020, he undertook the position of advisor law in CCI. Among his other duties in the Competition Commission, he has made great strides at disseminating the awareness of competition law in India to the various stakeholders through competition advocacy as per the mandate given under the Competition Act of and organized multiple events and lectures for the same. So it's indeed a privilege to have you here. And with that, I would like to pass on the stage to you. Thank you so much. I would also be sharing your presentation. So
no problem. Thank you very much, first of all, for inviting me for this particular program. And I am really honored to be here. And presentation is not important. Important is that to interact with the young energies. And in fact, I had honor to visit NUJS twice, I think in 2014 and then in 2018 or 19. So this time I'm missing that physical gathering, but nonetheless, now we have to cope up and live with this kind of environment and scenario. So what I will do, I'll just discuss the tribunalization in India, the need for that, why tribunals are so paramount and important, what is the need and why we shift from traditional courts to tribunals. And now there are some constitutional court judgments of Supreme Court which says that no, we have to go back to again traditional high courts for adjudication and also. Let us discuss one by one. And to begin with the tribunal, I will not go into the meaning and all because in my presentation you can share. It comes somewhere from France where the magistrate used to discharge their functions on the arbitrary actions of the executives. So that tribunes, word tribune, then subsequently become tribunal. And then law commissions also tried to define this particular meaning of tribunal in their reports also. Essentially what tribunal means is it is not typical court. And when we talk about court, what is court? There is an affirmation by one party and denial by the other, and you need adjudication on that. In nutshell, the court is adjudicating the issue or the legal right of a sufferer. He is claiming that he has a legal right and somebody is denying that, and he is adducing that by way of evidence and producing witness before traditional courts and getting a decree or judgment or order from the court. So this is typical court of structure, and we all know that we have lower courts and then we have high court, the constitutional courts, and then who also discharge supervisory jurisdiction under 227 and writ jurisdiction under Article 226 of the Constitution. And then we have the Honorable Supreme Court, where the appellate jurisdiction it has with, and apart from that, the special leave jurisdiction also SLP. Jurisdiction also it discharge. So by way of it is the ultimate court of the land. Now in 1969, Justice J.C. Shah was appointed to suggest that there are a lot of areas in the high courts, a lot of pendency happening. He gave his findings in 1976. He suggested that particularly a lot of dockets are there in the High Court relating to service law, and that causes the main reason for pendency in High Court because of service matters. And prior to that, you must be knowing the earliest tribunal in India came into being by way of Income Tax Tribunal way back in 1940-41. But J.C. Shah, I feel, was the person or the judge who ultimately suggested the government, union government, that you come out with some specialized tribunal who can look into these kind of areas. And the person who are manning the tribunal must be having their skills and specialization in service matters. Subsequent to that, Swansingh Committee adopted whatever suggested by Mr. Justice J.C. Shah, and he proposed by way of 42nd Amendment that there is a need to amend the Constitution and give place to the tribunal in this country. That paves way basically to have these tribunals in India, because 42nd Amendment was approved and passed, and Article 14A was inserted in the Constitution by way of Article 323 capital A and capital B. Article 323 envisaged, talking about Service Law Tribunal, Administrative Tribunal Act, 1985 was the creation of that particular amendment, and tribunal for other matters, including the labor law, revenue matters, industrial tribunal. These are all created under Article 323. Now, once the tribunal established, so basically the idea was, number one, to reduce the pendency from the High Court, and number two, that tribunal will be supplementing, will be substituting the High Court in that sense. Now, no need to go to High Court, and there is a tribunal who are basically taking care of service matters and other matters of specialization and skill. And many a time this was also found that the learned judges may not be well conversant with those particular technical issues, typical technical issues. So the person who is manning this tribunal must be knowing the skills of the trade, and he will be in a better position to give adjudication on those issues. The constitutional validity of Administrative Tribunal Act 1985, which was the creation of Article 323A, was questioned in Sampath Kumar. The question was that judicial review is the basic structure of the Constitution as propounded in the Keshwanandan Bharati. And what is judicial review? That the Supreme Court and the High Court has power to review any action of the executive or the quasi-judicial body. Now, it is a quasi-judicial body, basically. When we talk about tribunal, so it is not something typical court. It has trapping of court, but it is not pure court. For example, strict rules of Evidence Act are not applicable on tribunals. But nonetheless, they are adjudicating, they are taking evidence on oath, they are conducting cross-examinations. So there are many things which they have, you find in the tribunal functioning, but it is not strictly courts. So in some sense, the strict rules of this Evidence Act are not seriously applicable in tribunals. Now the question arose before the Honorable Supreme Court in 1985 in Sampath Kumar, whether the court is the judicial review, because there was a provision in the Administrative Tribunal Act which says that if somebody aggrieved by the order passed by the authority or the tribunal, the appeal will be by way of special leave before the Supreme Court. And other than that, the jurisdiction of High Court under 226, 227 and appellate jurisdiction of the Supreme Court basically was taken up. So if you are aggrieved, you can file appeal before the Supreme Court, and the High Court jurisdiction basically was took away. So that was questioned, citing the Keshwanandan, Minerva Mills and other Vaman Rao, all these judgments. The Honorable Supreme Court rejected the argument, saying that basically the power of these tribunals are substitutional in nature. They are not supplementing but substituting. And these people who are manning this tribunal are skillful persons, knowledgeable persons, resourceful persons, having specialized knowledge in the domain knowledge of that. So basically that controversy was put to the rest. After 13 years, in 1998, the 7th judge of the Honorable Supreme Court reconsidered Sampath Kumar, the correctness of Sampath Kumar in L. Chandar Kumar judgment. Again, the question arose whether the jurisdiction of High Court was correctly took away or not. This time, the Honorable Supreme Court has overruled Sampath Kumar, saying that the jurisdiction of High Court can't be taken away by way of creation of tribunal. Because according to the Supreme Court, these tribunals, whatever their experience in that particular short span of time, 14, 15 years, are not functioning up to the mark. And there were some reasons they have given. That basically they were appointed by the executives. Their appointment was mostly being done by the executives. Their tenures were not secure. There is a power of reappointment. So some kind of allurements have been given. So they have discussed all these things. And paramountly, they said that because these are not, these tribunals are supplementary in nature, they are not substitutional. So you cannot substitute High Court by way of tribunal, because the qualification, the aura of High Court judge, you cannot compare with the tribunal president or the chairperson. Keeping in view of that, again we come to square one. In 2008, Justice A.R. Lakshmanan, when he was a chairperson of Law Commission, and I'll just cite the report, 215 report of the Law Commission, he examined all these aspects, and ultimately, by way of detailed finding, he suggested the Union government to reconsider L. Chandar Kumar, because the very purpose of creating tribunal will be frustrated if we created one more ladder. Because the very purpose of reducing High Court from the hierarchy was that in order to reduce unnecessary litigation. And you are unnecessarily creating one more ladder. And now again, since by way of L. Chandar Kumar, you are introducing High Court back into the scheme of things. So it is the very purpose of Swan Singh Committee or Justice J.C. Shah Committee will be frustrated. So there is no point. So it is high time to reconsider the L. Chandar Kumar judgment by the larger bench of the Supreme Court, Constitutional Court. Post this particular report, again the Union government took view from the Law Commission, the Law Commission report 272nd, headed by Justice B.S. Chauhan. He suggested that the L. Chandar Kumar was correctly decided, and the earlier recommendation given by the Law Commission by my predecessor was not correct, because they are not basically substituting. They are because if you are substituting, then you have equal caliber person, equal qualification, the tenure protection, and all these things has to be kept in mind. So that was not being done in most of the tribunals, and their appointment conditions and their qualifications are completely different and can't compare with the High Court judges. So based on that, ultimately the view earlier given or the recommendation given was diluted by the subsequent report. So, and then there are some judgments came of the Constitution bench, which you might all be knowing, where the constitutional validity of NCLAT and the NCLT was challenged by way of challenging the queries of the Companies Act. Union of India versus R. Gandhi, the first judgment in 2010. Then Madras Bar Association versus Union of India, where the queries of entity was challenged. The National Tax Tribunal was envisaged by way of 2005 Act. Justice J.S. Kehar, when he was the Chief Justice of India, he authored the judgment, and he said that the substantial question of law, which was given to be decided by the newly created tribunal, can't be given to the tribunal, because substantive question of law has to be decided by the High Court, not by the tribunal, keeping in view of the difference in qualification and all these tenure, security and protection. And when most of the provisions were set aside or quashed, then ultimately it was found that the Entity Act will be OTOs and of no use. So entire act was quashed, that National Tax Tribunal Act. Recently, Roger Matthew, again on different context, was examined by the Honorable Supreme Court Constitutional Bench very recently. Again, the issue of criminalization in that judgment also discussed at length. And it was suggested both in the Law Commission 272nd report as well as Roger Matthew that the Union government may appoint a law commission or take some expert committee report, because I think Roger Matthew hadn't noticed the opinion given by Justice B.S. Chauhan in 272nd law report, which came I think in 2017, and Roger Matthew came in 2021. So again, the Supreme Court Constitutional Bench had suggested the Union government to appoint law commission or any expert body, wherein the feasibility of sending appeal of tribunal to the division bench of High Court rather than indirectly to the Supreme Court, because there are many tribunals where the appeals are directly going in the Supreme Court. So they have cited so many statutes and enactment and saying that rather than coming all the appeals to the Supreme Court, there should be one more layer, that is High Court, and then from High Court division bench to the Supreme Court. So this is how the summary of these tribunals and the litigation, their power, their qualifications, tenure, everything have been at great length discussed in these 4 or 5 constitutional bench judgments. I think maybe it is very useful if you could read all these important judgments from starting or beginning from Sampath Kumar. Now coming to the composition of Competition Commission of India. There was a view that it is a tribunal. Now, tribunal, which I have discussed, is at least it is a quasi-judicial body, and without any doubt. It will be where the allegation, there is a denial or affirmation from one side and denial by the other side and adjudication on that. Kindly see the spirit of Competition Act. It was created in the year 2002. Section 19 talks about filing of information. Now, earlier, before the amendment carried out by virtue of Brahmadat judgment, I'll just very briefly touch upon Brahmadat, then I'll come to the amendments and then to Section 19. The Brahmadat judgment came. I don't think maybe I need these slides. I'll just discuss because I am comfortable without these slides. The Brahmadat judgment came. In 2002, Competition Act was created or enacted or promulgated, and there was a challenge under Article 32. the vires of Competition Act, saying that because there is a provision in Section 7 and Section 8 which talks about appointment of chairperson and members of the commission who could be from the field of any person having experience over 20 years in the field of law, medicines, administration can be appointed as chairperson and members. So that was challenged basically by way of 32 by one Mr. Brahmadatt in the Supreme Court. And he was essentially saying that because most of the functions in the commission are adjudicatory in nature, they have power to impose huge penalty amount by virtue of Section 27 of the Competition Act, which would be 10% of turnover or 3 times of profit, whatever, whichever is higher. So basically, the nutshell of challenging the act was that the person from the judicial background, and particularly at the level of Chief Justice of High Court or the Judge of High Court, should be appointed as chairperson of this body rather than the executive. The matter, when it was adjudicated in the court, the Union Government of India proposed that we will come out with the body which will be the appellate body to this institution, which will remain as expert body, and the appellate body will be the adjudicatory body. So this is what the proposal was given by the Union Government, was accepted by the Supreme Court, and they said that it will be 2-tier system. One will be the expert body, and the another body will be the adjudicatory body. And based on that, without going into the merits of this case, Section 7, Section 8 of the Competition Act, the writ petition got disposed of. Accordingly, whatever commitment given by the Union Government, the amendment was carried in the Competition Act 2002, and in 2007, the amendment was subsequently happened. Amongst other things, the term complaint was removed and information was substituted. Now, you all must be knowing the difference between complaint and the information. Whenever we talk about complaint, basically we are saying or suggesting that there is necessarily a legal right violation should be there. That my legal injury should be there, and because in order to redress my legal injury, I am approaching before the authority, the court or the tribunal or the quasi-judicial body. So that is, list is actually required, litigation is required. But when we talk about information not required affecting of your legal right. Maybe a third person can also bring to the notice of the authority that some violation is happening and you take care of that. This is my duty and I am informing. And it is not even my duty. I'm just thinking that maybe I just go and inform you. So this is how the terminology was changed. Complaint removed and information was brought into. And then the composition of appellate tribunal was created, headed by the sitting judge of Supreme Court, which was earlier called the Competition Appellate Tribunal. Now it is merged with the Conclave. So these are some of the significant changes happened. And even you see the spirit of Competition Act, which talks about basically Section 3, Section 4, which talks about anti-competitive agreement, abuse of dominance by the dominant entity. There are factors have been earmarked under Section 19 of the Competition Act. Section 19.3, Section 19.4 talks about the factors to be considered by the Commission. So now the change came by virtue of this amendment is that it is not required to be filed by a person affected, and it can be filed by any person. Now information, it is in RAM. It is not in person, basically. And the jurisdiction of the Commission will be under Section 3 and Section 4. Whenever there is information filed, the process is like this. Commission will consider at prima facie level whether the case is made out or not. If Commission is of the view that yes, case is made out, then only the matter will be referred to DG, Director General of Investigation, to investigate and come out with the report. Now, at this stage, the issue arose before the Honorable Supreme Court in CCI versus SAIL, whether the hearing is required or not at this stage. Their contention was hearing has to be given whenever you are passing a 26-1 order to the opposite party. The Supreme Court negated that contention, saying that there is absolutely no requirement to give hearing to the affected party because they compared the 26-1 stage is a preparatory kind of stage. It is akin to departmental inquiry where you are just merely informing the charge. So at this stage, there is no legal injuries envisaged. And I remember I was there when the arguments happened in sale matter in the Supreme Court. So they said that no, even the 26-1 order could entail maybe affecting our status, our reputation in the market. Even the share market will also affected by way of passing 26-1 order, but that was completely rejected by the Honorable Supreme Court, saying that no, at 26-1 stage there is no requirement of hearing. Now, taking clue from that, I am of the considered view that at this stage, when commission is not even hearing, so that part at that stage we are not adjudicating basically. But after getting the DG report and issuing that DG report to the parties seeking or inviting comments from the stakeholders, at that time we are doing proper inquiry, and at that stage, yes, incidentally we are doing adjudication. The issue arose in Mahendra electricity matter, this motors matter, before the division bench of High Court, whether CCI is tribunal or not. The Delhi High Court held that apart from discharging the adjudicatory function, which is incidental, there are other functions, advisory function under Section 49. We are giving advisory to the government whenever they are asking any suggestions from us. We are doing advocacy, we are doing internship program and whole lot of things, which is typical courts never do. So what we are doing basically, we are even advising government on policy issues. We are doing advocacy. We are interacting with the various stakeholders, and it is basically knowledge focus organization. We are gaining knowledge. We are sharing our imparting knowledge and training programs and all, through training program and all. So one limb is obviously insofar as when we are passing final order, to that extent, incidentally, we are doing adjudication. But you cannot term us as adjudicatory body. But Mahendra Division Bench has directed the CCI because it is doing adjudication, so legal member is required. Now, that particular proposition, because they taken clue from the judgment of Gujarat Urja decided in the context of Electricity Act. And in the Electricity Act, there is a provision. They have power to award compensation, and there is a specific power to appoint judges as chairperson and president. Unlike that, my law is completely silent as far as Section 8 is concerned, which I have just spoken. So we are doing multifarious functions also, which I have just described. And we carried this impugned judgment of Division Bench of Delhi High Court in the Honorable Supreme Court. Matter is still pending and not yet adjudicated. So we are hopefully awaiting the outcome. Let's see. So these are some of the important aspects which I feel that I will just share and discuss with you. So as far as the functioning of commission is concerned, as I have spoken, Section 3 and Section 4, Section 26(1), and then we have merger regime under Section 5 and 6, where the turnover, the value of turnover or the asset value will be taken into consideration. If you are meeting the threshold limit, you need to come and intimate us and take the approval. And if you are not, and then we have this de minimis exemption where the parties, the target company or the entity which other party is going to target is having less than 250 crore turnover, or I think maybe now 350. So they are exempted from being notified under Section 5 of the Competition Act. So these are the salient features of the Competition Act, which I feel I would discuss with you. And I am actually interested to discuss with you if you have any issues or any query, because I am just going to complete my speech or whatever once I did without going into the PowerPoint presentation, because I sometimes feel that PowerPoint presentation is sometimes boring. So let me discuss extempore with you people. If you have some insights, you can share and let us discuss.
Should I unmute?
So I just had a quick question with Ayushi, you can go first. Actually.
Yeah.
All right. So my question is, recently I read that the Supreme Court expressed its displeasure because many tribunals had been facing a severe lack of infrastructure. And since we started the discussion on the tribals and the history and the scope of the past, I'd like you to throw some light on the problems which tribunals are still facing. Though a lot of scholarship and a lot of discussion have been made towards this, yet the problem remains unresolved. So could you please throw some light on it?
I only request the administrator, in my PowerPoint presentation, there was one slide that the views are personal. You please show that. Then only I will give my answers to you all. Because it is not the stand of CCI in lighter vein, because this is what all my understanding of this particular subject, which I have understood by way of my doing the job in the CCI. As far as you are right, in that sense, the infrastructure issue are always there. And when Compact was merged with the National Competition Appellate Tribunal, earlier, as it was a dedicated appellate tribunal hearing the competition matter exclusively, and they are deciding the matter. Because see, competition law is not very easy, because it has a lot of complex issues. It includes economics also, and any person who is joining, whether in CCI or in appellate tribunal at whatever level, they need actually some time to understand the concept. Now, by the time you understand the concept to some level, and then that superannuation will come. But nonetheless, I must tell you that the appellate tribunal headed by Justice Singhvi or Justice Serpurkar, earlier when they were, so they passed a lot of and very insightful judgments on competition law, expanding the scope and the width of this particular. Now, when it was merged with the NCLAT, then there was no proper composition, the forum was not there, and then there are a lot of appeals are going in the sector, from the sector of competition law. Then IBBI also appeal, I think, maybe goes to NCLAT. So now the amount of that dedicated approach which we found earlier with the specialized tribunal, because of lack of quorum, it was not there. And of late, if you see from past 2-3 years, not significant judgments have come from the appellate tribunal. Many matters have been challenged, including cement matter, this what you call Google matter, and there are so many other matters which are challenged in appeal, and we are still awaiting the outcome from these judgment because of lack of quorum and infrastructure issues. I can tell you, as far as this particular tribunal is concerned, maybe there are other issues might be there which I think maybe I am not aware of. But as far as NCLAT is concerned, yes, these are some of the issues, fundamental issues. But now of late, I think they have appointed the chairperson and members also very recently. So I sincerely hope that maybe some matter will be disposed of by the appellate tribunal, whatever pending in their list, as far as competition matters are concerned.
Thank you very much, sir, for your informative session. Sir, do you think that now we should move from adjudication to the conciliation or pre-litigation? If you look at various tribunals, be it RERA or Consumer Dispute Authorities or Land Dispute Tribunal, cases are increasing day by day. So, do you think that the adjudicator should promote conciliation or negotiation, mediation before?
A very, very good question, sir. Because I think if you see under the present scheme of Competition Act, there are two things. One, as I have spoken, it is not something a list. It is not private party list between A versus B. And if you are filing an information, then it is our prerogative. We have to see in the larger perspective. Now, what of late we have realized, parties have came, they said that now we have compromised our issue, and please allow us to withdraw my information. And once we rejected that, saying that since we don't have any provision under our law to allow these kind of withdrawals, they filed the writ petitions in court. So matters are pending there for adjudication. Now, the issue which you are raising is, I think, insofar as this particular law is concerned, I must tell you it is RAM in nature. Because if there are some larger market ramifications are there, then the individual should not be supposed to allow to withdraw the the information. But as far as larger perspective which you are raising in other sectors, if it is a typical list kind of thing which normally quote under CRPC also, there are certain kind of offenses which are compoundable, except the cognizable and some serious offenses which are in the category of non-compoundable. So I think all kind of economic offenses can be compoundable, and these kind of leeway should be given. But with this rider, I must tell you, the Competition Act is again proposed for amendment, and where we are proposing settlement scheme also. So where we find that maybe there is no larger ramifications are there, maybe by virtue of if this amendment is carried in subsequent in course of time, then we can consider that allowing the parties to compromise their matter. But by and large, these are the issues which affect public at large. If you see the scheme and the philosophy of Competition Act, the preamble, it talks about protection of consumers, prevent practices having adverse effect on competition. So these are all major important cornerstone of this particular law.
Thank you, sir.
Yes, yes.
So actually, I had two questions, but firstly, a very broad question on what is your personal opinion on the two-tier system? So I was doing some research on the Telecom Regulatory Authority of India, and I know that they also have a two-tier system with respect to one body managing the regulation and the other with the adjudicatory powers. And there are sometimes conflicts in terms of how both these bodies deal with the same subject matter, which kind of doesn't bring the uniformity in terms of that particular subject area that they work on. So what would be your personal opinion on the two-tier system that even the Competition Commission of India and then the NCLAT appellatory body is following?
As far as when we pass any order, and by virtue of this amendment in 2007, the appellate tribunal has been created, there is a layer, and it is a proper check and balance kind of system. That we pass one order, maybe we might be misconstruing something. So there is a layer, there is an appellate body which will take care of if there is any infirmity in my order, which will be corrected by the appellate tribunal. And if anybody who is affected by the appellate tribunal order, he can under 53T and go to the Supreme Court. This arrangement, according to me, my personal view, is perfectly good. But the moment whatever proposals are now suggested by the Honorable Supreme Court or by the Law Commission, again taking back one more layer by way of High Court, and now they are proposing the DB of High Court will first hear the NCLAT order or whosoever appellate bodies order to first DB of High Court jurisdiction, and then subsequent to the Supreme Court. So in that sense, my fear is that it would unnecessarily create a lot of time and resources in the High Court. I'll give one example to you, because my law is very clear. It talks about what are appealable order, what are not appealable order. It is very much there. 26(1), it is not appealable, where the prima facie opinion is given by the commission. But if you are closing the matter saying that no prima facie case is made out, it is appealable. Now, it is very clearly laid down in the law. If the power of commission imposing certain penalties under section 42 or 43, these are all appealable order. You can challenge it in the NCLAT. Something which is not there means by virtue of L. Chandra Kumar, the 26(1) orders are also being challenged. The jurisdiction of commission also challenged. And for your information, there are some cases which are pending in High Court for more than 10 years. And we are living in such a fast changing world where everything is being changed in a fraction of time. So these are the matters which are pending in courts for almost 8 years, 10 years. Now this tire cartel matter, which I was discussing with you in the morning, there was an allegation of cartel reference sent by the ministry, and ultimately we gave the opportunity of hearing, and we concluded the hearing. And then all of a sudden they filed the writ petition in the Madras High Court saying that the procedure was faulty, the reference was, and it's all technical grounds, absolutely technical grounds. They challenge it in the writ petition. The single judge has passed, after hearing this matter after 2 or 3 years, he passed a recent 70-80 pages order in favor of CCI saying that if there is any procedural impropriety, that does not take away the jurisdiction of the commission by virtue of section 15 and all. And the order was again carried in appeal before the DB. The interim order passed by the DB is that, because we informed the court that we have already prepared the final order. So they said, okay, if you have prepared the final order, put it in the sealed cover. Now in 2017, we placed that particular order in the sealed cover. In 2017. Now, very recently, 2 weeks back, the division bench of High Court has ultimately allowed the dismissed that writ appeal and allowed our matter. Again, carried in Supreme Court by way of appeal, was also dismissed summarily by the Honorable Supreme Court, and by virtue of that, we have finally passed our final order. Now, it took almost 6-7 years to us to pass the final order, where already we gave the opportunity of hearing, complied the natural justice and everything, and still, because matter was there in the High Court, we can't do anything. So these are some practical difficulties because of this. Because market correction is something which we have to do very quickly and expeditiously. And if we start making this particular body as a typical court, then there is no end to it. Then it will take all the time. And if you see the language of the act, it talks very clearly in section 36, it bound by the natural justice, but the procedure of evidence act is relaxed. So in that sense, let it be a regulatory body. It should not be made as another court where you are expecting that everything should be reasoned, 26(1) order should be reasoned. And recently, I'll tell you, very recently, there was a writ petition filed in the Bombay High Court by the informant saying that the 26(1) order passed by the commission is not proper. Now, 26(1) order is just, we have to give a very limited view on that particular matter because there was a wording or the finding given by the then Appellate Tribunal Justice Singhvi saying that if you started giving comprehensive order at prima facie stage, means you are prejudicing the judge mind of the investigator. So your order should be containing bare minimum reasons. It should not be cryptic or a vague order, nor it should be a very big reasoned order at 26(1). So we have to ultimately make some kind of balance between these two propositions. Now, he must be alleging 10 or 12 allegations, and we have passed order 26(1) order directing investigation on 2 or 3 allegations. Now, he filed the review on that. We dismissed that by saying that review is not maintainable. He filed the writ petition, and at the threshold, DB has asked whether you want to withdraw or should I dismiss this writ petition with cost, and immediately withdrew that, saying that I will seek my available remedy. I really don't know what remedies he's looking for. So these are some of the things which actually we face in the courts.
Absolutely, sir. Thank you. I think Abhiroop sir has a question.
Hi, Abhiroop. Good to see you after a long time. He's my good friend.
Good to see you, Sukesh ji. And in fact, for the benefit of the house, I'll just deviate for 20 seconds. Sukesh ji and I go back a very long way. So a very good friend, and great to hear him speak so lucidly on this entire issue. However, I would want to make a few observations as again thanking all you organizers for having people from all spheres affecting or kind of giving effect to administrative law. So again, Sukesh ji and I, as luck or as circumstances would have it, are on the other side of each other in terms of even the implementation of the law itself is concerned. So as far as the Competition Commission, and as Sukesh ji has very lucidly said, the feeling that one gets if you look at the Competition Act in itself is very rightly that the Competition Commission is a body that has various organs. It is an informatory body. It is a information dissemination body. It is a body which does activism in terms of competition law rights and everything. And there are two other very important organs of the Competition Commission, which is that it is also an investigative body and it is also an adjudicatory body. So the Competition Commission, actually the DG, is subordinate to the commission itself. And Sukeshji, please correct me if I'm wrong. You are the expert here. So the DG is subordinate to the commission itself. And the commission then, when the DG report comes in a particular matter, the commission sits in, if I may say so, judgment of the report of its own investigative body and then passes an order. And the commission, mind you, we will not obviously go into the merits of that. Very rightly, in certain cases, maybe in my humble opinion, excessively in some other matters, has the power and has given punishments of magnitudes which runs into hundreds and thousands of crores of rupees. So the only thing that perhaps we should keep in mind is the basic tenet of administrative law is that no one can be a judge in his own cause. So you cannot sit in judgment of a report that has been given by your own investigating authority, especially in common law, because in the continental legal system, the judge prosecutor is the same, are the same organs of the same body. But the Indian constitution framers and the common law system has, and in my humble opinion, very rightly, tried to maintain a great division in terms of the executive, the administration, the executive, the legislative, and the judiciary. So this is a unique case where some powers of the executive and some powers of the judiciary are being merged. And in my humble opinion, if in this case, the Competition Commission is not constituted or does not work, taking into all the recommendations of the Honorable Supreme Court, starting from L. Chandrakumar right up to Madras Bar Association, it has a very, very real chance of committing, which I may again very humbly say, travesty of justice. Because as far as, and Sukeshji himself is a lawyer and a lawyer of repute, and when we studied administrative and constitutional law in a law court, we always remember the judgment of Nazir Ahmad versus King Emperor, where they say that if there is a process laid down for a certain thing to be done in a certain manner, it has to be done in that manner or not at all. So these are some things which we may tend to forget when we are looking at the larger welfare of the people or the larger cause concerned. But as my friend Professor Sen was saying in the morning, that these are just the beginning. Today you are disregarding procedure for which you say minor matters. Tomorrow you shall be disregarding the same procedure for even things like personal liberty. So where does one, and of course being a corporate lawyer myself, a matter of 100 not a minor matter for the company or for the shareholders at large. But where do you draw the line? So this is some thought which I have, and of course, PSG, if time permitting, may have an answer, and this is a discussion.
No, absolutely. See, Abhirup, point well appreciated, the concern well appreciated. The arm's length distance which you are talking about broadly, that there should be an arm's length distance between the adjudicator and investigator, point well taken. If you could kindly see the scheme of the Act, the Competition Act, Section 16 and Section 17, both are very important. Section 16 talks about the appointment of DG, the Director General, and the appointing authority is central government. As far as the Competition Commission officers are concerned, the secretary and other officers, including director, advisor, joint director, and other ranks officers, are appointed under Section 17 by the Commission. Now, the first clear-cut demarcation you will find by virtue of Section 16 that the appointing authority is different, the central government. So the DG is ultimately reporting to the, as far as administratively subordinate to the central ministry, the Union of India. He is not subordinate to the CCI. Number one. Number two, broadly, because now there is a proposal, I think maybe, where they are, in some sense, the commission will appoint DG. This kind of proposition is in the air. So where I think maybe you might be taking me to. So the point is that whenever police is investigating, is ultimately not reporting to the magistrate under 173, but obviously is subordinate. He's taking directions and instructions from the court. So in very same manner, the commission, if is directing, heaven is not going to fall if this proposal or whatever amendment which the suggestions are there in in due course of time. I think Parliament in their wisdom will discuss all these things in at threadbare, the pitfalls and the pluses and minuses and the classic rules of administrative law, the common law practices. Everything will be discussed by them. Even though ultimately what DG is doing, commission is not suggesting them, because I am suggesting to DG by way of 26(1) order, this is my prima facie order. I am asking you to investigate. And as per my experience is concerned, Abhiroop ji and others, there are many cases where commission found prima facie there is a violation and DG said, no, absolutely there was no violation, and I gathered the evidence and I adduced the documentary evidence and other things, and I found that there is no case has been made out either in Section 3 or Section 4. And ultimately, it is not something that if commission is asking you to investigate means you have to ultimately found contravention and give it to the commission, and then commission will exercise it power subsequent under 27 or 26(6). It is not something that, because commission is asking you to investigate. Prima facie, we found that there is a violation. Now you tell us by way of gathering evidence, come out with the report. You are completely uninfluenced at this stage. So there is absolutely no stage where there is some kind of subordination is coming, because we are passing a quasi-judicial order or administrative order asking you to look into the contravention and come with the report. And there are many instances I have just mentioned where the DG found no contravention. So I think to that holistically, legally, maybe you may be having some weight in your argument, but holistically and practically, which I have experienced in my career as a competition lawyer in CCI, never ever I found that DG said that I am being asked to do something which was not proper. So he is completely independent, impartial, and he is doing his investigation. He comes with the report, and then subsequent to that, the commission will share the report to the parties, seek their objections, and then based on evidence and material, the commission will pass final order. So this is how things are going in the CCI, and I don't find actually there is any problem in that. Maybe as a student of administrative law, you have some point. Maybe
no, I think Sukesh ji, I guess very pertinent answer again from the commission's perspective, and this is where I guess the students get the fodder to kind of think about and debate, because in law, as I very firmly believe, nothing is cast in stone. Law and jurisprudence evolves every day. So thank you for your answer. Thank you so much.
Yeah, thank you.
So there's one more question from Shrija
Yes.
Singh. I'll just take that. She asks, sir, would the CCI consider increasing number of members or benches so as to deliver judgments more speedily? So is that something?
I am not capable to give any answer to this, just jokingly, because initially there was a multi-member commission and they were sitting in a pool and they were passing order. Subsequently, there was cost-cutting measures of the central government, and then they found that having 6 or 7 members on board because concept of benches is not there in the Competition Act. Earlier, before the amendment, there was some provisions, but post amendment 2007, there is no concept of benches. Although, for your information, we have already came out with our regional office in the south and in Madras, and the regional office we already have opened, and in Calcutta, Abiru and others, we are coming very soon by opening our office there in Calcutta as well as in Bombay. So these are the regional offices which we are calling, which we are opening, and which will definitely help the people to come and understand the issue. But as far as increasing the size of this particular body is rest with the central government. I am absolutely having no comment for that.
So I'm not sure if there are further questions. We can wait for 10 seconds in case there are any questions or anybody raises their hand. I do not believe there are any further
So I
questions.
think out of 40 people, I think maybe there were 40. Either there are no questions, or maybe I am not very clear to explain those things of tribunalization and my connection with competition law.
So I have a question actually.
Now this is afterthought.
No, actually I did, but
Just
so
joking.
sir, all right, sir. So I wanted to know that lately, like it is being like discussed in literature that there will be like a point in time and perhaps that the CCI would find itself and its functions overlapping with the functions of other regulatory bodies, like in the Geo case where there were like there was an overlap of functions with the TRAI. So how does CCI consider these matters?
This is, I think, maybe a very important question which you have pointed out to me. I am having some issues on this. Nonetheless, to begin with, if you see Section 21 of the Competition Act, 21 and capital A, there is a provision of reference. If CCI find that the issue pertain to other sectoral regulator, CCI can refer that matter to the concerned sectoral regulator, be it TRAI, SEBI, RBI, whosoever. Similarly, the other body can also send the reference to the Competition Commission of India, so that there should not be unnecessary tussle or the fight between regulators. It is not something which you can maybe point it out to CCI. There are whole lot of litigation you will find in constitutional courts where two regulators are fighting with each other on the issue of this jurisdiction and power. Now, when you talk about TRAI jurisdiction in this particular Bharti Airtel judgment, I think maybe you might be discussing that judgment with me. I'm having some issues on that because in that particular judgment of Justice Sikri, it was in the context where already they approached the telecom service provider to the TRAI for seeking their grievance, and then subsequently they filed the information. In context of that, Justice Sikri held that because the matter was first raised to TRAI, so let TRAI first give findings to that aspect. And if they find that if there are some anti-competitive agreement or some issues relating to Competition Act was there, then the matter can be referred to CCI. Now, I'm having personally, I really don't know how to reconcile this thing because as a competition commission, whenever there is a 26-1 order, when we commission for passed, there is a complete exercise of, you can say, a lot of churning happened in the commission when the information or the reference of suo motu cases made out. Now, specialization is required, some kind of deliberations are required, seriousness also required to look into from the perspective of bid rigging, cartelization, abuse of dominance at prima facie level. Now, these issues are typical complex issues. Now, the sectoral regulator, as far as competition law is concerned, I'm not talking about their the core areas because CCI is not concerned with the deciding or adjudicating or giving their finding on core areas or the main functions of that particular regulators. But as far as Competition Act is concerned, issues whether it relate to the telecom sector or real estate sector or maybe you say in electricity sector, competition issues has to be looked by CCI. This is my personal view. because we have expertise. And for your information, in Tangetco, very recently, that before the single judge of Madras High Court, the learned ASG, Mr. Venkatraman, appeared for the CCI and the Advocate General for the state of Tamil Nadu, and they filed a writ petition saying that because there is a sectoral regulator, the TNERC, the Tamil Nadu State Electricity Commission, is seized with the matter and he is competent to take, and they have drawing the inspiration from the Bharti Airtel, saying that first the sectoral regulator will look into and then only the Competition Commission. The ASG countered the argument by saying that, see, we are actually looking the competition matter, and our prima facie order is only related to the competition matter in the electricity sector, because there was some issue related to power shedding in the city of Chennai and vis-a-vis other parts. So there was some discrimination. So these discrimination we are looking from the angle of Section 4. This is what our case. And furthermore, we buttress our submission to the single judge, suggesting that because we have a power to send this matter to DG to investigate, and once the DG, who is the specialized body, will investigate and come out with the finding, we will share the report. These kind of mechanism is absent in the other regulators, because ultimately, insofar as competition law is concerned, first, the earliest point is 19-1, where the 26-1 order passed, lot of churning happened. And once that stage or that threshold has been met, then only the DG will look into the matter, and he is the person who is expert in investigating competition law matters. So these kind of things, if goes in sectoral tussles, I feel maybe a lot of time will be wasted, and you are not going to get any significant contribution from these regulators as far as competition law is concerned. Maybe issues related to their sector, but if it particularly relates to competition law, I think Competition Commission is better equipped to handle those issues. This is what my personal opinion. And this is what we suggested, and it was accepted by the learned single judge, and he passed the order in the favor of CCI. Nonetheless, that order was challenged before DB. Now, 22nd of this month, DB will going to discuss and decide this matter from the Madras side.
I think if there are no further questions, sir, I'd like to thank you so much for this extremely insightful session. We're deeply
Thank you very much
grateful
for
that
inviting me. Thank you very much.
Thank you, sir. We're deeply grateful that you spared your valuable time on a weekend to be with us. And I'd also like to thank Professor Chengappa for giving me the opportunity to moderate this session. Thank you, everybody. I would pass the floor to Ayushi now.
So can I leave now?
Thank you.
Or should I wait here?
So yes, sir, your session's done. In case you want to stay back and listen to the other sessions, that's
perfectly okay. Perfectly okay. Thank you, Professor Chengappa, Abhiru, and all of you.
Thank you, sir. Thank you so much. Now we would be moving to the next and the last session of the day. Aditi, would you please take over?
Thank you so much, Ayushi. With the due permission of all our panelists, may I begin the session? Yes. Thank you so much. A very good evening to one and all. I, Aditi Singh Chandel, a fourth-year student at NUJS, would like to take the privilege to welcome you all to the panel discussion on compliance of administrative law, issues and challenges in decision-making process. I'm absolutely honored to introduce our esteemed guests, who are not only repository of knowledge and wisdom, but also an embodiment of humility and grit. Our first speaker of the panel is Shri Ranjan Chatterjee, sir. Sir was the Joint Secretary, Ministry of Defence from 2004 to 2007, Chief Secretary, Government of Meghalaya from 2007 to 2009, and Consultant, Planning Commission from 2009 to 2012, looking after the environment and forest sector. He also served as an expert member of National Green Tribunal. Sir is an alumnus of the Hindu College, and he post-graduated from the London School of Economics. Thank you so much, sir, for joining us today. Our second speaker of the panel is Shri Ajay Kumar Bishtiji. Sir is currently posted as the Secretary to the Government of Arunachal Pradesh. He was earlier the member of Delhi Jal Board and was the Commissioner at Delhi Development Authority. He has also served as the Special Secretary to the Government of Delhi and Special Commissioner GST. He has been UGC JRF in history and has completed his MPhil in history. He has qualified UGC NET in law and is pursuing his PhD from NUJS Kolkata. Sir, we are truly honored with your kind presence.
Thank you. Thank you.
Thank you so much, sir. We are graced with the kind presence of our third speaker of the panel, Mr. Mervyn Alexander, sir. Sir is the member personnel at Indian Post, New Delhi, and was former Joint Secretary at Department of Atomic Energy. He was the former Assistant Director General at Department of Post, Kerala, and former Chief Vigilance Officer, Cochin Port Trust and Cochin Shipyard Limited. Thank you so much, sir, for joining us.
Thank you.
Now, I am very much elated to welcome and introduce Mr. Abhirup Mukherjee, sir, who is currently the Senior General Counsel at ITC. Sir was the former Senior General Manager and Senior Legal Counsel at DRDO India and has completed his graduation from the West Bengal National University of Juridical Sciences, Kolkata. Thank you so much, sir, for taking out time from your personal and professional engagements and agreeing to moderate this session. Now, without taking any further time, I would request Abhirup, sir, to take the session forward. Thank you so much.
Thank you so much, Aditi. A very, very warm welcome to all the panel members, the esteemed panel members. And
Thank you, sir.
Thank you to Professor Dr. Chakraborty, Dr. Chengappa, and all the student volunteers for having all of us here. And indeed, I am blessed to moderate such a esteemed panel of very, very senior administrators and bureaucrats. So just to lay the foundation before I leave the house open to all our three eminent speakers and then come in to intervene once in a while, I am drawn to the motto of our esteemed alma mater, which says, Yukti hina vicharetu dharmahani prajayate. So I just expand that to a further to say that any decision or any judgment that is passed without reason makes a hani of dharma. It is adharma actually. So one of the tenets of decision making, in my humble opinion, would be adherence to the time-tested principles of natural justice, which starts with the common law principles, the Wednesbury principles of the UK, then coming into our esteemed constitution, Article 21, Article 14, all those esteemed documents and all those esteemed ideas, and the ideas of impartiality, the idea that one should not be a judge in his own cause, the idea of fairness and reasonableness is a challenge which I think all our esteemed administrators of the panel have faced sometime or the other in their career whenever they have had to take decisions in the interest of the public at large. So to start with, I would request Mr. Chatterjee, sir, to share his views for about 8 to 10 minutes. Then we would come to Mr. Ajay Kumar Bish, sir, and then finally Mr. Alexander to sum up the session, and then we will open it for questions for about 5 to 10 minutes. May I request Mr. Chatterjee, sir?
Yeah. Thanks very much. Abhiru, I'm indeed grateful to the NUJS and particularly Professor Chengappa for inviting me to this forum for a discussion on this very important subject, which calls for a lot of introspection on the part of many of us on either side of the table. Now, you know, the principles of administrative law, as we are seeing over here, are borrowed largely from the British model, and it concerns rule-making, adjudication, and enforcement as a branch of public law and covers the entire gamut of public administration. So while constitutional law is the supreme law of the land, administrative law has to spell out the details and is built primarily on anti-authoritarianism. So one of the great luminaries in this field is Lord Ivor Jennings, who said that administrative law determines the organization, powers, duties, and authorities, and is built on 4 bricks to elucidate further what Abhirup had said, to check primarily the abuse of power by those who wield it, to ensure the impartial determination of the disputes of the people, then to protect the citizens from any unauthorized encroachment of their rights and liberties, as he mentioned, Article 14 and 21, and finally, to make the officials accountable to the people. This has also been further elucidated by the British jurist A.V. Dicey of the 19th century, who propounded a lot of treaties, whose treatise on the rule of law is very famous. So even in UK, from the elementary form of laissez-faire government, they gradually went on to a more engaging form of a system where government servants are expected to do more. And the Fulton Committee is testimony to that. There have been various objections to it also, but coming out of the basic thing of the protection of against foreign powers, levying taxes, maintenance of peace, we have come out of the laissez-faire system of administration to a more involved aspect of protection of the weak and vulnerable, and then the welfare state. And in the 21st century, we are moving in the direction of privatization and disinvestment, where it is believed that government should not do so much. It should do only what it can properly, and by keeping within the 4 corners of administrative law, and it should gradually step out of the larger canvas that it has been occupying, and as per criticism, somewhat unfairly. So in India also, administrative law dates back to the Mauryan and the Gupta Empire, then the Mughal and the British Empire, and its foundations have been, as mentioned, the natural principles of natural justice, the rule of law, powers conferred on the administration by law, no power is absolute, and that further there should be reasonable restrictions on the exercise of power. Now, in the Indian context, or possibly the world over, power dynamics revolves around the executive, the legislature, and the judiciary. Within the executive, there is the elected executive, both national, state, and the Zilla Parishad, and of course the civil servants. There is a general consensus or a perception regarding the politician. I do not wish to spell out more, but one can take it forward. Their task is indeed unenviable. The civil service in India dates back to, in the more present context, it dates back to about 400 years or so. Normally, a civil servant, relatively vis-a-vis the politician, is trusted more than an average politician. But this again is open to challenge, as one of my erstwhile colleagues, who's an activist, Mr. Harsh Mandar, says that if you ask the poor people, they would give the civil servants not more than 3 out of 10 marks. And I have also heard that, many perceptive people say that a politician, if he is taken seriously, he is capable of delivering justice. If he wants to do something, then he can do it. Much more than what a civil servant is able to achieve. Having said that, we come to this decision implementation, which is today's subject. It has many aspects. administrative law lays down the broad boundaries, but it is very fluid and dynamic, and it has kept evolving over time. Now, to give a positive thing to the civil servants, for instance, this management of the pandemic, which we saw in the last 2 years, I think the civil servants have acquitted themselves pretty well. And one of the reasons where India, with its vast population and a lot of challenges in the procurement of vaccines and things like that, civil servants have played a very, very important role. We are all aware of their role in the different parts of the country and how they have been in the forefront. So, if you compare this with the Great Bengal famine in the 1940s, I have not come across any literature to say that the civil servants have come to the fore to protect the people. Or the Spanish flu, when it had hit Bombay, Pune and all those areas, we have very little literature to bank upon. But I have read that most of the sahibs, retreated to the hills of Shimla, and when they found anybody, people who could approach them, say, what should we do? Our people are dying, this, that, etc. Just be at home and go to sleep, and you sort of rely on God to save you. So there was no other system available. So even at that time, the civil servants were there, the ICS was there, but perhaps it was not, public health was not a serious mandate with the government. One of the things which, which has brought about a deep sense of revolution is in this pattern of governance or power dynamics is the parliamentary form of government. Before the politicians have emerged on the Indian scene largely after the Act of 1935 came when there was self-governance, government was allowed, and the provinces had governments, British provinces had governments, not the princely states. So, whereas the civil servants have been there for the last almost 400 years. So there is a higher reliance on the civil servants. Of course, what is open to question is that civil servants also over period have evolved. Was there a greater reliance during the days of the British? Was there a greater reliance when the partition had taken place in 1947? Let us say up to the emergency of 1975, or post-emergency, what exactly happened? So then what brings into sharp focus is the relationship of the bureaucrat with the bureaucrat with the political executive. And of course, the newly emerged local bodies after the 73rd and the 74th amendments. Now, all these have tremendously impacted the decision making in the government. Now, the question is who decides, So, to take you back, when I was serving in the government of Assam and I was in the finance department, I was told a very interesting story by one of the persons who had come to seek something from the government. So, he went to his concerned department and everybody told him that it can't be done. Why? Because this matter will have to go to the finance department. So then after his work was done, he thought that, I must come and thank the person, who has done it. So obviously he was not, I was the additional secretary in the finance department many, many years ago. I'm talking of 1984. And so he was not able to access me. Then he went to the dealing clerk. The dealing clerk said, I don't do it, but there are a lot of other things like that. So finally, he went down to the level of the peon, because the peon had actually told him that I'll get it done. and he just embraced him with both his arms, and he says, "You are the government, you are the fellow who has dispensed justice to me." So it's so opaque, so vague that people are unable to figure out as to what exactly. There is complete lack of transparency, and one of the earliest examples of this lack of transparency was that when the British came and went to the courts of the Mughal emperor, and they came laden with a lot of gifts. Their basic idea was, we've learned this entire system of bribery perhaps from them, in a manner of speaking. But they used to go there, and eventually they found that many of the gifts which they would offer would not ultimately reach the emperor. That was a transmission loss which was taking place, I guess that transmission loss is there even today to a very large extent. So it is, there is perhaps an attempt to share, or many people think that out of the loot, what is my share out of the booty. But that will come to the issue of corruption, which I will come to later. Now, these are some of the major problems which we are facing. Until and unless you give weightage to this problem, you will not understand what this poor civil servant is expected to do, or you will not be able to fully do justice to giving him 3 marks of 10 out of 10 or 5 marks, as the case may be. Now, India, for long, this entire century, will continue to remain a very young country. India already hosts the world's highest number of the poorest people. And this is likely to go up further, because even though we call it the democratic dividend, but that is more, to my mind, an euphemism, and it will peak in 2048, 2048 to 1.6 billion. Then it will start petering out, and linked to this will be the problems of shelter, food, environmental pollution, schooling, education or quality education, health infrastructure, and the employment. These are all major problems, and we don't know whether we'll be able to resolve. That is why many political parties are hedging from the major issues of governance and are talking of subjects which are completely extraneous to governance. But people are happy to buy those kinds of arguments because for different reasons. Now, when you talk of corruption in civil services, we have to go to its origins, because in the laissez-faire administration, there was very little budget. In fact, even prior to that, civil servants were told, and I have read somewhere, but I don't recall where exactly, that civil servants were asked that, look, you won't be given any salaries. You have to live, of whatever you get, But that turned out to be a very pernicious system, So some people will extract 1 lakh of rupees, another person might extract 10 lakhs of rupees. So therefore, that was quickly done away with. So there we have the system of salaried civil servants. The salaries were pretty low, but in the recent past, after every 10 years, decennial, there is a salary increase jump of for the civil servants. For some time, I worked with the pay commission, interestingly. And one of the things which I carry back from that period is that civil servants, there is no escape for the government from giving a pay rise to the civil servants. Will they work harder? Will you get a higher degree of accountability? No, you won't. But if you don't give it, they'll be worse off. They will create more problems for the government. So the politicians also have learned that this has become a pattern. What has happened is the civil servants have improved their pay scales. There is a problem vis-a-vis the armed forces. But what about the problem vis-a-vis the poorest of the poor, who have to depend on the informal sector? So that is the gap has become very yawning, and even talking of corruption, Paul Appleby or Appleby, who was brought in as a consultant in this field of India, he found out to his dismay and said that a large number of officers are ethically neutral. When you say ethically neutral, I think you're speaking a lot. I remember that in my earliest days, I was in a subdivision, and I had a person whom I had appointed as my personal assistant. I just pulled him. He was a clerk, and he used to do it. So he had access to his own ACR. He could read his own ACR, because how could I hide his? So I had written that his integrity is unimpeachable. The fellow didn't understand the meaning. He didn't have Google at that time, Unimpeachable. And he kept saying that, sir, you just write, he's very good. Don't write unimpeachable, because later on I'll have problems. So you see, that's the kind of perception which people have about integrity and things like that. And today, perhaps a large majority of the officers in different cadres have become politicized, not because they themselves are making money, but because they are opening the floodgate for money. Just to give you a little example, sorry I'm taking a little time, is that, Madhu Kota, the one-time chief minister of Jharkhand, he made 4,000 crores. Now, do you think he made 4,000 crores which nobody even blinked? Some fellows must have nodded that, okay, you do this way, I will look the other way. Now, that is also a kind of corruption, isn't it? So, we owe allegiance to the Constitution. We take our oath from the Constitution, and yet we are allowing this kind of a thing, So how does this happen? This is possibly an extreme example. There would be any shades of that. So, and getting back again to the judiciary, the three pillars of the caterpillars, as I say, of the power structure, the judiciary, we heard recently the former Chief Justice of India. I think it is unethical to speak in a law university about the judiciary, but this was there wide all over the media, and they asked him about integrity, and he says that I cannot make a statement that there is complete integrity in the judiciary. Many people said that it is wrong. Now, while I have a very questionable respect for my namesake Ranjan Gogoi, but the question is, this is a statement which is very correct, I feel. Now, if you talk of the Indian Administrative Service, two of the speakers I notice are from there. Now, it is generally buffeted about by jealousy, ignorance, mafia, strong-arm tactics, and the fear of the politicians. Buffeted about means the system has a very nice, as was being discussed in the previous thing of Competition Commission also. The model is that, everybody joins at a certain level. There are different services. But over a period of time, some people in the IAS also, they develop qualities of rust very quickly. They oxidize very quickly, And there are some people in other services who turn out to be very bright. They are late blossomers. So should the doors be closed to them in perpetuity? Answer is no. Because people want good administration or good administrators to rise and take decisions for them. So, but there is a constant jealousy, there is this thing that, pull down this edifice, pull down these fellows, So, in the IAS, so that is a major problem. We have seen this coming from the IPS. Now, I'll come to the IPS later. We've seen this from some of the other revenue services. Why it happens is there is a lot of ignorance and a lot of attempt to try and see that looks, whatever happened in the past, now I want to get over and settle scores with a different service. And likewise, they feel that there is too much of fellow feeling and bonding within the IAS, and therefore these chaps protect each other even if they are no good. Now, in the process, what happens is that the officers have become very weak. When I was collector in Jorhat in the year 1982, at that time, there was a very corrupt OC of a police station. But my superintendent of police could not transfer him because that chap was in direct connection with the chief minister. So finally he says that, look, if I can't transfer him, then I'm not going to continue as a superintendent of police. And I was following it, I liked it. So then in due course of time that it boiled down to this thing that for about 7 days this fellow would be transferred, and after 7 days he will get back to his police station of Mariani, because it was a wet, lucrative police station from where he could collect some money and pass it on to appropriate quarters. So this bypassing of the system has led to a lot of corruption. Again, when I was in the civil aviation, I used to, among the various charges, I was looking after the Office of Director General of Civil Aviation, DGCA. But there was a technical fellow who was the DGCA. So every morning, when we used to go to Parliament or any place, you see, he would cozy up to either my secretary or to the Honorable Minister, as the case may be, and pass on some information that today morning such and such happened, something else happened, because he would have the latest inputs, and it would take a little time for me to get it. So the minister and the secretary were happy to get the inputs from him directly rather than through me, where there would be a little time gap. So my purpose of mentioning this thing to you is that, that this bypassing of the system, creates a lot of distortions. Similarly, so therefore in posting orders, I had a senior officer, Mr. Narasimhan, he passed away, and he was the health secretary. He could not transfer out any doctor, or he could not transfer out many staff. So what he said is, there was so much of political interference. So finally he said, he was much senior to me, I was a kid compared to him. At that time, he said that, look, transfer postings, he said that junior officer will put up files, under secretary will put up files straight to the minister. I will not do it. Why should the file come to me So this became such a serious thing that when I became a chief secretary, I would still make my transfer postings, but what I would do is I managed the system by also talking to the chief minister. I would tell him that, look, this is what I want to do, and for the following reasons, don't disagree. There would be 1 or 2 cases where he would insist. But if 8 out of 10 I could succeed even regarding posting of collectors, I thought I had won the game. I asked the same question to my colleague, Chief Secretary of Assam. He said, no, I can't make any transfer postings. Everything is decided by the Chief Minister. So you see, there has been this, whatever the civil servants were doing at a higher authority, at a higher level, all these things have been usurped by the politicos, and the majority of officers drift with the current. They are no longer doers, So their idealism is lost, and from the administrative services, it has dwindled on to a mere job. Then they do a job. The service element goes. Why did it happen? According to me, the biggest reason is that in the British days, district administration was the most important job. And they used to be collectors for 10 years, 15 years. They knew their job thoroughly, and they moved, on horseback throughout wherever. They created everything. They had more powers. So they were not hankering for secretariat jobs so much. Whereas in the Indian context, what is happening is this has been taken over by the state civil service officers. Politicians find them to be more pliable. Even for the direct recruits, IAS officers and things like that, they look at which officer is more pliable, they are comfortable with whom, and things like that. So this makes things extremely difficult. And according to me, the question which comes to my mind, he talked of dharma. I used to ask the question from a very early age, you see, Satyameva Jayate. Is it Satyameva Jayate or Asatyameva Jayate? Question mark. I am not giving an answer. And also Maslow's law, which we study as, the primary thing from hunger, freedom and everything, it goes to self-actualization. Now, for an IAS officer in the Indian context, if he has worked hard, he's come with idealism, he had other options, he left those, he's come here, he's not gone in for a corporate job. Why should you kill him? Why should you sort of kill all his initiative? And why should you deny the people the benefit of his hard work? So things are going from bad to worse, and what is happening today is that, as another senior officer, no more, Arun Ghosh, who had said that the mantra is how to get the job done without getting into trouble. That's become a very difficult thing. How to get the job done without getting into trouble? Because otherwise most people have decided that to do the least. They don't want to do much because they don't want to get into trouble. Because sooner or later somebody is going to catch you. That is the witch hunting is very, very serious, even in the civil services. So, Harshmander finally questions that is it worthwhile to continue with the civil service supposed to be selected on the basis of merit any further, or you should also go in for the spoil system as is there in the United States and so on. So anyway, I think I'll stop over here, and if there is any interjection, I will answer. But sorry for having encroached upon other people's time.
Thank you so much, Chatterjee sir. I think the wealth of experience that you have gathered throughout your long and varied tenure in the civil services clearly shows through. And I think from all of us would really appreciate the candor with which you have spoken about all the issues. We'll come back to the questions later. I believe we have two more eminent speakers who will share their thoughts with us. So I would first request Shri Ajay Kumar Bishji to kindly share his experiences with us, followed by Mr. Alexander. And then perhaps we'll throw the forum open for some questions to any of the panelists. Mr. Bish, sir.
Namaskar. Good evening, Professor Chengappa, sir, and good evening, all the panelists. It's my proud privilege to be here today to share some of my views. First of all, I am a serving officer. I am presently Secretary Labour in Government of Arunachal Pradesh. I will be sharing some experiences in administration, and these being official matters, so these are being discussed only for academic purpose, not for further propagation. That is my request, if that can be accepted. I would be happy sharing the views with you. So at my present job, I am Secretary Labour, and Labour, as we know, is in the concurrent list of the Constitution. Entries 22, 23 and 24, they relate to labor sector. And recently there have been new labor laws coming, codes, there have been consolidating codes, and the 29 labor acts have now been subsumed into 4 labor codes. One of the codes is Code on Occupational Safety, Health and Working Conditions. We call it in short OSH code, which repeals 13 previous acts, including the Factories Act. Now, being secretary in the government of the state, we have the responsibility as a state government to make rules under the code, and this is in two capacities, one as the state government and another as the appropriate government. Under the in the labor sector, we have three sorts of governments. We have the central government, exclusive domain of center, then we have the state government, exclusive domain of the state, and then there is appropriate government, wherein it is state/center, whichever government is applicable for those workers. So in the OSH code, this Occupational Safety Health Code, when we started drafting the rules, we faced one problem, that there is one act, Factories Act 1948. This act is a part of the labor sector, but in the rules of business of Arunachal Pradesh, we have the rules of 1998, the work pertaining to factories and boilers has been entrusted to Industries Department. Now, why I'm sharing it with you and the students is that in rule making, we sometimes encounter these difficulties, and then that is the difficulty we face in deciding how to go ahead. So since Industries Department is looking after the factories, we have to take into account their views, their comments, their advice, and in fact, we requested them to help us actively. And since they are also another department, so they did not come on board for reasons known to them. One of the reasons was that they said that now after coming into effect of the code, the Industries Department will go under the Labor Department, and therefore the factory sector, which is being presently with the Industries Department, the Industries Department's power will be reduced. That was one of the reasons that was there. So what we decided as a secretary, I didn't want to fight and then create a problem. So what we decided, because above me there is chief secretary, then there is minister, then there is chief minister. So decisions are taken at the highest level of the chief minister. So we notified, we call it pre-publication. We pre-published the draft rules under the OSH code, which did not include the portion on the factories. And it was a difficult decision for us, but then there was no way out, and we did it knowing fully well that we will have to separately pre-publish rules for factories also. The government of India is also facing this sort of a problem, because in their code in Industrial Relations Code, till now they could not frame rules on Trade Union Act relating to the erstwhile Trade Union Act, although they have made it for the Industrial Disputes Act, but not for the Trade Union Act. So now what happened here, after we pre-published it, then I discussed the matter with our Honorable Minister. The Minister is also Minister of Industries. Then I told that there is going to be a regulatory, the legal vacuum. The rules are not including the factory sector. So then he prevailed, and then he guided the Industries Department. The Industries Department came on board, and they gave us their inputs, and accordingly we decided to incorporate. And then the rules which were to be again pre-published, and we have again pre-published. And for natural justice, the requirement is that we have to give 45 days time for the pre-publication, after the pre-publication, to inviting comments from all the stakeholders. This and now 45 days are over. Now we are putting it up for final notification. This I'm sharing because rule making and rules also are part of the law as per Article 13(3). And we have a significant role to play. And then in the administration or in the government, one of the difficulties we find is the interdepartmental cooperation. So this is one example where the cooperation came, but it came later. Another experience that I am sharing with you is my recent experience. Again, that is also a very confidential matter, but since it is an academic exercise, so I am sharing it with you. Presently, I am also working as election observer in the state of Uttar Pradesh, and I was posted there. And in the elections, as we know, is a central subject. Election Commission is also in this. Election Commission of India is there in the list 1, entry 72. And Representation of People's Act, there is section 20B, which speaks of observers, and observer has a role to play. He has certain powers as well as certain responsibilities. Power always comes with responsibility. Now, one difficulty arose. I will not name the district and the constituency, but this is since our subject involves decision making and issues and challenges in decision making. So we are supposed to send our reports. So one of the reports, on one matter, we have to report whether the strong room we call the strong room is the storehouse where polled EVMs are to be kept. Polled, जिसमें voting already हो गया है, those are to be kept under security, and there is a system of 3-layer security. So once the polling is over, and the EVMs, we call it electronic voting machine, which comprises 3 components. One is the ballot unit, which is a bigger one. Then there is a control unit, little smaller, and then there is a VVPAT. So it makes 3 huge, it requires huge space. So the Election Commission's directive is that it should be kept at a place which should have a single entry, no other entry, and the directions are that it has to be a room. So in this case, it has to be a hall. So it will be a hall which has to have only a single entry. Now, the difficulty that we were facing, we were three observers for 4 assembly constituencies. I was in charge of 2. The other 2 observers were in charge of 1 each. Now, these 4 assembly constituencies, the district administration and the DO, we call it, the district magistrate is ex officio district election officer. They had suggested to convert the existing market. There is a newly created fruit vegetable market which has good space for the purpose of strong room. And instead of one centralized strong room, there were many rooms which were to be used as strong room. So all the observers objected. We said, no, it cannot happen because it has to be one hall. The difficulty is the district administration told us that we have to arrange for 4 assembly constituencies, which would involve the movement of people and the staff and the EVMs who are coming in around 300 buses. Then there are the sector magistrates, there are other people. So it's not only a question of one hall, but the hall has to have counting arrangements and also should have the transport facility available. So we examined the matter. All of us, all the 3 observers, we sat with them, and then we personally went to the site. And since a decision was to be taken, then we finally found that the arrangement which was being suggested by the district administration was an appropriate arrangement. Although we make laws and there are guidelines, but every place is not, the country is not uniform, and therefore we have to make local innovations as long as we are satisfied. So as civil servant, our job is to do the things, not to stall the things. So all the 3 observers, we decided, okay, fine. And then we gave our commendations, and the Election Commission also accorded approval to the arrangement. This I wanted to share because the difficulties in taking decisions which are faced by the civil servants and which are faced by the administrators, I just wanted to share. Now, the third thing which I want to share is that relates to labor sector. There is an act of 2008, which is Unorganized Workers Social Security Act 2008. And it's a central act because it's a concurrently subject, and states are empowered to make rules. So like other states, Arunachal Pradesh government had also made rules. Every state had almost made the rules, but registration of unorganized workers, it was a difficult exercise because they were charging money for it. There was a charge of 25 rupees for every registration of unorganized workers. This is an act of 2008, remained almost unimplemented till COVID came into the picture. Now, when there were pictures of laborers going back on foot, on cycle, and different modes of transport to their native places, the Supreme Court of India took cognizance, and there is a suo motu petition number 6 of 2020, which is regarding the miseries faced by the migrant laborers. Now, therein they said that these migrant laborers are mostly working as unorganized workers, and these people have not been registered, and there is a difficulty of finding out who is moving where. And the Supreme Court had so many hearings. They also referred to one order of 2018 in which it was ordered that please implement the Unorganized Workers Social Security Act and register the unorganized workers. Now, in the new system, the Code on Social Security, it subsumes the Act of 2008, because the Code on Social Security, it repeals 11 legislations. One of them is the Act of 2008. So the Supreme Court gave a direction to the central government also that please evolve a national database of these unorganized workers, because there was a study conducted by the National Statistical Office which had said in the year 2018 that there are 38 crore people, more than 38 crore people in India working in the unorganized sector. Now, during many hearings which were there before the Supreme Court, they gave the decision that please go evolve the system and put in place the national database. And thanks to the directions and the intervention of the Honorable Supreme Court, that now the national database has become a reality. Government of India has taken the responsibility. It has been installed. Registration of unorganized workers has commenced. Every state is doing it. There is a portal available in the Labor Ministry and even in the state government, with the state governments. And the figures of 15th February, that is 3 days back, the figures are that there has been a registration exceeding 25 crores. So what the earlier data was that there are 38 crores unorganized workers. Already more than 25 crores have been registered. So why I'm sharing this is that as a government, we were facing this problem that there was an act in place, there were rules in place, but implementation was difficult because there was not a centralized mechanism made available by the central government. And every state government said the same thing, that even in 2018, the Supreme Court had made the center responsible that you evolve a mechanism and share it with the states. Now, when it has been shared with the states, we have been able to implement the law. As civil servants or as administrators, our job is to function within the parameters of law, and we implement the law. We also make laws, as I explained about the rule making under the OSH code. These are few experiences. If time will permit, maybe I can come later and I can share few more experiences. So I'm very happy to share these experiences with you. Once again, I request that these matters may be kept confidential, they may not be propagated further. Thank you so much, and I'm grateful to all of you for patient hearing. Thank you.
Thank you so much, Bishji. It was really, after hearing Ms. Chatterjee, sir, it was really great to hear you, because the experience of being on the ground, having your boots on the ground and having to deal with practical situations and find innovative solutions to such challenges in a vast democracy like ours with multivarious problems is something that requires what we in corporate world call out of the box solutions, which I believe esteemed people like you are very adept at doing. With that, I'd come to Mr. Mervyn Alexander. Alexander, sir, I leave the house open to you. After you complete your views, we will leave the house open to the other participants and attendees for questions. Alexander, sir, over to you.
Okay. Thank you. I must thank um, Professor Chenkappa for a great opportunity, because this is the second time I am addressing a program in NUJS. Of course, last time it was a pre-COVID time and it was physically in your campus. Now, thanks to technology, we could, Mr. Ajay Kumar Bish possibly is joining me from Itanagar, I guess.
Yes, thank you, sir. Yeah.
And I am joining from an airport lounge in Trivandrum. So technology has just brought us together. That's one aspect of possibly COVID. So I'm, in fact, I'm rather lucky also to listen to a couple of very seasoned bureaucrats before me who really threw a lot of things which possibly I also have never thought about it. Because in a normal office work day to day, you don't rather focus on many things which have a larger impact. We just focus on the day to day. So that I must thank NUJS that to make make us to put our thinking cap also. So I will share some of my experiences, which as a member of the Postal Service, I had a manpower of about 6 lakh people, part of which is a part-time. We have about 2.5 lakh people who are part-time, and rest are all government employees. And managing them, because basically when we talk about our domain knowledge in Postal Service, it is actually man management. Because managing a large number of employees, their recruitment, their welfare, their establishment, just not an easy task. Most important, in fact, the most difficult task as of now we are facing is actually recruitment. It's not that we don't, we have a lot of posts, because filling up it is becoming a great challenge. You must have recently read what happened in Bihar when for about 10,000 jobs, about more than 1 crore people have applied. And conducting a recruitment exam actually is becoming a law and order problem now. So that is one very important, because and many places the recruitment which earlier has been given to of outsourced to private agencies. Sadly, our experience has not been good with that also. So it's actually a challenge, big challenge which we are facing. Maybe do a sort of a hybrid type of recruitment, which is one important mandate which we are facing. Well, before me, Mr. Chatterjee has touched about a very important aspect about corruption in bureaucracy. Being a department with so much contact every day with the citizen, I think we do have a lot of opportunities, to be unethical also with a lot of our customers. So I will just throw some of my experiences which I have learned over the years, which possibly will be of some interest to the audience. So I was Postmaster General Chennai for about four years or so. Many of you may know the Social Welfare Department gives something called an assistance to people like widows, people with handicaps, old age people, about an amount of initially was 500, later to 1,000 rupees, used to be given as sent as a money order to these people who are usually below the poverty line. So in Chennai, soon after I joined, one of the newspapers exposed, rather, it possibly was going on for a long time, about a sort of scam that, postmen take about 50 rupees for a 500 rupee pension which is given to these beneficiaries. So what happened after some time, the amount was increased to 1,000 rupees, and postmen automatically increased their commission also to 100 rupees, which became a sort of this thing. And we were thinking, and there were multiple views saying that after all, many people give it as a sort of, they happily give it, and it is a bakshish which has been going on, and why just bother too much about it. Sadly, many times people, after all, these people well off, who can immediately pick up a phone and make a complaint or something like that. So complaints were also unfortunately not coming. So what we did was, we did heard a lot of investigation, went around and caught a lot of people red-handed also. Because, there is a provision, the inspectors can actually go and check the physical cash available with the postman at a particular time. And it went on and also went into the media, particularly went to the print and the TV media to sensitize the people why they should not be paying any money to any of the postmen. It has gone to the corruption level has gone to such ridiculous levels that in many post offices we found that some of the postmen always come to work for maybe about 10 days when actually the money orders come for payment. Rest of the time he is actually on leave. He don't care to come to the office even. So just imagine if he gets about 500,000 money orders and if he takes a commission of 50 rupees or 100 rupees, it's a huge amount. It is more than the salary which he normally earns. So it became very paramount on our part that we should be stopping it. And thanks to this, our team which went around caught many of them red-handed. And second thing is, thanks to the sensitization we did through the media, a lot of complaints started pouring. Maybe I'm not very fair in doing that. Even a single complaint, I said, we immediately place an employee on, we suspend the employee. One of the problems with this disciplinary cases with the department employees, it takes a long time. So we wanted to do it on a fast track. So the time given was 3 months. Right from the receipt of a complaint, the investigation is done, the complainant's statement is recorded, then an inquiry is done, and after that a punishment order is passed by the disciplinary authority. It used to take some time, drag on and on. We wanted to finish it within 3 months. And sometimes what happens, even in the inquiry, the complainant overturns his original statement, which had given that he or she had paid the bribe. Unfortunately, those things were also there. But then we also sensitize our employees. Without a proper valid reason, they cannot overturn the original statement they had given. That there is a court judgment also to that effect. You have to substantiate why you are turning this thing, because after all, a postal inspector, unless a policeman, just cannot go and harass and get a statement with the force or anything like that. So that much is. So this exercise was done in a massive scale across the state, and we was around 200 plus of our staff, and it became a major trade. We have a huge department, and so it became a major trade union issue also. And I still remember the trade union All India secretary coming and telling me, "Sir, you are catching a fellow for just 50 years or 100 rupees. Look at the politician who is taking thousands of crores, and what is being done about that." I said, "That's not my job. My job is to catch the fellow who is in my jurisdiction. I will do it. Okay, if I am to catch somebody else who is taking 1,000 crores, I will do that also." So it became a sort of this thing, and I am happy that so they indicated that many of the postmen had actually turned ethical even if their money was given. 250 plus people have to be terminated, either compulsory retired or dismissed from service or terminated, that is removed from service. So then obviously the next stage is all of them went to court, right? And I'm so happy to possibly for the first time in my career, the High Court of Chennai had also given me, because of course this issue was discussed in the media for a large extent, that had given me a very, a statement highly admiring what I have been doing. And that is something which I will always remember in my career as sort of one of the bright spots we had achieved. So this is one side of it. The second aspect of it is, I'll just briefly tell you, many of you, not only in the postal service, but also in other government departments, if you have made a complaint, you will wonder why is nothing happening to that guy? He's continuing there. He's just not removed from service, not thrown out of the job, because unfortunately in government, or I should not say unfortunately, the Constitution provides a lot of protection for all the government servants. Possibly our founders of our the architects of our Constitution actually thought possibly that most of the bureaucrats will actually be honest. So much of protection is given under Article 311. So the first principle is that no government employee could be dismissed by an authority who is lower than an employee whom he was appointed. Okay. The second important thing is like no employee could be dismissed without a proper inquiry. Again, in the Department of Posts, which is almost common for most of the central government departments also, and it is almost similar for the all-day services as well. There are two types of penalties which we can impose as part of the departmental proceedings. Which is first is the major penalty, which of course is removal, dismissal, compulsory retirement, and all that. There are minor penalties which start with mostly it is reduction of your pay by few increments with or without cumulative effect and all that. And there is a third one which is called rule. These the minor penalty proceedings and the major penalty proceedings, the procedures prescribed are different. For a major penalty proceeding, a proper inquiry with a inquiry officer, a presenting officer, and the employee who is defending is given an opportunity to have a defense assistant also, which actually normally takes a lot of time. So one of the concern which we have is the delay in which it happens in concluding a disciplinary proceeding. Because government, even when you suspend a person, he still gets about 50%, and later up to 75% of his salary he gets a subsistence allowance. So without doing any work, even a corrupt employee will be getting a substantial amount, and it is usually in his interest, especially when he knows the charges are so severe that he will lose his job. He will drag on the case. This is something which we have been trying to address, how to speed up the cases so that justice is done fast and there is no loss to the exchequer. This is under what we call under CCA rules. Rule 4 CCA rules provide for this thing. So, but the sad part is many cases get delayed for long, and maybe one of the outcome of this COVID is of late we have started also doing through the VC, like courts have started doing it, and that has actually one of the positive effects is that this has also been speeded up. But still, people go for bias petitions. They challenge almost on every opportunity. Something or other is challenged. So it's actually it's a painful process, because if it's a private company, if some employee does some mischief, you can throw him out in no time. Absolutely, he's just told that from tomorrow don't show your face here. But unfortunately, in government that's not possible. But it is high time that we need to have a relook at the current process. Added to our woes is the large number of courts which interfere into the disciplinary proceedings. Any given day in my working day, I face contempt at least from 15 courts. So far, they have not taken any serious view. Somehow we have managed, but courts, particularly the tribunals, interfere at each and every stage. They do a lot of. Unfortunately, though, the people sitting in the tribunals are also our former colleagues. They do a lot of hair splitting, and they have made our job also difficult. So this is a big challenge which we are facing in government. How to speed up the disciplinary proceedings so that any guilty person gets punished quickly, because what happens is suspended employee is not even available for the government. In his place, we substitute somebody else also. So this is something which possibly we have to work out and come out with a solution. Then finally, there is something called a Rule 9 procedure also. You may know a lot of cases, including you might have heard about the former Coal Secretary's case, where some of the mischiefs or misdeeds will come to light after the officer or employee retires. So in such a case, what happens is a presidential approval. Normally, the presidential approval is through the minister in charge is obtained. After which it's a long process where UPSC invariably has to consult whether he is a lower level group C staff or whether it's a secretary level officer. This is the third process. It's called the Rule 9 process. So in some of them, unfortunately, Rule 9 also there is a long delay, basically for almost similar reasons which I had said earlier, because the enquiry is essential there also. Unfortunately, and sad part about this Rule 9 inquiry is many cases this retired employee, this act would have been, there's a time period, will not be getting his terminal benefits, and which is really a sad for many of them who will be actually looking for a peaceful retired life to construct a house and something like that. So there again we are looking for mechanism how we can speed up things. So these are some of the challenges which we have faced, which I have personally experienced, and I thought share it with you. I hope you found it useful, and I am of course open for any questions which you may have. Thank you very much.
Thank you, Mr. Alexander, sir. Grateful for your perspective. Very, very practical and very candid as usual. All the three panelists today, senior people, have been very, very candid with all of us. Just one interjection before I come up to my second point, or the second part of the thing, taking questions and all. One interjection I would like to make, hearing Mr. Alexander. The very old adages that we as law students or even aspiring students of law deal with or learn. The first being justice delayed is justice denied, which is the most commonly quoted and said maxim these days with the pendency of cases and all. But the contrary, or the other adage which runs parallel to this, is an adage which says justice hurried is justice buried. And also the other part which Mr. Alexander very candidly said about procedures, systems, the hair splitting which he referred to, which is done by the people sitting in the tribunals. Perhaps when the tribunal member who comes and does his job, when we criticize them, we say that they are being unnecessary, they are giving a go-by to the principles of natural justice, the principles of administrative law. Perhaps the hair splitting that they do and we get frustrated about, as a citizen, perhaps even I'd get that. But when I wear my lawyer's cap, I think they're just doing their job to ensure that tomorrow when they come up with their decision, nobody can point a finger and say that the process, the fairness and the impartiality, the three cornerstones of administrative law, those three things have been absolutely followed and observed in their decision. I have been informed by the organizers that we also have another senior bureaucrat amongst us, Ms. Padma Mahanti, who's attending the session, who's who joined us. So although she was not originally a part of the panel, may I kindly request Ms. Mahanti to also share her views in 10 minutes with us, because this is a very pertinent matter for, I believe, touching her area of work as well. And then we will come to the questions and perhaps the final comments from any of our panelists. Ms. Mahanti, may we please hear you for 10 minutes?
Thank you so much. I'm really sorry that I could not, I joined very late, but it's very, very enlightening for me to hear all the three speakers, Chatterjee sir, who spoke on people's faith in bureaucracy, corruption in bureaucracy, transparency in judiciary, bureaucracy being more pliable. Then I also heard Professor Ajay Kumar Biss sir, where he says power comes with responsibility, and Marvin Alexander sir, you spoke extensively about corruption in bureaucracy. I belong to the Indian Forest Service, and as Ajay Kumar Biss sir said, I am also a serving officer. So what I speak today, it's only for academic interest and not to be disseminated with this faith. I would like to share my little story. I belong to the Kerala cadre of Indian Forest Service, a lesser known service of the 3 All India services, but we too lot with people. And I worked in Periyar Tiger Reserve, which is known for participatory management. And touching upon the first point of Chatterjee sir, where he said people's faith in bureaucracy, my experience with Periyar and 6 tribes working, which are in Periyar, the Mannans, Palyans, Malamandarams, Malarians, and the Ulladans, were that we were able to, during my tenure, we were able to transform poachers into protectors. And it is India's first trans-boundary initiatives. The poachers were from Tamil Nadu. They would poach and do sandal smuggling in the Periyar Tiger Reserve. Through a series of interventions of the 2 states, Tamil Nadu and Kerala, when the states were fighting over Mulla Periyar, the officials got together, and in a social transformation, we were able to, really transform these 21 hardcore elephant tusk poachers into protectors. A part of the Periyar Protection Force. As on today, I have left Periyar 13 years back, but they still continue to be there, very much a part of the protection force. So exemplary work of the bureaucrats in the social change still happens in pockets, even though it's not documented, it doesn't hit the limelight so often. Talking about corruption in bureaucracy, sir, I am 21 years into the service, maybe 22 years, going to be 22 years. So midway, almost, it's a midlife crisis when people say honesty pinches somewhere. So I still have to see where the honesty pinches, because when we talk of honesty in bureaucracy or corruption in bureaucracy, I personally feel it's a very personal thing. And the benchmarks are set by the individuals. There is no. I was talking to one of my colleagues, senior colleagues in Kerala yesterday, who was suspended over a issue just 2 months back, and he's one of the most honest, known to be an honest officer with highest level of integrity, and with that he was brought back to service within 28 days of his suspension, again to the same post. And he was saying that, we are exceptions because we fall on the left side of the curve. So we should be reasonably corrupt to or sustain in the system. Then I was asking him, what is this, the parameter of being reasonably corrupt? He said, you have to be normal. If you become abnormal, system aborts you. So that was what he was talking in a lighter vein. And coming to the transparency in judiciary, sir, to share a small experience from my own life, again for academic interest. Last year, I was transferred to the ministry, and within 9 months of a 10-year posting, which was for 5 years, and my place of duty was fixed, I was transferred without citing any reason in my transfer order. And it was in the peak of COVID second wave when people were dying. And along with being an official, I am also a mother of 2 small children who had just got admission into school. People were dying. There was a lockdown, and amidst that, I was transferred. I had no other option but to go to the CAT and pray before the CAT. And it was only because of judicial intervention that I could stay put. And my kids are still here. And I was not, otherwise I had 2 options. Either I leave my kids